Testing, testing, testing. 1, 2, 3.
At least it's not us.
Yeah,
At least it's not us.
because we've been there before. Remember
Yes.
Calvin's
Yes.
roadshow thing?
Oh man, that was bad.
Yeah.
On the record, we've fixed our technical problems. I also would note, not so much for the parties who are used to this, but for other folks, apart from the four of us sitting here, Commissioner O'Donnell is participating in this hearing through virtual means. So we'll start again with appearances, and I guess we'll turn to Mr. Lapp.
Good morning, Chair Hoover, members of the Commission. David Lapp here for the Office of People's Counsel, and with me is Mark Shebist, Assistant People's Counsel, and Michael Sammartino, Assistant People's Counsel. Thank you.
And Mr. Yeah, go ahead.
Good morning, everyone. Tharu Vignaraja here on behalf of Stephen Topping et al., the plaintiffs in the lawsuit pending before the Circuit Court for Baltimore City in relation to this matter.
Thank you. And I take it those are all the parties, correct? I think so. Okay, so we'll turn to BGE.
Thank you, Chair Hoover. So we have a presentation. Believe.
It's on that one. Can we put it
it's
up
on
on the
here.
screen, though?
It's not appearing on.
There we go. There we go.
Morning, Mr. Chair, Commissioners. Daniel Herson for BGE. Thank you for calling this proceeding. We're happy that the Commission is investigating this matter, and we believe this is the proper forum and has always been the proper forum for this matter, so we're happy to be here today to have this conversation, important conversation. Before we get into the conversation in detail, I wanted to level set a little bit with the piece of equipment we're talking about. Can you advance to the next slide? So there's been a lot of discussion about the regulators, and of course this proceeding is about the gas regulators, but we are not running here a gas regulator installation program. The regulator is a very small component of much larger systematic asset infrastructure replacement work. So here's a little diagram of a single family home. The setup is generally the same though on lots of the different structures in our service territory. And the regulator is a small piece. You have the gas main running through the street. You have the gas service line coming perpendicular off the main to the front of the house. Then there's a riser that comes up out of the ground. That's where you find the gas service regulator if it's installed on the exterior of the home. And behind the regulator is the meter, and then the customer piping and appliances in the house. Today, during the conversation, you may hear the terms upstream and downstream. When we're talking about upstream, we're generally talking about towards the utilities infrastructure. So, for instance, here the regulator is upstream of the meter, and the main is upstream of the service line. Downstream is more towards the customer appliances. So, the meter is downstream of the regulator, and customer appliances are downstream of the meter.
So just for clarification, and this may simplify it too much, but when you say downstream, you're basically talking about what's happening inside the house.
That's correct. Yeah.
Sure.
Downstream is an industry term that can talk about literally where the gas molecules are flowing.
Okay.
They're flowing down towards the ultimate end user, which is the customer and their appliance.
Right. Mm-hmm.
So there's been a lot of question about why we're doing this work. We've heard allegations that it's unwanted and unneeded, and we vehemently disagree with that. Next slide, please. There were a couple things that happened in back about 10 years ago. In 2011, PHMSA, the federal agency charged with overseeing pipeline safety, issued a call to action to state regulators, to elected officials, to technical experts, basically saying, please find ways to incentivize the accelerated removal of aged and outmoded infrastructure. And they specifically mentioned materials that we have on our BGE gas distribution system, like cast iron main, bare steel, or unprotected steel main. Said find a way to get this stuff off the system. And Maryland answered that call in two ways. First of all, the General Assembly passed the STRIDE law in 2013 with wide bipartisan support that basically said, we agree, we want the gas companies in Maryland to get this infrastructure off their system. There's an intent paragraph in that law that says as much, and they established the special surcharge mechanism, which allowed for more accelerated cost recovery to incentivize the utilities to do more of that work quicker. And to replace the gas infrastructure on an accelerated basis. So the second part of what Maryland did was with this commission. This commission heard an application from BGE for a STRIDE plan. The first one was submitted in 2014, and they approved, the commission approved that plan and approved another 5-year plan in 2019. So the company has very much appreciated the commission's action on this front, and we believe that these programs have been very successful, both the STRIDE programs and also any asset replacement work we're doing outside of STRIDE. And you can see some of the numbers here about what we've been able to accomplish in the last 10 years, including over 400 miles of cast iron and bare steel main being replaced on our system, 40,000 bare steel and copper services. We've eliminated 373 miles, or 28% of our low pressure gas system. And we've installed more than 375 miles of modern plastic or wrapped steel main. So we are doing this work to meet PHMSA's call to action and to answer the Maryland legislature and this commission when it approved the STRIDE plan. We shouldn't forget, though, that there's other benefits to this work. You can see here we have reduced greenhouse gas emissions nearly 29% from our system since we started doing this work 10 years ago. So there is an environmental benefit to this, which of course supports Maryland's aggressive climate goals. And there's also an economic stimulus to Central Maryland, including employment of many contractors who do this work, and also many who are minority business enterprises, certified MBEs, that help do the work and help support aggressive supplier diversity goals that the state has. So why are we doing this work? To avoid situations like you're seeing here. So these are pictures of the aftermath of 6 incidents, 4 of which happened in Maryland, 2 of which happened in other areas of the Northeast. On the upper left, this was the Allentown, Pennsylvania explosion in 2011. It was attributable to a broken 12-inch cast iron main that leaked, and unfortunately 5 people were killed and 8 homes were destroyed. That was in February of 2011. PHMSA issued its call to action letter in December of that same year, largely in response to incidents like this. Then on the lower left, that is the Merrimack Valley incident in 2018, which we've heard a lot about, where there was an overpressurization of a low-pressure system. Most of the structures did not have the protection of gas service regulators on the property, so as a result, high-pressure gas entered houses that were not equipped for that, and you had resulting destruction of property and lots of fires. On the right-hand side, you see 4 pictures of incidents that happened in Maryland. Of course, top center, that's the Flower Branch incident, which we've heard a lot about in the comments filed in this matter. That happened in 2016. That was directly attributable to a malfunctioning gas regulator on the inside of the building that had a disconnected vent pipe, which resulted in the NTSB issuing its recommendations in a final report. The other 3 on the page are not related to internal gas regulators per se, but they are situations where you had an internal accumulation and ignition of gas that was leaking and resulted in catastrophic explosions. One incident of which was resulted in fatalities. The other incidents resulted in either injury to individuals or damage to property. Each of these events are tragic. Each of them resulted in loss of life or property damage. These pictures are hard to look at, but it's important to remember that when these incidents happen, both the industry and the utilities involved have to learn from these events. And that's what we've tried to do here at BGE, whether it's replacing the low pressure system or trying to move as much of the gas equipment outside as possible. We don't want these incidents to be in vain. We want to learn from them, and that's why we've in part made the decision to require the external placement of gas regulators. So at this point, I'm going to turn it over to Mr. Ralph, who's going to talk a little bit about the safety discussion between external placement of regulators and internal placement of regulators. Thank you.
Thank you, Mr. Harrison. So opponents of external regulators have pointed to PHMSA incident data, which they suggest supports the argument that somehow external regulators are less safe than internal regulators because they're subject to vehicular damage. However, we have analyzed the data, and this slide actually shows some of the incident narratives. We have analyzed the data, and it does not support that view. This data is really just reports of vehicular accidents that incidentally involve some gas equipment. The injuries in the PHMSA data were injuries resulting from the car accident, not a gas event. The bottom line is that we are not focused on preventing vehicular accidents. We are focused on preventing catastrophic gas events from occurring on our system. While we certainly don't want damage to our equipment, in the unlikely event that a vehicle does strike our external equipment or some other event occurs on the external equipment, a catastrophic event is mitigated by the fact that the gas will vent to the atmosphere. However, if one of these incidents occurred where there was actually, in one of these narratives, a situation where the vehicle went through the property and remained in the property. In the event that internal equipment is damaged, gas can accumulate within the house and cause a catastrophic event. Again, we don't want damage to our equipment, but equipment can be replaced. What cannot be replaced is the loss of life and the loss of the public trust if we fail to take into consideration the express recommendation of the NTSB and certainly the clear spirit of the Flower Branch Act. Next slide. So there's also been a lot of discussion about replacing or repairing these outmoded, older steel, bare steel, and iron mains. And this slide gives the Commission a comparison of both. And you know, I'm not going to go through point by point to talk about that. The Commission has it, and certainly if it has any questions about any of these points, we can discuss them. But what I will say is that replacing these old, outmoded, lower pressure systems is an important safety measure because the repairs do not address the underlying problem with these outmoded mains, namely that they're old. So it's important that we get these systems, these old outmoded systems, off our system as quickly as possible. In fact, repairing as opposed to replacing these mains may wind up costing customers more because these repairs will not, as I said, address the underlying issues and will eventually also have to be replaced because we cannot continue to operate our system safely without replacing these systems. Next slide, please. So this is a continuation of the concerns we have regarding the old cast iron and bare steel mains on our system. And what this slide shows is that as time goes on, there's a continuing rate of failure amongst these older outmoded systems. And there is no dispute, and we note that in the comments from staff and OPC, there is no dispute that these old and bare steel mains represent a risk on the system. And we have identified that risk in our distribution integrity management plan as required by PHMSA. As I said before, a repair-only strategy puts customers at risk because you cannot mitigate the risk by repairing a particular acute problem because it doesn't address the underlying risk. These facilities are old and failing at an increasing rate. In their comments, OPC recommends that there be a 2-year moratorium on the replacement of these old outmoded systems. We vehemently disagree with that, and we think it would be irresponsible for the utility to leave these systems in the ground when many of them are past their useful life or are nearing the end of their useful life and are continuing to fail at an increasing rate. We believe that to do so puts the public at risk. Next slide. So in this last slide, there's been a lot of misstatements and inaccurate statements out there by individuals, and we believe that it's important that these statements get cleared up, and this slide basically points out some of the statements that have been made, and I'm not going to go through these, but if the Commission has a particular question regarding any particular statement made, we'll be happy to address it after our presentation. But let me conclude by saying this, that we are concerned about the amount of inaccurate and misleading statements that have been made about gas pipeline operations and engineering by lay people who are not subject to any regulation or oversight. This is dangerous in that it could be confusing and misleading to the public about their safety. BGE takes the safe operation of its system extremely seriously. As the operator of the gas system, we have provided the Commission with reasons behind our change in our standards, and we have provided our expert opinion that external regulators provide the safest option to customers to mitigate against a catastrophic event. This view is in line with current engineering best practices, the recommendation of the NTSB, and the ultimate goal of the Flower Branch Act. Based on the comprehensive record that we have put before the Commission, we ask the Commission to assert its jurisdiction over this matter and provide clear direction as to how to proceed. Because the PSC is the proper forum to hear this matter. Certainly, the PSC is the proper jurisdiction to hear matters regarding the provision of gas service, not the court of public opinion, not any attorney, not even the city council or a court or a circuit court judge. Indeed, it would be a dangerous precedent to set to defer to others outside the regulatory framework that the Maryland General Assembly set up to hear these kinds of matters. That is, the commission and the utility providers. Thank you for your time and your attention to this important matter, and we again respectfully request clear direction on how to proceed. We are now available to answer any questions the commission may have.
All right, before I turn to questions, let me just indicate for the parties and the folks in the room, we intend on issuing directions in this matter, but we're not going to make a ruling today. Our process is that we take matters like this under advisement. We will be issuing an order at some point in the future, but we will not be issuing any decisions from the bench today. So with that, let me turn to the commissioners for any questions. And let me start with Commissioner Richard.
Thank you, Chair Hoover, and thank you. First, I want to recognize all of the members of the public that are here today and appreciate their taking the time to be here. I know it's not easy, and probably this is an unfamiliar forum. I guess I wanted to start with the company. We're here because something has gone terribly awry with your program. There's been a real, it seems to be a lack of communication with your customers, and that is of concern to me. It just, with your large public affairs team, we've heard that you had a program, a robust program, and outreach program, and at this point it seems to be very largely just one way. How have you taken input from the public in devising some of the changes and policies, and also in some of the, I guess, your plans, your updated plans on both your capital expenditures and also just how you are undertaking the responsibilities of the Flower Branch? Because again, I have real concerns right now that with the number of lawsuits and just the people that are upset about how you're treating their homes, that there has not been a real understanding of your customer, the fact that do you know your customer, and how does public input affect how you go about executing your program?
All right. So I would like to first clarify, many of the parties that will speak to this commission today, first of all, Kevin Nelson for Baltimore Gas and Electric. Many of the parties that will speak about this matter today, the representatives for BGE have met with personally on numerous occasions. So I think the perception that we're not speaking with these communities and these customers is a misrepresentation. And what we found through those discussions is on this technical point, we are diametrically opposed. And that's the purpose of the proceeding here today. As Mr. Ralph has said, we're looking for clarity on what the utilities authority is and what the best technical outcome is for the ratepayers in Baltimore.
Okay. There is, I think it was very well laid out in the statute and in our guidance to the company, a waiver process. But it doesn't seem, and the waiver process included a number of areas, including aesthetics. But at least going through all the filings, it doesn't appear that there was ever instituted a process how you can engage with the public in looking at this waiver process. Because again, we've seen the pictures, we understand this is about safety, but it appears that there are a lot of different measures, a lot of different approaches that the company could have taken to ensure safety. but also ensure that the customer requirements were being met. So again, what steps, or if any, did the company take to, again, have a meaningful waiver process so that the citizens could engage with the company in an approach that respected their homes?
So the waiver process that we have in
So
place,
if you could just state your name before you
sorry.
start. Sure.
Sean Gorman with BGE. So the waiver process that we have in place is really focused on the technical requirements and the safety objectives of moving the regulators outdoors. The ultimate decision when granting a waiver is when there is no technical or feasible way in order to deliver the enhanced safety of the outdoor regulator. The aesthetics option is sort of secondary to the safety. So for that reason, we perform technical reviews of the locations to ensure that we can deliver the safety that is required. The aesthetics are really not a factor in the in the exception process that we established.
So you did not, you just pretty much ignored the waiver process. You didn't have any opportunities to try to reach some kind of again, an approach that ensures safety but also respects people's homes.
Commissioner Richard, I think the answer is that we take into consideration the technical aspects of whether or not our approach actually can work at a particular location. But I think, as Mr. Nelson said, we have had discussions with community members. This comes down to a disagreement about what is the right thing to do. From our standpoint as the gas operator, we believe that safety is paramount. We have taken into consideration these other concerns, but as the gas operator, unless there is a technical reason, we believe that safety trumps those concerns. Now, others disagree with that, and I think that's why we're here.
Okay. Well, again, I don't disagree about safety. But, I mean, up till recently, when you changed your policies, internal policies, it wasn't that long ago. You had replaced a number of mains in other parts of the city. I think Bolton Hill is often pointed to. So, I mean, are we to understand now that Bolton Hill is not a safe place in your system?
So first of all, let me just say this. We're not saying that regulators on the indoors are not safe. What we are saying is that regulators on the outside are safer. The regulators on the inside cannot mitigate certain risks that we now know about, and that's why we updated our standards. I believe Mr. Nelson would also like to address your question.
Well, I'll just add that factually, yes, Bolton Hill was a community that was where the gas system was replaced during the transition of this policy. And so there are some outside, mostly there inside. And as Mr. Ralph said, from a technical perspective, they can be safely operated, but they don't mitigate all of those risks.
Okay. Well, again, in some respects, I mean, it's either safe or it's not safe. And I think we need to have some kind of a sense as to how to approach your system. And if Bolton Hill, you were able to come up with some measures that you believe are safe, I guess I would like to understand, why in the waiver process there wouldn't be an opportunity to work with all of your customers to ensure that same, I guess, pass-fail is safe or not safe. Otherwise, we're kind of left to wonder if people should have gas at all. Otherwise, because there's this lingering question about continually trying to figure out how to enhance safety. So, again, I'd like to I guess just understand where we're to go with this information about some parts of the system that have recently been updated, okay, but were before the change, and why we can't also look at the experience there and, again, allow citizens to work with the company to have, again, a measure of safety and a respect for their homes. Is that inconsistent?
Yeah, so a couple things, Commissioner Richard. I disagree with the notion that it has to be either safe or unsafe. The system is safe. However, we don't stand static when we have additional information that provides us with things to consider to make the system safer. All of the systems, whether gas, electric, nuclear, all of these sources of energy have, as time has gone on, become safer. And that's the role that we're responsible to play, is to make sure that we're doing the safest thing for customers. And so that's why we updated our standards to make sure that that we can account for the new information that we had to make systems safer. Ms. White.
Thank you. Dawn White, Vice President of Gas for BGE. So, good morning again, and good morning to the Chair and the Commissioners. But Commissioner Richard, to really answer your question, to David's point, safety is an evolution, right? You know, we continue to look at our standards and understand industry best practices, work with external organizations like the American Gas Association and Southern Gas Association, in addition to others, to identify best practices. And so this is a best practice that we identified and a transition that we made along the way. To kind of also hit your response as to, you know, the future of gas and then what's the impact of that. The one thing I want to remind the Commission in particular is, you know, we have 700,000 gas customers that we have to ensure the safety and reliability and resilience of the gas system. And it's our responsibility that we continue to look at the standards, right, and continue to identify opportunities to improve. So I just want to make sure, you know, we reiterate that, you know, gas still is a key part of the future of the energy industry when we think of both the needs of the state of Maryland and the customers within the state of Maryland, but also in being able to meet our goals that we have, both from a Maryland path to clean, but also from a federal environmental focus as well. So just want to reiterate how important gas is, but also that it's important that we continue to focus on safety.
Okay, and I want to let my colleagues get into this quickly, but I just wanted one last area is we're here to also try to reflect, you know, from the Commission, state policies. There is a clear state policy right now, and that is to look at multi-unit buildings. And at this point, I'd like to understand this decision to I guess, divert attention for the single homes as you're looking at your safety programs, and really not attack the issue before us, and that was the legislator's directive on multi-unit buildings. I mean, at this point, I understand there are now estimated 11,000 plus opportunities to look at this, and the program, as I understand it, is you know, at best going to approach, you know, 700 units a year, and this is going to last over 10 years. So why not focus more of attention on the state policy and also the PHMSA requirements on multi-unit buildings, and not, you know, again, at this point I understand you're up to 4,000 individual single-family homes, but again, it's not attacking the problem that the legislature has clearly pointed to. Why the distraction, I guess, on these individual homes and not go after the multi-unit buildings?
Let me go first. So first of all, thank you for that question, Commissioner Richard. First of all, this is not a relocation program. As Mr. Herson said in the beginning, this is part of the PHMSA call to action main replacement program. So we're not diverting our attention away from the Flower Branch Act. That's the work we do under the Flower Branch Act is the work we do under the Flower Branch Act. This work is part and parcel of the old, outmoded, bare steel and iron main replacement program.
And I understand, but you're also talking about a large program specifically looking at the low-pressure systems. I understand mains, but there are all kinds of variations on these STRIDE programs. So I specifically want to understand why not more attention on the multi-unit buildings with these limited STRIDE dollars?
We are, again, They're two different things. I just want to, I want to be clear because it seems that
I understand Stride. I really just want to understand why the resources are being diverted.
they're not
Okay.
being diverted.
Well, okay, I mean, they're
They're
limited.
not, they're
I
different
mean,
programs. We're not diverting the resources.
Okay, well, you in your own testimony, you talk about, well, if we do this, then we're going to lose all these crews, and we're going to, waste resources. But again, you have a very limited program stretched over more than 10 years to address the multi-unit homes, multi-unit buildings, and again, focusing in on other areas. So.
They're different programs, Mr. Commissioner. Go ahead.
Commissioner, they're actually differently qualified resources. So the individuals who are qualified to do commercial and larger metering regulations, they often have to be welders. They have all these other skill sets which predominantly are not needed on the main replacement programs that we have. So the premise that we could switch the hats, for lack of a better word, of the individuals doing the main replacement work and accelerate the flower branch work is not linear. There's an extent to which it's true, but it's not as simple as maybe I think OPC suggested in their comments. I'd further add that we're addressing through main replacement a specific and demonstrable threat to our system in the way of cast iron main breaks, whereas with flower branch we are taking a preventative measure. Let me be more precise with my language. The flower branch initiated work, so the multifamily regulator relocations, we're taking a preventative measure on a conceptual risk. And I think you can see in the data we presented in our program, right, these cast iron mains, in our presentation, these cast iron mains are failing at an accelerating rate. And we are concerned about the potential that continues to accelerate into an unmanageable situation. Now, how that maps to this regulator installation on these, this is an opportunistic safety improvement that goes along with our primary objective, which is the retirement of these cast iron mains.
Okay. Well, I'm not going to take any more time. I want to let my colleagues get into this, but again, I understand the mains, but I don't know how this necessarily requires a program that also includes replacement of regulators and the low pressure system. And especially given the poor public engagement, this seems to have really, again, I think the company needs to take a look at this operation pipeline, and I'll, at the outset, let everyone who wants to testify know that I'm very interested in the OPC approach and would like to have comment on the framework that OPC is suggesting, because it seems like a good balanced direction we might take in trying to, again, balance the needs of safety and the concerns that the citizens are bringing to us. So with that, Mr. Chair Hoover, thank you.
So let me follow up before I turn to the other commissioners. Let me follow up on a couple of issues that Commissioner Richard raised. So the first discussion about the neighborhoods where you did this work prior to this decision to put all the regulators outside. You made some comment that some of them were put outside, some of them were left inside. So I guess I want to find out what was the process for determining, which houses were left inside and which ones were put outside.
It's often site-specific circumstances, so literally where we're going to put the pipe on that property and what was the most cost-effective, expeditious, least impactful to do. Does that answer your question, sir?
And as a follow-up, though, I mean, you've made this decision that the outside regulator is more safe, but you don't intend on going back to these previous neighborhoods and moving these regulators outside that are currently inside, correct?
Not until we have some cause to alter that service line in the future.
And then on the discussion about Flower Branch, I think the concern that a number of us have is that, and obviously you're under two different mandates here. You had the mandate from the Stride Act to sort of replace the system and the pipes and things like that. And then there was a later mandate from the legislature to focus on the danger from leaks in multifamily dwellings and moving these regulators from inside to outside. And I think the concern expressed during the legislative discussion was that in these large multifamily dwellings, when the regulator leaks, because there's less traffic in some of these areas, the circumstance of gas, accumulating and then sparking and causing a catastrophic explosion was fairly high. And it's one of the reasons why in reading the Flower Branch Act, it appears to put a lot of emphasis and a lot of concern on moving these regulators in these multifamily dwellings from the inside to the outside to address this issue about leaks and accumulation of gas and later catastrophic events. And what I'm concerned about is that while you talked about, well, it's two different paths and things like that, I guess the sense I'm getting is that the Flower Branch thing is sort of, subservient to this larger effort to address the Stride things. Whereas I think the legislature's thought was that the Flower Branch repairs are actually more important, and that an emphasis should be put on, approaching those buildings, fixing those situations, because those situations are probably more likely to occur and cause obviously much more threat of loss of life and more significant property damage, as opposed to fixing the overall system. And so I think the concern that Commissioner Richard raised is that you're not putting enough priority on responding to the Flower Branch mandate. And if I read in your filing, the testimony you provided to the General Assembly, and one of the issues you raised was, well, the initial definition you have of multifamily dwellings is so large that it's going to be very difficult for us to do this because there's just so many buildings included. So you suggested, and I think the legislature followed your suggestion to narrow the definition of what counts as a multifamily dwelling. So I think in that situation, if there's a narrower universe, then it becomes more apparent that the company should be looking to fix those issues as opposed to, fitting it in as you're doing the Stride work. Yeah. And just identify yourself for the record.
Will do, Mr. Chairman. Charles Washington here for BGE. When we worked on the Flower Branch Act, when I think about the way that bill was constructed, it was really modeled off the recommendations from the NTSB.
Right.
And NTSB recommendations have a dual path. They recommend proactively moving towards the multifamily buildings and addressing indoor regulators in multifamily buildings. But the twin recommendation of the NTSB is that whenever we're replacing a service line or meter, that we also cite those regulators outside. And so the legislation itself really targeted one of the recommendations because the legislative process allowed the space to do that. But all of the conversations were about how can we more effectively and efficiently implement the total recommendation of the NTSB, which included both multifamily and also taking the opportunity whenever you're replacing a service line to replace for any occupied structure.
Okay.
Can I also just add really quick?
Mm-hmm.
So, I hear the conversation around, Flower Branch being a priority and, in comparison to Stride. But the one thing I want to reiterate is that we have requirements to follow, and we have to be able to value all of those requirements and really evaluate, all the things that we need to do to meet the intent of the law. Right? So from a PHMSA perspective that I really want to call out is our requirement to follow DIMP, which is the Distribution Integrity Management Program, which in some ways, both of those programs, both from a Flower Branch and Stride perspective, follow the requirements there. It requires us to really look at the risk and the threats that we have on the system and to develop a program in which we actually replace the infrastructure. So it is something that we also must continue to look at. So we constantly look at what is our riskiest infrastructure, and we have a plan in which to replace that. Part of Stride being able to replace a lot of that infrastructure but also looking at and valuing what's the work that we have to do with Flower Branch, and being able to understand how do we do both or all of the programs that we're required to perform to ensure that we're meeting the requirements of the law, but also the risk, safety, and valuation of the system itself.
Okay. So let me turn to,
Can I?
well, actually, go ahead, Mr.
One more
So,
point.
Sure.
Just because I was the attorney who worked on the Flower Branch Act filing.
Sure.
I'm concerned to hear that there's a perception, maybe implied or expressed, that we're not taking Flower Branch seriously. We submitted the plan to the commission. It was supported, I believe, by staff, and OPC didn't object. This commission approved that plan, and that plan was submitted under the same stride plan that we're operating under now. So we're not in a situation where we're putting more work towards stride versus what we should have been putting towards Flower Branch. They're two different streams of work. And the fact that we're taking the Flower Branch a little bit further in terms of moving regulators outside on structures less than 6 dwellings does not mean that we are doing more work on stride. It doesn't mean that we have to devote more time or resources to the stride work that we could otherwise have been pushing towards the Flower Branch work. I just want to be really clear about that, because I think it's dangerous when you start crossing those two, because Flower Branch was a mandate from the Maryland General Assembly, but that doesn't mean we can ignore the stride mandate or, frankly, the federal government's mandate under the PHMSA regulations that we constantly identify risks on our system and address those risks. If we go the OPC route, with all due respect to them, that is not sustainable. We cannot stop this stride work for 2 years. We would be facing a serious situation with our cast iron and bare steel main. Tons of leaks we couldn't keep up with, resources we couldn't meet the needs. It would not be a situation that we want to be in. So I understand their approach and suggestion. I just don't think it's feasible.
Okay, so let me turn to the other commissioners, and Commissioner O'Donnell. Actually, I think you may still be on mute because we can't hear you. Okay, so actually, I think we're still apparently having problems hearing you, so we're going to try and fix it. So. Is this a Okay, so let me turn to Commissioner Sussman, and then we'll come back to Commissioner O'Donnell. So.
Thank you, Chair Hoover. Before I actually had a series of process questions, but I do want to talk a little bit about the Flower Branch Act and to get some clarity about what it does and doesn't require. So, Mr. Washington, if you could come back up, and you were talking about whenever a gas service line is newly installed. Is that what you said?
Yes, when I was describing the NTSB recommendations, I talked about the twin recommendations that we approach aggressively,
Okay.
multifamily units, but then that we also
Okay. And you recognize that the NTSB regulation or the recommendations were not adopted by PHMSA. Is that, you understand that? That while NTSB made recommendations about regulator replacements when the service line is replaced, PHMSA didn't go that far in adopting that regulation. But that's actually separate and apart from that. The Flower Branch Act provides that whenever gas service is newly installed at an occupied structure, a gas service regulator may be installed only outside the structure. So you read that to mean gas service line, not gas service. So whenever a gas service line is newly installed as opposed to gas service is installed.
I don't believe that's...
Okay, and the reason I'm asking that is that is important for us in terms of understanding what the law requires, and also what BGE's understanding is of gas service.
Sure.
Okay.
So I know that there's been varying interpretations of that part of the statute. I don't think that we have put forth an understanding that the Flower Branch Act requires us to move a gas service regulator outdoors anytime a service line is touched. I was suggesting that was the recommendation of the NTSB.
Okay, I can tell you, having read the BG filings, you don't actually use those words, but there's a bit of word salad that was in, for lack of a better term, in your filing that talks about it's after considering the Flower Branch Act or in the spirit and intent of the Flower Branch Act. So I'm mostly just trying to get a sense of what BG's understanding is about the use of the term gas service. Because in other parts of the legislation, they talk about gas service line. And as a lawyer, when we read legislation, we look to the words and assume that if something wasn't added, so if they use gas service as opposed to gas service line, that the legislature intended it to reflect only gas service, new gas service. And I can point you to your own construction standards for deploying regulators that was adopted at the end of 2021, and you define new services and existing services. You talk about gas services, and new gas service is service that is being provided to a customer that hadn't been receiving gas service before. So I can tell you that I read the legislation to require installation of an outdoor regulator only when there is new gas service at an occupied structure.
Commissioner Suchman, I might be able to help with this response
Please.
a little bit. So we acknowledge that the Flower Branch Act does not require the work that we are doing on structures that do not meet the definition of multifamily dwelling. So I just want to clear that up, because I know in the early days of this, people were saying, well, BGE is claiming they have to do this work under the Flower Branch Act. They're telling us it's a requirement. If that was a miscommunication on our part or our contractor's part, we'll own that. And we've tried to clear that up in subsequent conversations.
But if it's not required, then how is it required? How is it consistent with the intent and spirit? I mean, they would have put gas service line in if that was the intention.
Well, they did put it in for new gas services. So,
But I'm talking about existing. I mean,
understand.
everybody in this audience is living in an occupied structure that
understand.
has gas service.
I understand. Well, first let me say, I don't believe, and engineers can correct me, I don't believe we can offer gas service to anybody without a service line. So when we talk about service line, we're talking about gas services. So in the terms of the Flower Branch Act, if it's a new build, new construction, somebody who's never had gas before on our system, our view is the Flower Branch Act requires the regulator to be placed outside. Now, to your question on existing structures, which is what I believe most of the folks in this audience are here about, is no, the act does not require it. BGE, though, believe the spirit and intent of the law was that the General Assembly thinks that gas regulators are safer outside. So we went beyond the bounds, the minimum requirements of the Flower Branch Act, and said, we're going to change our policy in light of the incidents that have occurred on our system and elsewhere in the country, in light of the NTSB recommendations, and in light of the Flower Branch Act, to change our standards to require external regulators in all circumstances, not just new gas service. So that's why we are where we are today.
Okay.
Not because it's mandated by the Flower Branch Act, but because we believe we're...
I just wanted to get some clarity there. Okay, so going to the construction manual for regulator location. So you made changes to that construction manual in late 2021, correct? Okay.
Correct.
Was that before the end of, I mean, I'm assuming it's before December 22nd, 2021. And the reason I'm asking that is because BGE submitted its regular relocation plan to the commission on December 22nd, 2021.
Okay.
Okay, so I'm assuming that by the time the plan was submitted, BGE had already changed its construction manual.
That was, let me refer to Mr. Gorman, because he was actually on the team that did the change, but my understanding is it was in process. So if it hadn't happened yet, it was
Okay,
contemporaneous.
but you knew it was happening,
Yes.
even if it hadn't, okay. Can you explain to me why there was no reference in the regulator restoration plan to include at least some mention that you were going above and beyond the requirements of the Flower Branch Act to require that regulators be put outside?
Well, I mean, my recollection at the time as we were drafting the plan for submission was we were trying to address the requirements of the act itself.
Well, but you said that it was that you interpreted the act, the intent and spirit of the act to include requiring outdoor regulators. So you were thinking about outdoor regulators and the Flower Branch Act. So
We
I'm
were-
wondering why,
Well, we
year
were-
year and a half ago, that you didn't include that in the plan.
Well, because we were trying to respond to the requirements in the act of what a plan submitted to this commission needs to include. That was not part of the requirements of the act.
Okay,
In fact,
and then-
you're correct that we did go beyond it, but that was driving our internal standards change. That was not something we felt needed to be included as part of the Flower Branch regulator relocation plan, because it's not part of that plan. It's something totally different. It's part of the STRIDE and other asset replacement work we're doing.
Well, it's hard for me to, I mean, it's in or it's not. I mean, I'm getting
It's not.
from
It is not
BGE
in
that
that.
is part of, it was the intent and spirit of it. Mr. Washington talked about gas service lines, and that was, I mean, so it's sort of hard for me to get my hands around, what it is that you thought. But sort of getting to the next plan, which was filed August 11th, 2023, you also didn't include reference to the change in the construction manual requirements in this either.
Are you talking about our STRIDE mid-year report?
No, I'm talking about the regulator report that BGE submitted August 11th, 2020. Oh, not 11th. I'm sorry, I'm getting my dates wrong. The second report that BGE submitted on its the regulator plan, the
The
regulator.
annual reports,
Right,
the annual updates.
Got too many.
Yeah, so the annual updates are, the reporting template, if you will, for that was something that was established through that process, that case.
Okay,
So we're-
okay,
we're kind of following
but again, in that report, there was no reference
That's
to.
correct.
Okay.
That's
Has there been any submission that BG has made to the commission that has notified us about a change to your construction manual to require that regulators be relocated outside instead of inside?
No, we have not made an official filing with the commission notifying the commission of the change in those standards.
Okay, so your understanding is until this proceeding, there wasn't anything that BGE or you're aware of any other party has submitted to the commission that would notify us about the change in how regulators were being located in single-family homes.
So I'm not aware of any other filing that's been made by any party. I will not pretend to know what interactions happen between the commission's
But
engineering staff.
from BGE's perspective, nothing was ever, we were never alerted to the change.
Not through a filing from us. I don't want to go as far as saying that your honors were not alerted, because again, I don't know what the interaction is between the commission and its staff engineering division. Our position as the engineering division is aware of the change, or was aware of the change at the time.
Okay.
Some commissioners may have been aware of the change as well. And But in terms to answer your question, no, we never made a filing with the commission. We're not aware of any other party making a filing with the commission.
Okay.
Or,
Mr. Washington?
Mr. Washington.
Yeah, if you wouldn't mind me just adding something there, I think
Please.
that's true in terms of formal filings, but I think that there were quite a few more informal communications about what we were doing. You know, the conversation has come up about community meetings, and we spend a lot of time. We take it very seriously, our obligation to speak with our customers about our programs and our processes to provide safe service to them. And some of those community meetings, the Public Service Commission actually attended. Several of those meetings, the chair of the Public Service Commission attended and listened to the concerns about what we were doing, the reasons that we were doing it as we described it to our customers, and even offered comments himself. That was a previous chair of the Public Service Commission, I want to be clear. Mr. Chairman, as you sit up. And so, you know, I don't think it's an accurate representation that there wasn't any communication to the commission and its staff about what we were doing. We had a number of meetings with technical staff. My team did, as they tried to understand what they were hearing from constituents. But there was not a formal filing.
Okay. All right. Thank you, Chair.
So let me try Commissioner O'Donnell again. So, nah, still not working. Okay, so Commissioner Barve.
Well, you've been very comprehensive, the three of you, so most of my questions have been asked, but what I would like to do is, I presume you've seen the recent communication on this from the Office of the People's Counsel. Do you care to comment on the record with respect to that? My understanding is you don't agree with him, but would you care to comment about that?
Are you referring to the
Their comments.
Yeah, there are comments on the moratorium? Is that what you're referring to?
No,
Because
I
there were several things in the comments that we do agree with.
start there.
So we agree with the Office of People's Counsel that external regulators are safer than internal regulators. We agree with that. We agree with the importance of the safety aspects of replacing the outmoded lower pressure systems off of the system. Where we disagree is that a moratorium is a responsible measure when you have identified in your distribution integrity management plan that as a risk.
Yeah, and I'll also add, Commissioner Barve, that OPC, I think, puts forth a number of suggestions about maybe some exceptions that could be made, some accommodations that could be made. A couple things on that. First of all, I believe one of them says if it's property located in a historic district, then we should consider putting it on the inside. Sounds great. The problem is, frankly, lots of the housing stock in Baltimore City that we're doing this work in would fall under that designation, almost to the point that the exclusion would swallow the rule, and there would not be really any regulators put on the outside of the houses on the work that we're doing. Also, it's just it's part and parcel to the idea that we just have a fundamental disagreement about where they're most safe. I mean, if they're going to have a number of exceptions, well, you can put it inside in this instance, you can put it inside in that instance. I don't have any reason to think people aren't going to want to take advantage of those exceptions, and that we're not going to have regulators on the outside of the house. They're going to be on the inside of the houses, and again, that's sort of defeating the safety advancement we're trying to make by placing them on the exteriors of homes.
And Commissioner Barre, if I could just add one thing. The safety benefit of putting the regulators on the outside is this, that if a catastrophic event occurs, a gas event occurs, it's not an individualized event. It doesn't just affect that individual's home. It affects the neighboring homes and the surrounding public. So, as Mr. Herson said, we don't want a situation where the exception is gobbling up the rule, and it would defeat the safety benefit altogether.
The other thing, Commissioner Barve, just to conclude this point, is we did include in our comments a number of what I'll call mitigating options. One was a potential covering that we're working on and testing to see if it would work. We reiterated the point we've tried to make in response to a lot of the media statements that you can put items in front of the regulators, you can paint the regulators. We've tried to move them as close to the steps as possible. So I don't want the commission to be left with the impression that BGE is just not budging on anything. The problem is, in our experience so far, is that those, at least in the conversations we've been having with the customers that are raising these concerns, that's not what they want to hear. They want to hear us say it's okay to put them on the inside. This isn't about painting it on the outside. It's not about putting it somewhere else on the outside that's not as visible. We don't want them on the outside at all. We want them on the inside. Because you're damaging our property, you're putting them outside is less safe, and they don't look good. That's what we're hearing. So I don't think, the idea of, again, we put these mitigating factors, mitigating options there for the commission to consider because we're trying to be reasonable. We're trying to work with customers, but the customers are just saying we don't want them on the outside at all. We want them on the inside. And that's just a fundamental disagreement we have with the customer because we believe we're advancing safety by having them on the outside for all the reasons we've included in our comments.
Thanks, Mr. Chairman. I have nothing else.
So let me try. Can we try Commissioner O'Donnell again? Do we have any thought about how this might work?
Can he call him?
Okay.
All these engineers, you think we...
Yeah, I know, yeah. All right, so while we're working on that, let me ask a few questions. So I want to kind of understand the process that you go through when you do this work. You talked about the hiring outside contractors. So when you're coming into a neighborhood, is it just the outside contractor that shows up to do the work, or are there BG&E people there too? I mean, how's it work, if you're coming to my house to make this change?
The principal interaction would be with our contractors and their crews. The first thing that'll happen is you would receive letters from our communications team that notify you that we're coming and describe what the work is going to be like. As we get closer to that, those same individuals, often the project manager or myself, will meet at community meetings, which was the case with many of the customers here in Fells Point. Then the crews will mobilize. You'll see construction going on for usually several months, installing a new gas main, and then we'll send out additional communications that say, hey, now we're going to start accessing your homes. Most of the time, there will be a dedicated individual who's usually one of our contractors who is responsible for doing all of that scheduling. So that person is the one exchanging phone numbers and emails, discussing with the customer what's going to happen to their property, finding a time where they can both the workers and the customer can be there to permit access to the building. Once all of the customers are now receiving service from the new gas service, the flow of gas from the new mains and services, we'll then retire all of the old mains in the street and start restoration.
And one clarifying point, I just want to add, we do have internal inspectors,
thank you.
that are actively engaging with the crews, with, customers as needed on a regular basis as well.
But just so I'm straight, the people that are interacting with the customers when you're doing the work are not BG&E personnel, they're these outside contractors. Is that correct?
Yes.
Okay. So next question. In Exhibit G, there's a whole series of, communications that you sent to customers, to let them know about this. I'm wondering, what was the sequence of, were the items sent to customers in the order that they're in your presentation, or were there some other, what's the first thing I would get?
First thing you're going to get is a letter that says there's a project that's going to occur. And that can be a month or more in advance of the project.
Okay, so this is the the Dear Neighbor letter that says, in the coming weeks, BG&E will begin? Is that the first communication that I'd get?
I believe so. Let me find the exhibit. Yes.
Okay.
I think I may
so-
have these in a different order, Commissioner. I apologize.
No, I understand, but I want to find it. So the very first thing you get is this letter from you describing what's going to happen. So the concern I have is this, and maybe this is hindsight, but all the discussion this morning has been focused on safety. But I really don't see anything in this letter that kind of talks about safety to a large degree. I mean, it's sort of like, well, we're going to be coming in and we're doing this to modernize the system and things like that. And it strikes me that you may have avoided some of the pushback if you had actually led with the argument of, look, we're doing this because we think, based on whatever, that it's safer to have this regulator outside your house as opposed to inside the house. And so that's what's motivating us to do this. But instead, the letter is and the safety stuff seems to come much later in the process. And my concern is that by the time you basically made the safety argument, to a certain extent, people weren't listening, because I guess they'd figured out that, they were resisting this for whatever reason. So your safety argument was, not resonating with people. And if you had started with that, maybe things would have been different. And then the next question I have is, once you got all this pushback, and maybe you've answered it through this discussion that, look, we've decided this is the safest way to go, but was there any reconsideration of this decision to force the regulators to be placed outside? I mean, was there any internal discussions within the company of maybe we need to rethink this, or was it just, full speed ahead?
Yeah, go ahead.
So the process that Mr. Nelson has described to you really accurately kind of walks through what we've done over about a 2-year period. But once we started getting pushback, a lot of that changed, right? Because he's describing the experience that an individual customer would have had. But it became more of a community discussion than an individual customer discussion at a certain point in time. And that's when you would have seen quite a lot of BGE employees being involved. My team, I think many of the neighbors who are here today know members of my team by name, have met with them many, many times. You asked whether it was full steam ahead, and the answer I would give to that is no. There was a point in time earlier this year where we stopped work for, I think it was about 8 weeks, subject to check, to think through whether there was anything that we could do that would be consistent with what we've learned from the federal authorities and what we've learned from what we still do believe was the spirit of the Flower Branch Act, that we could do that, be consistent with those safety motivations. And we spend a lot of time thinking about it. And unfortunately, it came down to a primary disagreement with our customers about what's safest. We did spend time figuring out ways to try to mitigate the visual disturbance. And we've committed to making that available to our customers to try to mitigate the aesthetic issue. But I think that at the end of that 8-week period, we did still feel that this is the safest way forward, and our federal regulators have either told us that directly or pushed us in that direction. And we think that when we surveyed state policy across the region and across the country, we see many gas utilities moving in the same way.
And I would just add to what Mr. Washington said that, we had been doing this work for some time, and this resistance wasn't there. So when the resistance started to come up is when as Mr. Washington just said, we started to take a look at this and see, if we should continue to go forward. And given that safety, it was pretty clear, we thought, given the recommendation from NTSB and our investigation, our engineering best practices, that was the proper thing to go. But I don't want to leave you with the impression that, the resistance that you see now was the resistance that was there when we began. We began this work replacing regulators as part of our work long before the present.
And if I could just clarify something real quick too, Sean Gorman. So the work that's going on is in areas where no regulators exist in the first place. These customer homes do not have a regulator that's being relocated. They are getting a regulator for the first time at that house. So when installing a regulator for the first time, a decision needs to be made. Where do we put it? When we look at the Flower Branch legislation, while it does not mandate that existing services have a specific location, it does indicate that single services are viewed as being safer when the regulator is located on the outside of the building. So in these cases where we are choosing an initial location for a regulator in the first place, that is the spirit of the law which we are referring to.
And I'll add that we are continuing to do work even under the court's restraining order with the permission of customers and lots of other parts of our system. It's not 100% cooperation. I think given a piece of paper that they have to sign, there's pause for these individuals, but we're seeing hundreds that do accept the argument. And I would submit that this is a somewhat sort of location specific movement resistance that we are discussing.
If I can just follow up very quickly. So you have an exception process, though, that someone could apply for to get the regulator moved into the customer's home, correct?
We have an exception process where the job owner who is working on that location, if in their judgment it is not technically feasible to put a regulator on the outdoors, they can file for a variance.
So that would be a crew member, someone
So,
doing the work.
so the only exception process is if it is not feasible to put the otherwise there is no other exception for putting a regulator outside. Is that correct?
Yes,
And-
and feasibility takes a number of things into consideration, such as compliance with ADA, the location of various characteristics of the site. So there's different things that go into that
Okay.
feasibility determination. But yes,
And how many exceptions have you approved, or have been approved?
I'd say on the order of 40 to 50.
40. Could you get that number for us?
I could get that number for
Thank
you.
you.
Okay. So let me turn to Commissioner O'Donnell because I think we finally fixed our technical problem.
We may have a workaround, Mr. Chairman. You hear me?
Okay. Go ahead.
Let's
Yes.
give this a try. First of all, let me just say, this type of problem is one of the most pernicious types of problems for multiple stakeholders to solve. And Commissioner Barbe knows that after almost 3 decades in the legislature, and myself almost 2, but all 5 of us in our various and varied experiences in state government and federal government, know that this is tough stuff here because we're trying to balance some very serious issues: homeowner property values, homeowner safety, implementing the PHMSA requirements as we see them. So I'm going to ask some questions, Mr. Chairman, just to get back to a couple fundamentals to check my understanding. So first, to our staff, one, is the staff of the Maryland Public Service Commission the administrator in the state of Maryland for the PHMSA pipeline safety program?
Commissioner O'Donnell, I believe the answer to that question is yes. But actually, if possible, would you be willing to withhold questions to staff until we give after our presentation, or do you really want us to be available now?
All right. Well, I'm not going to go too deep. I'm just going to kind of build a few things here. So, two, to the company, we have a exemption process for this work. If you're going to place one outside in the homeowner doesn't want it, is there a process that they can apply for and receive?
Commissioner O'Donnell, Daniel Herson for BGE. Are you referring to the Flower Branch Act program? Because yes, there is a process.
No, I'm referring to this whole regulator replacement. If someone says, I don't want you putting my regulator outside, I don't want a regulator outside because I don't like it, it's ugly, you're intruding on me and my happiness. Is there a process for me to basically opt out?
So in that event, the customer would have conversations, I believe, with the project manager. The project manager, as Mr. Nelson and Mr. Gorman were just saying, would be the person to submit the exception request. And it would probably not be granted just based on aesthetic concerns. It would have to be that the company concluded it wasn't feasible to put the regulator on the outside. That's the only process I'm aware of outside of the Flower Branch context.
And one thing I will add is we have offered to customers the ability to electrify. So if they, are interested in, changing out their electric appliances as a part of this, then they would be able to do that, instead of having the regulator put it inside.
So I'm looking for a yes or no answer. Is there a process? Because Mr. Hurston, you've known me for quite a while, and I don't like going around my elbow to get to my other elbow. Is there a process or not?
No,
I'm sorry?
no,
No, there is no process.
Was that Mr. Hurston? I couldn't tell.
no,
Okay.
this is Dawn White, no.
Let me just say, Commissioner, if I could just clarify, not for the aesthetic reasons that you stated. There is a process, but it's based on technical reasons such as the ADA, or it's just not, it's not physically possible to do that. So the answer is there is a process, but not one for non-technical reasons, if that
Well,
clarifies.
aesthetics seem right at the core of this issue. That's where everybody's upset, right? You
That's
got people up in arms, got pitchforks and torches, got our friends with light for everybody, and they don't mean Bud Light, over to Baltimore Sun and other outlets around the state. They got things worked up to a pitch level, and people have legitimate concerns. And the elected officials are trying to best represent their constituents, represent those concerns, while still taking into account the need for us to implement our federal programming, meet our inspection requirements, which, for those commissioners who don't know, when they audit our implementation of the PHMSA pipeline inspection safety system, it's more rigorous than a legislative audit, for sure. And we need to implement that thing to the T and do what they tell us, or we don't receive the money and we have to pay for those employees out of our own pocket. So we're balancing a lot of interests. It's tough to do that and come up with a good solution, and I don't think there's a good way to split the baby here. However, if you have a process that can never be used for aesthetics, ever, you basically are at one extreme on a spectrum of potentialities with regard to solving this problem. At the other end would be everybody applies for one, you check the box, you get one. So those are the two extremes. One that you can't use, never going to get approved, and the other one, everybody gets approved, and there's no saying no. So somewhere in between, maybe there's some light, some ground that we can maybe achieve some to surround without attempting to split the baby. And so I'm trying to figure out what that might be. So if you have a process where if you apply, it's not very rigorous and everybody starts applying, you basically have no safety program. Everybody's going to opt out. Problem goes away for sure. The elected officials don't have to deal with it, and the problem does go away. But the safety of the consumer is not protected. It's not protected. It's not in the public interest to do that. And part of our charge is to make sure that public safety is part of the public interest considerations we take into account. So what does the company say about some kind of process where some discerning, sparing approval, something beyond none, but something less than everybody gets one, waiver or whatever you want to call it, is possible. Can the company speak to that?
I will just say, that the company would certainly not be opposed to such a measure. As you said, one that doesn't swallow up the rule, the safety aspects of what we're trying to accomplish. And in fact, in our comments, we gave a number of potential solutions. If those are things that the commission finds useful, then maybe one of those could work. But we're open to some consideration that the commission, that we may not have, suggested.
All right. Well, there's a start. There's a kernel of hope. And where there's hope, there's life, and where there's life, there's hope. And
Life
maybe
eternal.
we've got a kernel germinating here. Who knows? We'll see where it goes. I'll prepare staff for this question. They don't have to answer it now, but when we get back to staff, I want to be asking staff about when they made this original presentation to the commission on the nature of this issue and what needed to be done, whether or not we were kind of presented with a, you don't have a choice kind of scenario. You got to do this. You don't have any choice. You got to move forward and get it done. So, tough issue. I'm glad everybody's here. I thank all the citizens for sure for coming. And we have heard from your representatives, trust me. All of us have heard from them. And they're fighting for you like tigers. But, we're trying to make sure we meet the letter of the law, both federal and state and otherwise, and make sure we make our decisions in the public interest. So thank you for being here. Let's see if that kernel of hope germinates. Thank you, Mr. Chairman.
So let me turn to Commissioner Sussman.
And to follow up from this kernel of hope that Commissioner O'Donnell has presented, I would suggest looking at what other states have done in terms of exemptions, because I'm reasonably certain, and I did a little bit of looking myself, that historic neighborhoods do play a role in the kinds of exemptions that other states have allowed. So I'm not asking you to make commitments here, but I am asking you to take a look at how other states have handled this. And I am a little concerned that there are exemption processes in place for relocating regulators for multifamily units under the Flower Branch Act, but there's nothing for single-family homes, and I'll just leave it at that.
I guess I'll just say I'm not aware of an exemption process where the customer can submit to have a multifamily regulator remain indoors.
The only distinction between those is that with Flower Branch, it requires the permission of this commission or its staff, whereas those that do not fall under the law follow the same criteria, but the determination is made by our engineering staff. They are otherwise identical to my understanding.
That's correct.
Commissioner Richard, go ahead.
Thank you, Chair Hoover. Both Commissioner Barvey and I talked a little bit about the Office of People's Counsel filing and their, I would call it a framework. That's how I'm looking at it. I just want to make sure it's clear what we're talking about with the framework, because I think the company used the word moratorium. To be clear, this is not a moratorium on the company's responsibility, core responsibility to maintain a safe operation. Is that correct? Is that your understanding? We would not be providing a moratorium on safety of the gas system.
No, well, if it's the recommendation by OPC, we would say that that would affect the company's ability to provide the safe provision of
That is a core responsibility of the utility, and I just want to, I'm not going to read their whole filing, but
Right.
it's part of their framework. They say BG it will be ordered to file a plan, among other things, to identify leaks in service areas with aging infrastructure and repair, or if necessary, replace leaking infrastructure that poses a threat to public safety. So their plan, really their overview, is simply to take a pause on just the parts of the plan that would involve regulator relocation in single-family homes. But there would still be a requirement that the company have a very robust program, including a STRIDE program, on maintaining the safety of the system. Is that your understanding? Again, this is a framework.
Right.
Okay.
We currently do look at where we're going to replace mains. The problem is with OPC's plan is that it's asking for that process to be 2 years.
It's a framework, okay? So again, we don't alarm the public that somehow there's a complete moratorium on safety. That is not at all what is in the, I guess, the framework that OPC is suggesting. It would be, and the process, should the commission go in this direction, there would be, I'm sure, a robust, active stakeholder process in how we would proceed. So again, I just don't want the impression to be left with the public that somehow OPC is suggesting a moratorium on the safety of the system. Is that your understanding as well?
I think there's a few provisions here, Commissioner, and maybe if we understand your question in a slightly different context,
I'm just talking about the context of the framework.
Understood.
The
I
Office
have
of
it.
People's Counsel plan, and it's been, I think, characterized inaccurately as somehow a moratorium on safety.
So our view would be that ceasing replacement of this aging infrastructure, as a result of the disagreement about these regulators, would be throwing the baby out with the bathwater. We've presented several options that the commission could consider whereby they would direct us to permit inside regulators under certain circumstances. In terms of the cessation of replacement that's been suggested by OPC, we've presented the data here in this presentation. We've presented previous data through our STRIDE process about the degradation of this system, and we feel it would be, a substantial increase in the risk to the public to cease those operations. Now, if your question is referring to, I think it's item B in OPC's suggested course here, when installing new regulators, BG should evaluate service installation on an individual basis. We would agree that if the commission should direct us, that we could establish, means and methods to do that.
Okay. I just want to make it clear, though, there is no suggestion of a moratorium on your responsibility to maintain the safety of the system.
Understood.
It would be very narrow, and that would be on the regulator relocation of the single family, single.
Again, to clarify, there is no relocation of regulators for the work that is replacing the low-pressure mains. There is an installation of a new regulator. So if there were to be a restriction on installing regulators, that would also be a restriction on transitioning from low pressure to a higher pressure system.
That's exactly right.
Okay. It would be, but also I would, again, we don't want to get too broad here, but even in Andover, the pointing to the system up in Massachusetts that I think led to some of the concern over low pressure, there's not, to my understanding, a full replacement program. They are going in and installing leak detection. They're installing various other types of technologies to maintain the safety of that system. So there would be measures, is that not correct, for BGE even if we were to adopt this narrow, moratorium to maintain the safety of all of BGE's system?
There are other avenues to protect a low-pressure system which we could implement. Unfortunately, a lot of those actually look like regulators. But our greater concern, and we'll be really clear about this, is with the cast iron system, it is not sustainable indefinitely. Cast iron corrosion cannot be mitigated. As it occurs and as it accelerates, those pipes will become unsafe.
Okay.
And just
to be clear,
adding-
I mean, again, that's part of, and I don't want to, again, jump ahead of OPC, because, I'm just talking about how I understand their framework. I want to understand it better as well. But again, it does not relax any of the requirements for a safe gas infrastructure.
Yes, I just want to be clear. What I am saying is that any moratorium on what we've identified in our distribution integrity management plan required by PHMSA to be a risk, which is this accelerated deterioration of the cast iron main, is, in our estimation, a safety concern. So any slowdown on that is a safety concern.
And I just want to provide a little bit more context to help kind of really understand what we're talking about here. By delaying the regulator installation, so if we were to just kind of stop and say we're going to put a moratorium on that, what that requires us is to limit the modernization of the system, because then we would not be able to upgrade the pressures from low pressure to high pressure. So as a result, then we're keeping in the low pressure cast iron main that has the potential for leaks, that if left in the ground longer and longer continues to deteriorate at faster and faster rates. So that's the risk that we're talking about here.
And understood, and also the company knows well, the other gas companies also know that we will be having another proceeding soon to examine and look at gas infrastructure across Maryland, the types of programs that will be required to maintain its safety, but also take into consideration the state's, movement toward decarbonization and possibly infrastructure contraction. So there will be another full proceeding on some of the issues that you're talking about right now. I just don't want to alarm the public that somehow, if we look at the OPC framework on this one narrow program, that we are relaxing safety at all. That's my only thing I want to make sure that is understood from our discussion
And it does
today.
create more risk.
Okay, well, it sounds like then you created risk in Bolton Hill that still have not then been identified. So I just want to be careful here to not alarm the public about safety. I mean, if you have concerns about this approach, then you need to take a look at all the work you've done in the last several years. So anyway, I'm sorry, Mr. Chairman.
That's not correct, Commissioner Richard. The system in Bolton Hill has been replaced.
Yes.
That's a new system. It's not the old outmoded system that we're trying
It doesn't have the enhanced safety that you say is required now.
We understand
since
that.
January.
We understand that, but as we've made clear a few times today, the greater risk is this outmoded system that continues to deteriorate in the ground, that we have to replace, that is in our DIMP as required by PHMSA. That system needs to come out of the ground, needs to be replaced. So as part of replacing a gas main, you have to install a regulator. And in the Bolton Hill situation, before our standards changed, yes, there were regulators that were installed inside. Those regulators are not unsafe. The concern that we talk about, the concern that we have talked about is the replacement of the system that's old and outmoded, that continues to fail at an increasing rate, some of which are past their useful life and some that are approaching the end of their useful life. That's the risk. The inside regulators are not unsafe. The external regulators are safer. And as a utility company responsible, as you said, for the safety of the public, we have changed our standard to provide the safest possible service to customers, and that's what we have instituted going forward. And we are happy to consider ways to consider other concerns that the public may have, but it's our job as the regulator, as the utility provider, to put forth a plan that we think provides the public with the safest possible options to avoid catastrophic incidents.
Okay, and I appreciate that. We'll have a chance to hear from staff and OPC this afternoon to get into specifics. And in the proceeding, I think we are going to evaluate, I guess, DIMP rankings for various projects and make sure that we are categorizing them at the highest priority, going to the risks that are at the highest priority and kind of make sure that that program is in place, and that we're also keeping in mind the state policy on decarbonization. So I'll stop there. Thank you, Mr. Chair Hoover.
So, just so I'm clear on this, so the work that was done in Bolton Hill is the same work that you're doing in Federal Hill, correct?
Yeah, fundamentally, again, our principal objective is the replacement of the old gas mains and services.
Okay,
And in that respect, it's the same.
Okay, and so there was a statement by Mr. Gorman that when you're doing this work now, that these houses, quote, didn't have regulators, and so now we're installing regulators and we're installing them outside. Is that what was happening in Bolton Hill?
Correct. So the previous system operated at low pressure, which means that the
Okay.
pressure in our pipe is the same as the pressure the appliance needs. The new system that we put in operates in that case at up to 9 psi.
Okay.
So that regulator reduces the pressure going into the building so that the appliance operates properly. Among many reasons why that is effective in mitigating the failure that happened in Andover is that all of the upstream piping prior to the customer has a very high safety factor. So if something goes wrong on our side, that regulator will prevent the pressure from going in to the customer's house, but not catastrophically affect our
Right,
infrastructure.
and I want to follow up on that. So at the very beginning of this presentation, there was discussions by Mr. Ralph about the PHMSA discussion related to outside regulators and the situation of auto accidents where, there was damage done to the car and to the person in the car, but it didn't cause. So what I want to find out is, when these regulators are outside and they're hypothetically, there's an auto collision, are these devices secure enough, strong enough that a car hitting them will not cause an explosion if it's outside, or does it depend on obviously the speed and the velocity of the automobile incident?
So obviously if a vehicle hits, the vehicles are large, if they hit anything it can damage it, and yes, that can release gas. When you go through the incident reports from PHMSA, a couple things jump out. The fatalities are the occupants of the vehicle.
Okay. Right.
Most of the reports reference high rates of speed and structural damage. So what that means is that whether the regulator was on the front of the wall, outside, or inside, it would likely have been damaged in those cases either way. Does that?
So when it's outside and it's damaged, will that act lead to an explosion, or do we need some other sort of,
Yeah, so our belief is that when it's outside, you're more likely to have ignition that looks like a flame, as opposed to when it's inside, the release of gas has the opportunity to build into a larger combustible mixture, and that results in an explosion. The difference being the flame is heat,
Right.
the explosion produces pressure, which can then damage the building structurally.
And Chair Hoover, I would just add to that. That's essentially the finding that NTSB came to. That had the regulator been on the outside and it was damaged either by the car or some other incident, it would dissipate into the atmosphere. And if there was some ignition of that gas, as Mr. Nelson pointed out, you would have a controlled flame torch, as opposed to what happens when it's damaged on the inside of the home and there's a buildup of explosive gas.
I'll also note OPC's findings, as I read them, and they can speak for themselves, reached a similar conclusion.
Okay. Any other questions?
I just have a quick question. I don't know the specifics of it, but my understanding is that BGE has brought a lawsuit against a contractor for faulty installation of regulators. Could you give us a little bit
Yeah,
of
I'll
background
speak
on
to
this?
that.
Thank you.
Obviously, I don't want to get into the aspects of the litigation, but what I will say is this: it is not having anything to do with regulators. The lawsuit has to do with the fact that the contractor did not provide the kinds of quality that they were contracted to provide in connection with the installation of bollards. So this has nothing to do with regulators at all.
But they went in front of the regulator. Is that?
So no, this is not necessarily a regulator situation. This could be any meter set or any equipment that is subject to being struck because of certain requirements that we have. So in those situations, we install a bollard, and that's from another PSC proceeding that we had in connection with Sleepy Horse.
Okay, so this
And in fact, I will just say this, Commissioner Sussman, that was a situation that was a result of an internal strike of that explosion was a result of an internal strike of a gas system that caused that explosion.
Okay, but you put these ballards in front of regulators to protect them from being struck. Is that the?
In certain situations where there are regulated, anything that's external, any gas equipment that's external, in certain situations there are bollards. And bollards are there to protect vehicle strikes in those situations where there's common vehicle traffic. So in a parking lot, for example. A sidewalk is not one of those locations.
Okay, but if there's a regulator in an alleyway, you would put a bollard there to prevent a car from striking the regulator.
Any place that there's normal vehicular traffic, yes.
Okay. Thank you.
So, any other questions? All right, seeing none. So let's do this. I want to bring up Mr. Vigneraj's panel, but I actually would like them to come to the table. So we'll take a 15-minute recess to sort of change out the parties.
no. Like, you know what? We're not doing this. I'm gonna take a good nap, wake up, I'm gonna do it. Yeah. So the PowerPoint presentation you're gonna see, and the what's it called, has been recreated
Talk
this
one,
morning.
two, test 1, 2.
So I told Lisa I was gonna send her this. That was why there's a little bit of a.
Oh, when you said that, I thought it was tomorrow.
All righty.
See, this is.
So we're back on the record. Mr. Vignaraja.
Thank you, Chairman. Good morning still, I believe. Oh, no. Good afternoon, Commissioners. My name is Tharu Vignaraja. I'm a lead counsel for the plaintiffs that have filed the lawsuits Topping et al. Versus BGE in the Circuit Court for Baltimore City. I want to make clear that the reason we are here is not because the Circuit Court is not an appropriate forum to address this, but because the Public Services Commission's views on these matters bear on the litigation. And it is critical for the litigants in this matter to solicit both counsel, guidance, direction, and findings from the Public Service Commission. What I want to do with this initial presentation before we open it up for questions is to outline precisely what the plaintiffs are asking the Commission to do. Realistically, we're not just plaintiffs. These are community leaders that represent a diverse range of associations and neighborhoods all across Baltimore. All of the people that are sitting here with me, all of the people that are in the room and will testify later are neighbors, they're residents, they're vice presidents and presidents of community associations. They are the people that have been on the front lines advocating and organizing on this issue long before I knew what an external regulator was. And it is because of the groundswell of opposition, the likes of which I have never seen in Baltimore City, against a private entity, that it ultimately resulted in a lawsuit. That was not the first step, it was the last one. And so here we are as plaintiffs, but really the requests that we are making are on behalf of literally dozens of community associations to the Public Service Commission. And there are 4 requests. The first request that we would make is that the Commission issue an order or guidance that makes clear that homeowner choice is paramount and is a prerequisite. We would not make that request if the safety claims of BG&E were true. That would be ridiculous if we were to say we want homeowners to be able to demand an option that is unsafe for their home and their neighbors. But because we do not accept that, and we'll get to that in just a moment, our first request is that homeowner choice is paramount and a prerequisite for the installation of an external regulator. The second request that we make is that this commission, which ratified the gas service tariff some number of years ago, which is the contract, as you all know, that governs the relationship between customers and BG&E, that gas service tariff be clear from the Public Service Commission's perspective that it not authorize the termination or threat of termination of gas service simply because a homeowner declines the installation of new equipment. There are very specific reasons why you can shut off a homeowner's gas service in the state of Maryland under that contract and under COMAR regulations. Those reasons include not paying your bill. Those reasons include declining access to the equipment that is already there. But the contract, as well as COMAR regulations, do not contemplate and explicitly do not include terminating or threatening termination of service for declining gas equipment that is not necessary, that is not required by state or federal law or state or federal regulations, and is unwanted by the homeowner. The third request that we make, and this is one that we're going to spend some time on, is that the commission issue a finding that external gas regulators are no less safe than internal regulators, and in fact are likely more dangerous based on the comprehensive, robust data that has been publicly issued by the federal agency responsible for maintaining the safety of 2.6 million miles of natural gas pipeline, the Pipeline and Hazardous Materials Safety Administration. That this commission issue a finding that those external regulators are not just not more safe, but are actually more dangerous than the internal installations. And this is a myth. that BG&E has propagated for months. It is something that they have been asked by reporters, by community associations, by advocates, by the judge in this hearing to supply what data they point to support that claim, and they have not provided data. The data that they point to is the data that we presented, and we will present again here today, because we think that data makes it crystal clear that intuition and anecdote aside, external regulators are dramatically more dangerous than internal installations. And fourth, we asked the Commission, and this is not precisely the forum for this, but we believe it is connected enough that we're going to ask this request, that the Commission direct and reconsider the overall project of replacing low-pressure gas lines with high-pressure gas lines that are going to service well for the next 100 years. And I'm going to start with that one, if it's okay, because that is the one that is really the subject of another hearing, but it is related enough that I want to be clear about our position on this. Low-pressure gas lines have been underneath the streets of Baltimore and beyond for decades. They are, in no question, disrepair. They are, every year, every decade, becoming more dangerous. But be clear, there are 4 options for how to address that concern. The first solution, of course, is to repair and maintain the low-pressure gas lines. Commissioner Richard, you alluded to other approaches that other jurisdictions have taken to identify and spot check where the risks are, where the holes are, where the leaks are, and focus maintenance and replacement of those particular streets, those particular blocks. That's option 1. Option 2 is that you can replace the low-pressure gas lines with new low-pressure gas lines. You don't have to move to high pressure, which is what necessitates the regulators. You could replace low-pressure gas lines, either incrementally or wholesale, with new low-pressure gas lines. We think there's good reasons why BG&E is doing it, moving to high pressure, that have to do with lowering their overall costs, reducing maintenance costs overall, reducing the risk of infiltration of water within the pipeline. There are good reasons for doing it. That is certainly a choice, but be crystal clear. To avoid the safety concerns that they're alluding to, you don't have to put in high pressure, you can put in low pressure. The third solution, of course, is to replace with high pressure gas lines, which is what the Public Service Commission in prior orders by a prior commission has in fact approved. And that is what they are operating under. Operation Pipeline has been in effect for some time. We can understand their reticence and reluctance to hit pause on that. That is underway. But be clear, that is the third option, is to replace the high-pressure gas lines, which is the only one of the 4 solutions that necessitates external or internal regulators. So let me just make sure everybody is clear, the audience and the commission as well. You put in a regulator because you put in a high-pressure gas line. The high pressure is underneath the streets. Before it gets to your stove, it needs to be brought down to low pressure. So the moment you put in a high-pressure gas line, BG&E is absolutely right, a regulator has to be installed. It doesn't have to be installed externally. It can be installed internally, as they did in Bolton Hill, in Upper Fells, in Butchers Hill, in numerous neighborhoods across Baltimore for the past 2.5 years. But that is what requires a regulator to be put in the first place. So if they're concerned about regulators because they're concerned about the risks of high-pressure gas lines, that is a risk they have chosen to adopt. And the fourth option, of course, is to move towards electrification. It is what other jurisdictions in this country have proposed. Montgomery County, San Francisco, Washington, D.C., New York City have all outlawed future natural gas hookups. They have pushed towards the carbon goals that Maryland as a state have adopted. And it respectfully is our view that one of the reasons why, interestingly, BG&E prefers to at least put in the gas lines, even if they lose this particular battle and they have to put every regulator inside, they'd still rather that than go towards electrification or go towards low-pressure gas lines, because these high-pressure gas lines have 2 advantages for them. The first one is a very simple economic one. If they repair or maintain the corroding low-pressure gas lines that are presently in place, they got to pick up the tab. Those are maintenance costs, those are repair costs that come out of their bottom line. Because of Maryland's law, wise or not, it is the law of Maryland, because replacing instead of repairing is an infrastructure investment, they get to pass that bill on to all of us in the form of rate increases that they get the Public Service Commission to bless, or in the form of surcharges. Of those four options, the community believes that high-pressure gas regulators with a demand that every homeowner have an external regulator is the least attractive, The environment and the environmental concerns push towards electrification. We don't have to invest in another 100 years of gas infrastructure. That's what the replacement pipes will last us, 100 years. Billions of dollars will be invested in something that we hope to phase out in the next decade, that Montgomery County, San Francisco, New York City have already started to phase out. But that is the investment choice that they are making. So the first request that we have made is that we encourage the commission to reconsider that fundamental threshold determination. But realistically, that's beyond the ken of these plaintiffs. We're not experts in that. You guys are, and we entrust that judgment about the overall environmental concerns versus the economic considerations to the commission. The ones I want to focus on are the ones that affect individual homeowners in Baltimore City and beyond. The first request that we have made is that the commission make clear, as the judge's temporary restraining order does, that an external regulator cannot be installed without the written and informed consent of the homeowner. Written and informed consent. Because as you will hear from not just the people at the panel's table, but from countless other residents, this is the source of the anger. This is the source of the vitriol, is the misinformation campaign, the bullying and bulldozing that BG&E appears to have done really in every neighborhood, but in certain neighborhoods more acutely than others. There are two reasons why we think that consent is appropriate. The first is that homeowners know the particular and peculiar risks to their safety and to their community's safety better, with all due respect, than the commission or BG&E. Some people live on streets that have narrow lanes that entice speeding. There are people that live on streets where they see people zipping by every day, every night. Some people live in neighborhoods where there is more vandalism, more theft, more individuals that are out at night doing mischievous things, which we will point to as a specific concern in specific neighborhoods. Some people live in neighborhoods where there is more scooter traffic or pedestrian traffic. Some people live in homes where they know, because they're a senior or their neighbor's an elderly individual, that the maintenance responsibilities for an external regulator, which do not exist for an internal regulator, are more than they can do. The utility company has gracefully put out guidance for all the things that you have to do once you get an external regulator. They've started mailing them to folks to tell them exactly what they have to do, and we'll make this certainly a part of the record. Some elderly people can't go out every snowfall and brush off the snow. Some people can't hire inspectors, as they've suggested, to manage and maintain the safety of those external regulators. That is something that a homeowner has to make a decision about what's best for them. Liz, can I see that for a second? I'm just going to read into the record one thing here. Many gas appliances have open burners. Older models also have pilot lights that burn continuously. It is very important to keep the area around your gas appliances clear of all flammable objects and substances. That's pretty straightforward. The next paragraph. To keep your meter accessible, make sure there is a minimum of 3 feet of clear space around each meter. While BG&E maintains the gas piping up to the gas meter, each gas customer is responsible for maintaining and monitoring all above-ground pipes after the meter. Be sure to periodically inspect gas piping located after the meter for leaks and corrosion, and make any necessary repairs. Plumbers who are state certified to work on gas piping can perform maintenance repairs of gas fuel piping after the meter. This wasn't just BG&E's guidance. It's also now the guidance that has been issued, and you'll hear more about this from one of our members, that home insurance companies have put out. Home insurance companies that are companies that now get sued when something goes wrong with these gas pipes outside have provided guidance of what is needed for the homeowner to maintain their legal responsibility to keep those pipes safe. That's the first reason. The second reason the homeowner ought to have the final say is because in certain neighborhoods in Baltimore, they have. And in other neighborhoods in Baltimore, they have not. We publicized Bolton Hill. It was a graphic, clear illustration of how ridiculous it was that just over a year ago, residents of Bolton Hill, they had to demand it. It wasn't an obvious option, but they pushed, they persisted, and BG&E buckled. And they allowed virtually every home in Bolton Hill to get an internal installation with an external snorkel vent. And let's be clear, these regulators work the same. The same regulator inside is the same regulator outside. They both exhaust to the outside. There's a snorkel vent for the internal installations to exhaust to the outside. And that is why every affluent home in Bolton Hill was given the privilege of having an internal regulator. And I have a lot of respect for many of them friends from BG&E, but I want to be clear about some things that they just said that were not true. We did an event, a press conference, at the corner of Landvale and Park, and we walked down the street. You should visit. You should drive through. Every one of those homes, with one exception on one side of the street and another exception on the other side of the street, got internal events. It wasn't some, oh, it's appropriate for 268 Landvale, but not for 270 Landvale. They're identical homes, one after the other, after the other, after the other. We're not talking about corner houses versus houses with driveway. They're identical. And the homeowners, as some of them will testify, were given the option, after pushing, to have an internal installation. And they weren't unsafe. One of the things that has been frustrating about the narrative that BG&E has said is that this wasn't about black and white communities. This wasn't about rich and poor communities. It just so happened that right after they finished with Bolton Hill and Upper Fells and Butchers Hill and certain other neighborhoods, that their standard changed. Commissioner Sussman, I think you mentioned and asked them about the timing of their internal change. Interestingly, and I'll make this a part of the record, the installations in Bolton Hill that were internal were done beginning in February of 2022. So whatever claims they had about seeing the light, seeing the revelation of the dangers of external regulators, it didn't happen in December of 2021. It may have been a transition. They said to the judge in the first hearing that it was part of some construction manual. They had a date of January of 2023 on that. And they represented to the judge that the Public Service Commission had blessed that. Now, pressed by the judge and pressed by the commissioners, they acknowledged that it wasn't the commissioners, that there was no formal filing, but they believed some engineers were aware of the changes in the standards. That document was dated January of 2023. They have now pointed to an earlier document in late 2021. This is publicly available. You can go to the Bolton Hill Community Association. They do a very good job of maintaining their archives. And on their archives, they have a notice that says, and this is in February, the headline is, Major BGE Project in Bolton Hill could begin in February. BG&E will begin major gas line work in Bolton Hill in the first quarter of next year. So in late 2021, they're talking about the first quarter of 2022. They go on to explain what the concerns are, concerned about noise, private public property damage or repairs. They will be digging up roads. They talk about parking. And they explain that this was originally going to be done in 2020. The rollout of this initiative was originally planned for the middle of 2020, but was delayed due to the pandemic. But in February of 2022 is when they were working in Bolton Hill. And as you will hear from Ms. Adrienne Smith in West Baltimore, from Ms. Saritha Staten in East Baltimore, these are neighborhoods that around that same time were being forced, some before, some after, to get external regulators. And when they pushed back and when they said we don't want them, they don't want them not just because aesthetic concerns. Don't let them caricature the position of these families, but because of safety concerns, because of vandalism, because of automobile accidents, the concerns that they raised at that time, BG&E said, sorry, you have no choice. And if you don't do it, we're going to cut off your gas service. And that is exactly what they did. This wasn't an idle threat. In October of 2022, they shut off Ms. Smith's gas. And it wasn't because they weren't making noise. They got a petition with 20 signatories from the 1600 block, what block was it? 1600 block of North Smallwood Street that said, we don't want this. In their petition that they shared with their elected officials, they said, we've driven to Bolton Hill. Just give us what Bolton Hill got a few months ago. They didn't say, oh, we have a new standard. Oh, there's a new policy. They just said, no, sorry, you don't have an option. They put that in writing. They issued requests to the media. They issued requests to their public officials. They filed a lawsuit pro se in Montgomery County in district court. Ms. Smith didn't know that it had to be filed in circuit court in Baltimore City, and the judge said, because of the venue and because of the damages, we can't proceed. But they tried there too. Now, don't blame some of my clients for being able to get the public's attention because they live in beautiful neighborhoods in Federal Hill and Fells Point. They are fighting on behalf of everyone, but be crystal clear, neighborhoods were lamenting this choice for months. They were just ignored. They were bullied and bulldozed despite their best organizational efforts, and you will hear again from others about exactly what they did. Because of the individualized knowledge that a customer has about the risks specific to their home, their street, their community, and because it is truly offensive that some homes got this benefit and other homes didn't, when they themselves acknowledge that both are safe, some are just safer. Well, if I want to get a bike helmet that's a little less safe than another bike helmet, but both bike helmets are mine, are options because they are both safe, customers get to choose. And BG&E, just because it's a monopoly, doesn't get an exemption from that general principle. Once they have acknowledged before this commission that both are safe, that neither is mandated by the Flower Branch Act or anything else, customer prerogatives, a homeowner's specialized knowledge ought to be paramount. The second request that we have made is that this commission make clear that the gas service tariff that governs the relationship between customers and BG&E not include the possibility of turning off your gas service because you could decline new equipment. Now, we only have a preliminary ruling from the circuit court, from Judge Nugent, but one of the requirements, as all the lawyers know, for obtaining a TRO, a temporary restraining order, is that the plaintiffs are likely to prevail on the merits. And Judge Nugent, in issuing his order with respect to the TRO, explained that his interpretation of the gas service tariffs was the plaintiffs, that the language in that gas service tariff, echoed in COMAR regulations, is that customers are required to give reasonable access to its equipment located in or on the customer's premises. I didn't make a particularly sophisticated argument before the court. What we said was they have the right to have reasonable access to their equipment located in or on the customer's premises. That's equipment that's already there. You can't have reasonable access to equipment that you're installing, which is the grounds that they were using, the grounds that they listed in these notices that said we're going to shut off your service. They said you are denying us access to the equipment. The judge said nothing in COMAR and nothing in the gas service tariff makes clear that you can shut off service or threaten to shut off service because of a customer's choice to decline new equipment. BG&E is entitled to access its existing equipment located on or in the customer's premises. We augmented that basic argument with some more sophisticated arguments about what words like modify mean, citing U.S. Supreme Court interpretations of how the word modify can't mean putting in wholesale new equipment. But the bottom line was that the gas service tariff doesn't allow them to shut off people's gas service, and that's the way it should be. I investigated the history of this. There was a time when BG&E was frustrated because homeowners wouldn't allow them to come in and read the meter so they could give them an accurate bill. Back then, what they had to do was actually apply for a writ of replevin from the sheriff's office and say, that's our equipment, so you're shutting the door, you won't let us in, but we have a right to get our equipment back, so we need a writ of replevin from the sheriff, and we can then go in, and while we're getting our equipment, we can look at the thing. They ultimately, and understandably, because they were frustrated with homeowners that for sometimes good reasons, sometimes for bad reasons, wouldn't let them in, they codified that requirement in the gas service tariff. The gas service tariff guarantees that BG&E can come in and look at the meter, make ordinary repairs, do that kind of thing. Nowhere in that gas service tariff are they allowed to install new equipment and a declination of that being a basis for terminating service. Now, this is something that the court could issue a ruling on as well. They're interpreting contract language, so the terms of this could be clarified by a court. We believe the Public Service Commission doesn't have exclusive or primary jurisdiction, but does have concurrent jurisdiction to interpret a contract that you yourselves have ratified in prior iterations. So it would be appropriate for the Public Service Commission to make clear to the residents of Baltimore and beyond that they don't have to worry that their gas service is being shut off because somebody is denying a new piece of equipment. And by the way, the alternate interpretation of that would mean BG&E gets to install whatever they want based on their own internal standards, devoid of data, devoid of an obligation under law or regulation. Just because they chose to, they can then come in and say, if you don't do it, we're going to cut off your service. It happened in Federal Hill recently. But before all the media were there and all the cameras were rolling, when some of my clients were arrested for objecting to people's gas service being cut off, it happened in West Baltimore. It happened to Ms. Smith on October 27th, just before Halloween of 2022, after months of organizing, weeks of objecting, after submitting a protest in writing, asking the media and politicians to reiterate, they ultimately went to Ms. Smith and said, we're shutting off your gas service if you don't get an external regulator. And she said, I don't want one. My house is over 100 years old. No, it's not in a CHAP district. No, it is not in a historic district, but it's her parents' home that she inherited. And she didn't want a gaudy, unnecessary, unsafe regulator on the outside. And she said, I won't do it. So they cut off her gas service for 2 months. She couldn't host Thanksgiving dinner. She couldn't host Christmas dinner because she didn't have heat or hot water or cooking gas. Ultimately, the week between Christmas and New Year's, she relented. She surrendered. She literally said, I can't do it anymore. All of my neighbors, I'm trying to fight for them too, but the media is not paying attention. The politicians aren't paying attention. I can't do it anymore, and she relented. And now there's an external regulator on her home. In that letter, this wasn't my argument, it was hers. In that letter to public officials, in that letter to media, she said, we just drove through Bolton Hill. It's only 5 minutes away, and we don't see any of these regulators there. We know that the work was done. What she didn't know is that they'd gotten the work done. There'd been installations. There was a snorkel vent outside of every single home on Landvale, on Park Avenue, with 1 or 2 exceptions, because either the person wasn't home. We've been trying to figure out why they got it. Maybe they chose. Maybe they didn't like the idea. Maybe they thought it looked good. Maybe they wanted to decorate it and paint it the same color. It doesn't matter why, but some people got it, and Ms. Smith never had that option. We asked the commission to make clear that the gas service tariff does not authorize BG&E to terminate or threaten terminations of gas service solely on the grounds that a homeowner is declining the installation of new equipment that is not required by law or regulation. The third thing that we are asking for is for the commission to make clear that external regulators are not less safe than internal regulators. I'm sorry, that external regulators are more dangerous than internal regulators. And for this, I'm going to have to spend a few minutes presenting some data to you, and I'm going to ask if we can actually put up this screen. I'm going to go through some conclusions first, and then I'm going to walk through the analysis because respectfully, I'm a little frustrated by this perception that this is really complicated rocket science, and the data is really difficult to interpret, and therefore BG&E must have it right. It's not complicated. It's not complicated at all. You can go on YouTube and search for gas explosion car accidents, and you will find dozens of examples. We thought it was a little bit much for this commission, but we'll certainly put it before the court. Dozens of videos of cars crashing into homes and then blowing up. But don't take my word for it. Let's look at the data. The Pipeline and Hazardous Materials Safety Administration maintains on their website data going back to 2010 and then a separate data set going back even before that. We've analyzed both, but I want to focus your attention because it is considered more recent to the most recent data from 2010 to last month. It is literally from 2010 to the present. You can download the spreadsheet. It's a big spreadsheet. It's got 1,393 rows, one for each of the incidents across the country. It's got like 500 variables. Every possible variable, they have to report each and every one of these incidents. I'm just going to show you what that looks like for a second. That's the raw data, and it's big. There are hundreds of examples, thousands of incidents, and literally hundreds and hundreds of rows. But at the end of the day, there's 1,393 incidents. Between 2010 and the present, you can actually search within the 1,393 Excel spreadsheet for one that involved an incident relating to internal equipment or external equipment. And I'll show you exactly how we did that in a moment. Of those 1,393 incidents, some very catastrophic, some very modest, of those, there were 256 that involved either an interior or an exterior regulator or gas meter. Both are considered part of that compilation. So we thought, well, that's the best way to compare which one's safer. We've got data from across the country for over a decade, in fact, 4 decades, and we thought if BG&E really had evidence that this was more unsafe, surely the data would reflect that. They'd have some high-powered, high-paid expert analyze this and present to you this beautiful study that said they're so dangerous internally, you got to put them outside. Well, it turns out none of the data and none of the examples support their claim, and I want to go through this in some detail. 87% of the 256 incidents involved an outside meter, not an inside meter. Of those, we looked for the ones that had injuries, hospitalizations, or fatalities. There's a separate column for each one of those. There are separate columns for fatalities, for injuries, as well as for hospitalizations that didn't require the person to be admitted at the hospital. Each of those are counted. So across those 256 incidents that involved an interior and exterior equipment set, there were 101 people who were injured, hospitalized, or killed. Those trend lines that I just mentioned are consistent for those as well. Nearly 80%, 80 of the 101 were linked to incidents involving exterior installations of equipment, meters, or gas regulators. We looked, maybe it was more, it caused more injuries, but maybe the fatalities happened because of interior. So we broke it down. We looked at fatalities, we looked at injuries, and we looked at hospitalizations without a permanent stay. Of the 23 fatalities, 74% were related to external regulators. Of the 67 injuries, 81% were related to external regulators. Of the 11 additional hospitalizations, the mildest ones, even there, 82% of the incidents nationwide, according to PIMSA's published data set, were linked to external regulators. So then we started hearing what BG&E's latest line was, because remember, we asked them for the study or the data. And after months of silence, we decided to go look at it ourselves. And so we put this data out there. After every community association, the judge, the reporters had asked them for studies, we finally did the analysis ourselves. And now they say, oh, this is a traffic safety problem. It's because a car is going really fast and hitting a building. And when you hit a building, whether there's a gas regulator there or not, you might die. That's true. And so we thought, how do we test that assumption? Well, a gas regulator, a piece of gas equipment, if it's hit, might get sheared off and there might be a gas leakage. There might be a fire. There might be an explosion. If most of these fatalities, if most of these injuries were in incidents where there wasn't a fire, when there wasn't an explosion, they might be right. It's just somebody driving out of control, hitting a wall. It happens to have a gas regulator there, but they die on impact. That would be a pretty good argument. Unfortunately, the data doesn't support that. In fact, in the incidents involving fatalities, there are 23 of them, every single one of them, not some, not most, every single one of them had a fire or an explosion. Some of them, the notes make clear, the death was caused by the fire or explosion. Some of them, it's less clear. But in every one of the fatalities, it is because the incident at least acknowledges that there was a fire or explosion. They just weren't slamming into a brick wall that had a piece of metal there. They were slamming into a brick wall that had a gas meter or a gas regulator or a gas line that had some leak that caught fire and in some instances exploded. For the benefit of the audience and for the thing, I just want to make clear what this looks like. Those are the 256 incidents that have an internal or an external regulator, 87% external regulator incidents related. Of the injuries, the 101 injuries, hospitalizations, or fatalities, 79% were external regulators. We broke it down by fatalities, injuries, and hospitalizations. Within each of those subcategories, same thing. The overwhelming majority, 80, 75, 80 plus percent, were related to external regulators. We broke it down by fatalities, about the fires. And I want to just spend a minute on this. In that first graphic in the upper left corner, there were 23 fatalities. 35% of them, there was an explosion. The other 65%, there was at least a fire. When we go to non-fatal injuries, the 67 of those, in 10% of those, there was neither a fire nor an explosion. Those are the examples that support BG&E's position. They just hit something really hard at a really fast speed and they got hurt. But in all of the others, and literally in all of the fatalities, there was a fire or an explosion. In the non-serious ones, in the ones that had hospitalization but you didn't have to stay overnight, it's a little bit more even. The color coding got switched. I apologize. That's poor graphic presentation. But 45% were non-fire incidents. 55% there was a fire, and there were no explosions. Okay? So for those last 11, it's a little bit more even. But in all the other categories, there was an explosion or a fire. And the reason I wanted to do this is because when it comes to data, I'm a numbers guy. I know I'm a lawyer, but I'm a numbers guy. It's sometimes easy to misrepresent statistics. And in a forum like this, I don't think I've ever been here before. I wanted to make sure that there was some measure of credibility that came with these conclusions. We are submitting this as part of the record. You can play with this data set yourself. You can re-download it and do it over. This first tab is raw data. It is all of the information across every column, across every incident. The second one is all the data with the key variables. And for ease of reference, I have put in the row above, you see that like A1, that right there, COPRL, that is the column from the original data set from which this column is done. So instead of having 500 columns, we've narrowed it down to the critical 12 or 15. But if you want to just see where it is, the report number is column C in the raw data. It's the first column, obviously, in this data. So we have the report number, so you can go back and back reference it. Your technical staff is going to hate me for it, but you can go back and look at every single one. This is the location or street. This is the city, the date and time of when it happened. You'll see that it goes from 2023 June, literally the most recent incident, all the way back to January of 2020. You see the bottom one right there. So these are all of the incidents across all of the data sets going back literally the 1,393 incidents. This is the column that allows you to identify which ones are involved. Outside meter or regulator sets, inside meter or regulator sets, the main, that is like the main equipment at the service center, etc. This row, which is originally column AR, is the number of fatalities. This is the number of injuries. This is the number of hospitalizations that were not overnight. Give PIMS a credit. This is the number of injuries treated by an EMT. This column, column AZ in the original data, is whether or not there was an ignition, whether the gas was ignited. This column is whether or not there was an explosion or not. This column is whether or not there was an unintentional release, and I think it's in cubic pounds or cubic tons how much was released. Sometimes it's very small, sometimes it's quite a lot. This is the year of the installation of the equipment in question. This is the costs that were borne by the operator. And then you've got details. You've got the outside force. You've got whether or not it's intentional or not. We're going to come back to that. And then you have a narrative description of exactly what happened according to PIMSA, and we'll come back to that. What I want to do is make clear what we did. What we did was we took these system parts, and you see that there's a handful of them, and we said, let's get rid of the ones that are involving district regulators or farm taps. Let's keep the ones that are inside meters. Let's get rid of the ones that are main or other. Let's keep the outside ones. Let's take out the service ones. Let's take out the service risers and the service valves. And now we go from 1,393 incidents to 256. You see in the bottom left-hand corner the 256 incidents that meet those two criteria, outside or inside. And then what we did, we don't have to recreate the whole thing for you, but I just want to show you, is if we then click on fatal, and we get rid of the ones that have 0 fatalities. So these are all the fatal incidents. You will see these are all the fatal incidents across the country that involved internal or external for the last 13 plus years. You can still see the number of hospitalizations, but these are not ones that have 0 fatalities but some injuries. That's how you got the 256. These are just the ones that are fatal. And then you can say, well, what if we just did these incredibly dangerous internal ones, and let's see how many of those cause that. Turns out there are 3. There are 3 incidents across the country over the past 13 plus years where somebody died because of an internal regulator. 6 people died in those, and each and every one of those is a tragedy. But I want to make sure, because BGE tried to tell you about the anecdotes, I saw that nice Exhibit F in their thing about how the excessive speeds were involved. I want to show you in just a moment what was involved in these internal meter ones. But before we do that, let's just go to those external meter ones. These are the ones where there were fatalities related to outside meters. Number of people injured in addition. You don't have to be a data analyst to see that every single one of them had an ignition. Every single one of them. And if you sort down here, some of them involved explosions, some of them did not. But 5 of the deaths were related to explosion ones. And then you can go into and look at these detailed accounts of what happened to understand exactly what took place. And here's what's interesting about the internal ones. The internal ones all involved intentional damage, or other incorrect operation. We'll go about that in a second. One of them was vandalism. One of them was intentional damage. One of them was tampering. And you can go and read the descriptions of what happened in each of these. And for the purpose of the record, I just wanted to clarify one thing. The first one happened in 2020. This happened in Omaha, Nebraska. This is one where the PIMSA concluded that the apparent cause of the incident was tampering with the pipeline inside the structure. The district's conclusion is consistent with the results of a joint Nebraska State Fire Marshal Agency and Omaha Fire Department investigation that took place following the incident. Somebody messed with the regulator or gas equipment inside. It exploded, I believe, or there was a fire. There was an explosion, and several people died. Intentional tampering. The second one, Rochester, New York, August 2019. There was an investigation in Ogre, and here's a fascinating read. RG&E, the local one over there in Rochester, RG&E and fire department personnel on scene identified that the service regulator upstream, so glad it was defined earlier, somewhere outside the house, of the company meter appeared to have been intentionally tampered with or disassembled that would have released natural gas into the building. As part of the company's normal control notification procedures, the NRC was notified. However, the company did not consider it reportable to PIMSA since there was no component failure or contributing company cause of the event. Subsequent discussions with NYC PSC safety staff suggested RG&E request clarification from PIMSA. Mr. Request was sent on October 10th. Response was from Mr. Peter Katchmer on October 16th. Mr. Katchmer indicated this was a reportable event. Somebody messed with something upstream that caused a leak inside of the house that then exploded and resulted in a fatality. The reason we flag that is because that is one of the concerns that residents have. You will hear later today that it is not that difficult to tamper with these things outside. And there are communities like Miss Smith's, like Miss Staten's, like Federal Hill, like Fells Point, where people are worried that we are one TikTok video away from somebody coming and with a flatbed screwdriver popping off the top and adjusting the pressure, height or low. I'm glad to hear that there's experimental new hardware that could make it safer and harder to deal with, but this is the reality that residents of Baltimore face right now. The last one in Minneapolis, Minnesota, was one where it says, as a result of the explosion, 2 individuals were killed and 9 were injured. At the time of the explosion, this is the last one of the 3 incidents that involved interior regulators or interior equipment. This was the last one. As a result of the explosion, 2 individuals were killed and 9 were injured. At the time of the explosion, 2 workers were installing new piping to support the relocation of gas meters from the basement of the building to the outside. Even what they are doing has a risk. And we know this. We know it's an acceptable risk. We get it. But that is not a risk that you can force down homeowners' throats. Bottom line, and I welcome them coming up here and telling me if I missed an example, we have not found one incident anywhere in the country that resulted in a fatality because of the malfunction of an interior regulator. These regulators are supposed to be the safety mechanism. They have automatic shutoffs. They have an external vent in the internal installation and the external installation. This specter that these are so much more dangerous is not supported by reality. And I just decided this morning to pull this because I found it puzzling that they were saying that there were instances where the car was hitting, but they were all dying because of the speed at which they were at Exhibit F, where they have all the excessive speeds. Yes, there were a lot of excessive speeds. In every single one of them, there was also a fire or an explosion. Here are 3 examples that I'm going to close this part with that explain this. Decatur, Illinois. It's case number 307, so you can look it up in the specific one. Report revised to show restart time, which is equal to the shutdown time. A third-party passenger vehicle drove off of a residential road and crashed through a natural gas meter set and into the side of a home, with the vehicle coming to a stop completely inside the residential structure. The gas meter was installed immediately adjacent to the structure. Gas began leaking and ignited a fire, which ensued, which resulted in a fatality to a resident of the impacted home who was inside at the time, damage to the structure and contents, and damage to the public vehicle. That's one where the house caught on fire because of a gas leak. There's literally dozens of these. Injuries and fatalities, there's dozens of these. Just another one. West McNeese Street in Lake Charles, Louisiana. Case number 257. Vehicle left the roadway and made impact to CenterPoint Energy Facility and customer's home, which resulted in gas leakage ignition, and driver fatality. It literally hit a thing, it ignited the gas, and the car exploded, and the person was killed. Case number 27 in Bismarck, North Dakota, 400 North Street. The MDU service technician determined a vehicle traveling in a residential subdivision left the roadway and struck an outside meter set on the house, shearing off the riser at ground level, causing a release of natural gas that ignited. The driver of the vehicle did not survive, and 4 residents of the house were transported to the hospital. The 4 residents at 414 were evacuated. Occupants at 426 and 1392 were also evacuated. Number of people evacuated in part is an estimate. In each of these instances, there are countless examples, literally no examples of what they're claiming is the big specter, the big fear about Flower Branch occurring again. Lots of examples of cars hitting gas pipes, shearing off the metal equipment, gas leaking, it igniting, and or it exploding. And I am sorry to have belabored this point, but it has been frustrating for these litigants to see BG&E, with all the credibility that they have built up, walk in here and wave a wand and say it's about safety when it isn't. If it was about safety, they would have made that argument 3 years ago when they testified before the Maryland General Assembly. They said the exact opposite. You're going to hear quotes about what BG&E told the Maryland General Assembly, specifically citing Baltimore City and its densely populated streets as a reason why they shouldn't do it. The law is clear. I was going to spend a lot of time, but I actually think the Commission has a pretty clear handle on this. The Flower Branch Act does not require this. The Flower Branch Act does not require this. The National Transportation Safety Board's recommendations were not adopted by the federal agency that has authority, primary authority over safety considerations, PHMSA. In fact, the Flower Branch Act does have twin mandates, but it's not the mandates that they were talking about. Public Utility Article Section 7-313C is the other twin. Yes, you need to relocate it for new installations, and yes, you need to relocate it for multifamily dwellings with 6 or more units. But the law of Maryland also says that a gas service regulator be installed away from roads, driveways, parking areas, or other locations exposed to vehicular traffic or other external forces that may damage the gas service regulator. That is a mandate too. And in every street in Baltimore City where those regulators are a few feet away from the street, where in Miss Dayton's neighborhood people speed all the time, where people crash into buildings all the time, to put it there is a violation of current Maryland law. It's not you can put it wherever you want, as long as it's not a multifamily dwelling. For multifamily dwellings, you have to put it outside, but everywhere else, it's up to David Ralph and BG&E. No, you actually cannot put it in the places where they are putting it. I don't know exactly why they feel so strongly about this. I don't think it's safety. I think it has a lot to do with their broader commitment to handcuff us to their golden goose, to install natural gas pipeline that will outlast all of us living here today. I think it has a lot to do with shifting liability. In these cases, even though there are more injuries, more hospitalizations, and more deaths related to external installations, BG&E and its counterparts across the country don't get sued. You know who gets sued? The motorist and the homeowner, the auto insurance company and the home insurance company, which is why they're issuing guidelines for what you're supposed to do once the regulator is outside. On the instances where something internal happens and a building blows up, even though there are many fewer of those instances, many fewer hospitalizations, injuries and hospitalizations and fatalities, you know who gets sued? The utility company. It's not my job to speculate as to why they did it. It is my job to make clear that safety is not the reason. And we are urging this commission to certainly reconsider the broader mandate of a 100-year investment at the cost of billions of dollars to taxpayers when we're supposed to be moving away from it. But we more specifically, on behalf of the plaintiffs, ask that you make clear that the gas service tariff does not allow them to do what they've been doing to too many communities, that safety is not a reason to put these things externally, that the data simply does not support this. I don't know that they have a contrary study. We've asked them, reporters have asked them, The judge asked them, and all they did was say, it's in the spirit of the Flower Branch Act. It's in the spirit of the Flower Branch Act. Well, in the language of the Flower Branch Act is that you don't put them near driveways or roadways. And that is what they are doing in Baltimore City. The example that they themselves cited in writing as the reason why external regulators should not be mandated under Maryland law. In light of this data, in light of the outrage that communities have felt, we urge the Commission to intervene. We don't think, put it in writing, I don't think you have primary or exclusive jurisdiction over this matter, but we do believe you have concurrent jurisdiction. We believe you have an important role and responsibility here to clarify the meaning of that contract and to make clear that on the safety question, you don't get to just take BG&E's word for it. You don't get to throw up a couple of splashy photos. I could have shown you video after video of door cameras watching cars hit buildings. But I didn't want to do that because I think the data is more compelling. That's what they're supposed to rely on. And for these reasons, we respectfully submit and ask the Commission if there's any questions for me or my learned panel.
Just one sort of process question. You do, and I think you mentioned this, you do intend on filing the spreadsheet that you discussed with us
We do.
and provide to all the parties. So.
Correct. It is data that is derived specifically from the PIMSA thing. That's the first tab, but we'll provide everything and the PowerPoint presentation. Play with it to your heart's content.
Sounds good. So I guess you have questions for, all right, so we'll start with questions for Mr. Vigneroger first, and then we'll turn to the panel.
Actually, I have some questions for Mr. Gorman. If you could come to the podium. And if you could bring with you the construction manual for location, the assembly location policy. Okay, so I didn't really appreciate the date until Mr. Vigramna Raja, I'm sorry, and people get
I've
my
heard
name.
much worse.
I know, people get my last name wrong all the time. But so I didn't really appreciate the 1/27/23 date in the document I have. So what I'd like to know is what I'd like to get a sense of what was the previous policy in place and the date for that, or was this the first time this policy was put in writing?
No, the adjustment to this policy, which happened in early 2023, was around. I'm looking for the exact section, but I believe it was around emergency response practices, where if we encounter an emergent situation where we need to make the situation safe, under those circumstances, we do not have a requirement to move the regulator from an indoor to an outdoor location.
So what I would like you to submit to the Commission is the very first time that the policy changed to address location of regulators outside the home, and any subsequent changes. And I'd like to make sure that the date is reflected in this. So I'd like to know the very first time this happened, and any subsequent changes up to this January 2023 date. Okay, thank you. Don't leave yet. Okay, so I'd like to get a sense of sort of customer responsibility with respect to the regulators and who owns the regulator. So what, the regulator's coming. There's the main, which is clearly owned by BGE, and then there's the line that goes towards the customer's home. Who owns that line?
The utility owns that line.
Okay. So when the line is connected to the regulator, at what point does the utility's ownership end and the customers begin?
The utility's ownership of the equipment ends at the outlet of the meter. There's a point of service valve on the outlet of the gas meter, and all of the piping after that point is customer-owned equipment.
Okay, and where is the regulator in relationship to the meter?
It's upstream.
Okay, so upstream. So you own the regulator.
That's correct.
Okay. And is there ever an instance where the customer owns the regulator?
No, there's not.
Okay, so that the customer, if the customer has a regulator installed in the home, BGE would still continue to own the regulator.
I guess just as a point of clarification, there are instances where customers get their own regulators and they're installed on the downstream side of the meter. Those would be owned by the customer. They're purchased and installed by the customer and their plumbers. For the regulators upstream of the gas meter, those are in all cases owned by the gas utility.
And how often is it that a customer would opt to own a regulator? Why would a customer want to own a regulator?
It's typically for larger services, commercial services, where they require a large volume of gas, and they opt to receive the line pressure directly from the main and then provide the regulations themselves because of specialized equipment.
But for single-family homes, you own the regulator.
Yes.
You'll always own the regulator.
Yes.
Okay. So for regulators that are outside the home, what is the responsibility of the customer for purposes of maintaining the regulator?
Really just to make sure that it is protected from external forces or from weather events that occur in that immediate location. It's sort of akin to shoveling your sidewalks when it snows.
Okay, and if for some reason they don't, somebody is away for a couple of weeks or someone is infirmed, what could happen to the regulator if the snow is not removed from the outside regulator?
The issue that would occur there is that it would block the vent. The issue actually also occurs if there's an indoor regulator which vents to the outside. In both cases, there's the possibility of snow accumulation, which would cover that vent hole. So the risk there would be that the vent would be covered such that it would prevent the venting of the gas.
Okay, so for an external regulator, is the vent in the same place as the vent for the internal regulator?
Yes, the minimum distance above the ground is 12 inches for both a vent from an internal regulator as well as the vent opening from an external regulator.
Okay, so the vent itself is always in the same place, whether the regulator is outside or inside the home.
The minimum requirement for them are the same, yes.
Well, and mostly I'm trying to understand, I mean, clearly, if a regulator is located inside the home, the customer doesn't have to do anything inside the home to protect the regulator, other than banging into it or, so you don't have the customer doesn't have the same requirements to keep it free of snow because it's inside the home.
They do. The same requirement exists for the outlet of the vent as well. For an internal regulator that has the vent line that must go to the external of the building, that also must be maintained clear of snow.
Okay, so that in either instance, they're going to have to keep snow away from the vent.
That's correct.
Okay, but is there anything else external to the home, if a regulator is outside the home, that the customer would have to do with respect to the regulator, other than keeping the vent clear of snow?
Not particularly, no. The same sort of situations of make sure you don't run into it with something heavy, if you're carrying a sleeper couch up and down the stairs,
Okay.
something like that. The same considerations would be in place for both indoors and outdoors.
Okay, all right, that's all I have.
Commissioner O'Donnell.
Thank you, Mr. Chairman. I wanted to ask the representative of plaintiffs couple things. Of the voluminous statistics you presented on the accidents that you evaluated, you said most of the explosions occurred for installations outside, and I believe. So my question is this: how many of those outside installations actually had safety bollards to protect that installation?
It's a
I don't think I heard that.
No, you didn't. And I believe that data is actually in the broader set. So I think you could actually analyze that. My assumption is that the overwhelming majority did not have safety bollards. So let's be crystal clear. You could alleviate some of the risks that we're talking about by putting those two big metal yellow poles outside of each one of these installations in front of every single person's home, just as they do for commercial locations. Those, of course, are the bollards that BG&E recently sued one of its contractors for failing to install in its filing, noting that over 90% of those bollards had been misapplied, that in some instances the subcontractor had just dug a hole and stuck the bollard inside of it. So there's no guarantee that even if BG&E took it upon itself to require this for every external regulator, that it would prevent this. But I don't have any...
Yeah, I can't. My intention is not to prevent against improper installation or malfeasance on installation. My intention is to say there's kind of been a new standard adopted, is my understanding, that requires these safety bollards to protect these installations for the exact reason that you present all this data for. So you're presenting the case for bollards, which I don't think your clients want, do they?
No, I mean, let me be clear. There's competing considerations. There's Americans with Disability Act considerations for why bollards can't be put in specific locations. The bollards themselves have, apparently in Baltimore City, almost universally failed to be installed properly. But you're right, Commissioner.
I understand, but sir, isn't the acceptable, when feasible, installation practice protect vulnerable installations outdoors from impact by installing safety bollards? Yes or no?
Could you ask that question again, Commissioner?
Sure. Isn't the accepted and adopted procedure, when feasible or when practicable, to install safety bollards to protect these installations from impact when installed outdoors?
That is not my understanding, and I would point to every one of the installations at residences in Baltimore City over the last 2 years. I do not know of residences, and I'll look around, where there are safety bollards at every single house. Certainly there are ones.
I didn't say that. I didn't say that, so please don't put words in.
Okay, apologies.
I said when practicable and when indicated, when they're necessary to protect the installation.
That is not my understanding of the standard or the practice in Baltimore City or the
Stick
region.
them in out of the goodness of our heart because we want to?
No, I think there are instances where bollards have been installed. I don't believe that is the standard practice.
No, I'm not saying I'm saying when it's indicated. When there's no, of course nobody wants them, but sometimes they're indicated to protect the installation.
My understanding is...
Gloss over that when we presented all that data. Which one of these explosions had safety bollards to protect the installation? And I don't know that there were any.
No, Commissioner, I think I have to agree with you. I think you're right that if you put bollards at these locations, some of these vehicular collisions would not have happened. But that is not the current practice, requirement, or to use your language, that is not where they have been indicated by BG&E. I think BG&E testified earlier that they are typically installed in commercial locations like parking lots. So
Well, it is my language because I'm on the bench.
I appreciate that, Commissioner.
And yes, I don't want to quibble with words. I don't want to split hairs with words. I'm a no-nonsense, get-to-the-point kind of guy, right?
Me too.
And you kind of glossed over that bollard installation, which to me is an important safety component.
Perhaps I can answer it this way. There are things that you can do to mitigate risks on both sides. So, for example, there are federal and state regulations. It was in part of the National Transportation Safety Board report that you, for example, install methane detectors for interior regulators. So in instances where they're worried about methane building up, one of the ways to mitigate that risk is to have an automatic safety valve shut off because of a methane detector internally. Those are also not standard practice or indicated. It is true that if the company or a homeowner wanted to, for an external regulator, install a bollard, or for an internal regulator, install a methane detection, that they would reduce the risks. What I can't agree with you on, Commissioner, is that that is the practice, or that all of these instances would have been prevented. Those bollards have been installed apparently.
I didn't suggest that all of them would be prevented. I did not suggest that. Please don't put words in.
I'm not trying to put words in your mouth, Commissioner. What I am saying is that there are zero, let me repeat that, 0 instances of fatalities linked to the kind of concern that BG&E claims necessitates the external installation of these, and there are several, as in dozens of examples of injuries and fatalities related to the external installation. So yes, that number might go from dozens to a smaller number, but I don't believe it's realistic to suggest that bollards would bring it to 0, nor do I think...
I'm being unrealistic today. That's my goal, so okay. I'm trying best I can. Let me ask you a different question.
Yes, sir.
You said that you didn't think that the PSC had primary, your words, primary jurisdiction over these matters. And I just wanted to ask you, from the perspective of the state's administrator of the federal pipeline safety program, who's gonna evaluate that, and who's gonna enforce adherence to that if we don't have primary jurisdiction? I think we have original jurisdiction to enforce and implement that program, which means we're doing what we should be doing here.
Let me be crystal clear. We invite and applaud the Public Service Commission's involvement in this matter. As a legal matter, there are 3 types of jurisdiction with respect to an agency and a state or federal court: exclusive jurisdiction, primary jurisdiction, or concurrent jurisdiction. It was our view, and the Circuit Court for Baltimore City has adopted this view, that the Public Service Commission for the state of Maryland, and other commissions are constituted differently, does not have exclusive jurisdiction over this particular question, in part because it relates to contract matters and it relates to safety matters, where PIMSA also has concurrent jurisdiction, the federal safety agency.
I don't think we have exclusive jurisdiction either.
Correct. And
the court, we have original jurisdiction.
The court also indicated that the Public Service Commission didn't necessarily have primary jurisdiction, which would require it to wait for the Public Service Commission to weigh in. To be clear, we want the Public Service Commission to weigh in, but I couldn't, in good conscience, looking at the statutes of Maryland, claim to the court that we had to wait for the Public Service Commission, in part because of the prior commission's press release, which was cited by the Circuit Court. The view was that the Public Service Commission absolutely has jurisdiction to weigh in on these matters. It does not have exclusive or primary jurisdiction of the variety where a circuit court would have to wait to, for example, interpret the gas service tariff, which is ultimately a contract interpretation question.
Well, that's not what I'm suggesting. Okay. But what I am suggesting is I don't see a situation where, you'd really have to stretch credulity to believe somehow that a circuit court in the state of Maryland, whether it's Baltimore City or anywhere else, or an appellate court for that matter, would want to enforce and take responsibility for enforcement of a program they have nothing to do with, which is the PHMSA pipeline safety implementation. And that's what you're suggesting.
I want to be, on this, I completely agree with you. I do not think the circuit court wants to take over the responsibility of what the Public Service Commission has to do. The narrow matters that are before the circuit court in our litigation are, number one, whether the contract between customers and BG&E allows BG&E to terminate service on the ground that a customer declined new equipment. That narrow question.
I think the case could be made well that the safety considerations here in the implementation of this federal safety program kind of one-ups the contract considerations of contract law. I would suggest it.
Commissioner O'Donnell, I think this is really important to be clear. Every plaintiff agrees. If this was a paramount safety concern, then aesthetics would not trump that. The circuit court's decision would not trump that. If federal PIMSA or the State Public Service Commission or federal regulations or a amended Flower Branch Act required for safety purposes the installation of these regulators in a particular location, we would obviously adhere and acquiesce to that. But where federal and state law has been silent, and in some instances not silent, we don't believe it's appropriate to have BG&E decide unilaterally that every installation has to be external.
Well, I think the NTSB, through its PHMSA program, does think it's a safety issue because they issued a call to action on this matter, and it's going to be interesting to hear our staff tell us what they told us when we found we had a problem here. So thank you for those answers, but I just like to elicit, not trying to be obtuse, would like to elicit some different perspective. Thank you.
I appreciate the questions, Commissioner. Thank you.
Commissioner Barve.
Thank you, Mr. Chairman. A first comment and then a question for you, Mr. Vignoraja. The comment is, I appreciate your love of electrification. I myself believe that we have to move to mandatory electrification, but that's not a decision for this body. That's a decision for the state legislature, where I didn't succeed in accomplishing that 2 years ago, and it's perhaps a decision for local, county, and city governments. It's not a decision that we should be making. It's a big policy decision. So that was my comment. The question is, BG&E has gone out of its way to say that the fatalities involving external regulators were all of the drivers. They imply that none of them, I don't think they said this, but they implied that none of the fatalities were of homeowners and maybe pedestrians. So my question is, number one, do you agree with them on that? Number two, is that data is that information in the data set? And just number three, after you've answered those two questions, I would love to have your reaction to that point of view of the utility.
Thank you, Commissioner Barve, for that question. So the data set includes it in some instances. It does not. It has fatalities, injuries, hospitalizations. It does not specify whether it was the motorist or not as a data question, but in the anecdotal narratives corresponding to each incident, it sometimes does specify that it was the motorist who was injured or who was killed, that it was the occupant of the home who was injured.
Is that in the spreadsheet?
It is.
Okay.
It is in the very last column. There is a narrative account. And again, I know that in Exhibit F, BG&E inserted sort of its headline version. We have not done any of that. This is just the raw data from PIMSA, and that does incorporate it. The critical thing that I had alluded to was that their working assumption, because there isn't like a clear causal link. In some instances, there were lawsuits that addressed the question of who was to blame, et cetera, but there wasn't in every narrative a causal link of the person died because of the fire or because of excessive speed. What we can point to is there are a number of instances where the narrative references excessive speed, but in all of the fatalities, there is data saying that there was a fire and or an explosion, and in several of them, the narrative description suggests that the person died because the car or the home exploded. Beyond that, we're just focusing on fatalities and injuries. I think the Public Service Commission has to take account of the question of risk. You'll note, if I can, I don't know if I can put this up for just a minute. It was interesting that if you look at the outside and inside meter fatalities, I'm just gonna, for the ones, let's do outside first. It was interesting that when you look at the outside meters, the installation year is, and you'll see my point in a minute, relatively recent. 2006, 2010, 2000, 2017, little older one there, 2012, etc. If you look at the ones that were the internal regulator fatalities, these were all quite old, 59, 96, and 59. So it does appear that more outdoor installations are being installed as we move forward. And as a result, the number of incidents appears to be rising. In all of this time, we only have 3 instances where there's a fatality related to an internal.
Okay, but what I was trying to get at was, I take it that you do not agree with, agree's not the right word, that you, yeah, agree. You don't feel that the BGE assertion that this is, you know, the fatalities are car drivers, that doesn't really carry any weight with you.
No, it doesn't, and for a very specific reason. I'll try to answer your question more succinctly. It's a fair observation that I was meandering. Excessive speed was a factor in the accident. People drive fast. People drive fast in Baltimore. We don't have the best drivers. That is going to cause these incidents. But in each of those where there was a fatality, there was also a fire or an explosion. So excessive speed was one factor in the accident. It was not the factor that caused the injury or the fatality.
Okay, thank you, Mr. Chair.
Commissioner Richard.
No questions. I think it was a very thorough discussion, and I think I'll just stop there. Thank you.
All right, let me ask one question. The very first ask you made of us was that we allow the homeowner to make the choice about whether or not the regulator goes in. And in the circumstances where you have a single detached house, you know, that's one sort of situation. But in the city of Baltimore, where you have row homes, don't you run into a situation where the decision of one homeowner actually affects, you know, at least 2 other homeowners and maybe some others?
Chairman Hoover, I think that is true, and I think it goes in both directions. If you accept, as we submit the data indicates, that an external regulator is more dangerous, then when a person chooses to get that in an informed way, they are presenting a risk not just to their own home, but to the homes nearby as well. So I do think that there is a threshold, and this is why I said I would not make this argument about customer choice if there was a clear safety answer. In both instances, there are risks to the homeowner and to the neighbors, as with many choices that residents make about whether to have an awning, whether to, you know, clean off their sidewalk, whether to attach a railing. Each of those comes with risk factors, safety factors for their neighbors as well. But where we, as here, the data suggests that it is at least as safe, if not dramatically more unsafe to put it outside, we believe the homeowners should do it. We've encountered them, BGE's not wrong about this. We have found a couple of homeowners that said, God, I don't want that thing in my house. I'm not sure if I understand it, but I don't want that thing in my house. In that instance, I don't think it's appropriate to demand that they put it inside because they may have good reasons why they worry about it. There are people that worry about the methane emissions and things like that. I mean, there may be instances where for another separate reason they want to put it, which is why we believe that the paradigm of customer choice best addresses those competing considerations.
Okay. Any other?
Actually, so I have a question for BGE. We were speaking about bollards earlier, and I just wanted to get a sense of what the cost is if someone can speak to that for per installation. I mean, are we talking about, a lot, little? I mean, if that were to be part of the installation for single-family homes that have installations on an alley or.
Yeah, thank you, Commissioner. Kevin Nelson
Okay.
for BG. We could get the data to tell you exactly as order of magnitude, it's hundreds of dollars, not thousands.
Okay.
Maybe 300, 400. If we're also doing it while installing a service or doing some other activity, that reduces the cost, right? Because many of the activities, digging the hole, for example, is a sunk cost in the work we're already performing.
Okay, and then if you're putting together that data, could you also give us a sense of the difference in costs between an internal versus an external installation?
Yeah, I can speak to that right now.
Okay.
It's not precise because in literal terms, the cost to put a regulator, let's say it was a new installation, the cost to put it on the inside of the wall versus the outside of the wall is zero. The hole still has to be drilled through the wall for either a vent line or for the service entrance, and all of the piping still has to be run. Where it can change the cost profile on an existing service is if the existing service has to be moved, put in a different alignment to the facility in order for the regulator to be placed outside. Imagine, if you would, the existing pipe comes underneath the stairs that enter the home. Obviously, we cannot set a piece of equipment there, so we would have to put the service now maybe to the side of those
Okay, so
stairs.
that would increase the cost
Yes.
to do an external location as opposed to an internal. And
Generally speaking, that's correct.
okay, and are there situations
Oops.
where,
I apologize.
yeah,
Utility company turning off.
right,
the
we
lights.
need mood lighting here. Are there situations where there is an increase in costs to put it internally versus externally? So are there situations where you might have to move the line in order to
To
allow
leave it
for the
inside?
yeah.
Yes, the inverse can be true.
Okay.
There are probably 100 permutations. Commonly we'll see if we can't find a place to safely vent a regulator, sometimes in extreme cases we'll actually have to run the vent line maybe to the side or the back of the house in an unfinished space like a basement. That can add substantial costs versus certain alternatives. But I mean, we do these so as to not disrupt things like wheelchair ramps and stairs to get into buildings. But the cases are very diverse.
Okay, but is it safe to assume that sort of on average, if you kind of, factor in both situations where you have to move it for internal and external, that there's not a substantial difference in cost between putting it outside versus putting it inside?
I would say that and we've filed or stated comments just the fact there is a marginal increase as an average in setting the regulator outside when retrofitting an existing service. As a percentage of the cost of our operations in this space, we're talking single digits. I think I've estimated it around $5 million a year versus the maybe 10,000 services that would be subject to this policy in a given calendar year.
Okay, thank you.
Okay, so we'll turn to the panel and we'll start at my left. And if you just state your name and make any statement you want to make, or if you don't want to make a statement, that's fine too.
Sure.
So.
My name is Kate Sims. I'm a lifelong resident of Fells Point and a BG&E customer. My home, along with the majority of homes in Baltimore City, does not have or currently need a gas regulator. This operation pipeline in question is not merely a regulator relocation program, but this is brand-new equipment being forced on customers. While there's no doubt the current low-pressure gas infrastructure throughout the city is in need of some TLC, but the bigger picture question should be, why did BG&E make the choice not to repair the current safer low-pressure infrastructure, but instead chose to replace the entire infrastructure with a new elevated pressure system, which will require the addition of regulators? Also, as the state of Maryland is committed to moving away from fossil fuels by 2045, why is BG&E investing $1 million a day on gas infrastructure? While BG&E continues to claim this new infrastructure is for safer, more reliable service, BG&E has yet to produce justification that demonstrates the current low-pressure system is either unsafe or reliable to customers. This raises the question of who will ultimately benefit from this new system. Will it be the citizens of Baltimore who will benefit, or will the benefits go solely to BG&E's profits? Had BG&E chosen to repair the current infrastructure, those repair costs would have been an expense to BG&E. However, choosing to make this a capital investment, every penny spent on this project will be passed along to consumers through BG&E's current monthly stride surcharge and next through rate increases. In addition to BG&E's ability to recoup all the costs associated with this program, making the choice to install regulators on the exterior of homes would shift the liability for maintenance and outside force damages away from BG&E and onto homeowners. Insurance companies are now issuing tips on installation burdens to homeowners who have additional burden to homeowners who have exterior regulators, including keeping it free from snow, ice, and debris, as well as recommendations that it is supposed to be away from corrosion, which the corrosion is added when they're exterior. Considering Maryland's Climate Now Solutions Act, there should be more focus on electrification, not investing in large-scale new gas infrastructure. To prioritize this goal, BG&E could be collaboratively working with customers in a reasonable timeline towards electrification, instead of forcing new gas infrastructure upon customers with little to no warning. Who has considered the effects of the irreparable harm caused to homes not only during installation, but also when these regulators become stranded assets as fossil fuels are phased out within the next 22 years? The installation of this new gas infrastructure, including the regulators, further locks Baltimore into gas infrastructure that reinforces our unsustainable dependence on fossil fuels, reduces BG&E maintenance costs and liability, contributes to climate change, and hurts public health. Throughout this project, BG&E has demonstrated a total disregard for their customers in Baltimore. Customers have dealt with vague, inaccurate information, work performed on 1 or 2 blocks per neighborhood at a time, which has strategically covered a broader area while simultaneously reducing project visibility, bullying tactics, inequitable and destructive work, and illegal service shutoffs. Today, I am asking the Public Service Commission to focus on what is truly best for the public, not just BG&E, and to complete a full investigation into BG&E's proposed plan, the safety implications of it, as well as the long-term financial and climate impacts. Thank you.
Any questions? All right. Thank you, Ms. Sims. Next.
Good afternoon. I'm Liz Bement, and I am a resident of Upper Fells Point, and I would like to start off by reading this statement. The bill, as introduced, produces several challenges and concerns that should be addressed to ensure a thoughtful and feasible approach to this effort. BGE has a unique situation in that its service territory has several densely populated areas, such as Baltimore City, that do not often provide for appropriate open outdoor space to allow for outside meter or regulator installations. While BGE prioritizes safety of its system from a comprehensive lens, there is a need to consider the impact of prioritizing one safety program while potentially compromising the effectiveness of others. BGE, they wrote this in February of 2020. This was their position statement on the Flower Branch Act bill. Then, later on, they do a complete turnaround and use the Flower Branch Act as the reason to switch to safer exterior regulators, even while they were still installing the interior ones through the start of 2022 in Bolton Hill, as Mr. Vignaraja had stated. This is complete hypocrisy on the part of BGE. So what's really behind BGE's turnaround since they wrote this statement? Our homes certainly haven't gained any additional outdoor space for gas regulators since then. In fact, many of our houses are located directly on narrow sidewalks that are public rights-of-way, and lots of accidents involving cars and even buses occur on those same narrow sidewalks when they crash into homes located there. According to a 2022 audit from Lloyd's of London, U.S. drivers ram their cars into buildings 100 times every single day, 40 more daily collisions than previously thought. I have some first-hand knowledge about this, since cars have crashed into the corner tavern across the street from my home 8 times in just 9 years. This is it. Dangerous Baltimore intersection dubbed Crash Corner gets makeover. I live adjacent to Crash Corner. People also hit regulators with bikes or scooters, not to mention the tampering that can take place when regulators sit exposed on public sidewalks, just tempting vandals to do some damage. So I request the BGE point to what data justified their complete change in position between 2020 and 2022, and I want BGE to answer where the liability lies for explosions caused by car crashes when the regulators are sitting exposed to busy city sidewalks. Is it on the motorist? Is it on the homeowner? I don't think it's on BGE. And what about tampering, freezing, or other damage to the regulator? By installing these outside on the right-of-way, BGE has shifted liability away from themselves and onto the homeowners, who are now tasked with monitoring them for anything that may cause damage. And who exactly will take care of this dangerous regulator that's sitting exposed when so many properties in my neighborhood are vacant at any given time for any number of reasons? Some are Airbnbs, or they're between renters, or in between owners, or they're being renovated, or they're waiting for city permits. But that won't be BGE's worry now that they've strategically shifted liability onto the homeowner. There is a massive assumption by the general public that whatever equipment BGE is installing on their homes is safe, and that's just not true. The residents of Baltimore City are the collateral damage in BGE's quest for shareholder profitability placed above their required mission as a public utility to provide equitable and safe service to the citizens of Baltimore.
Thank you. Ms. Bennett, next.
Good afternoon. My name is Magdalena Fitzsimmons. I'm currently the board president of the Washington Hill Community Association and have resided in Baltimore City for the past 25 years. Before I read the statement I prepared, I'd like to go back to what one of the commissioners, and I'm sorry I don't remember who, said about communicating with the public at the beginning of this hearing. To that end, I'd like to read a quote from the AGA submission to the PSC. I'm quoting from attachment 3, page 24. The AGA states, "It is a leading practice for a gas utility to engage and secure the support of cities, towns, and counties in replacing utilization pressure systems. Streets and roads, along with other underground infrastructure, are greatly impacted by these upgrades. Gas utility operators and the communities that they serve must work closely to develop plans that are workable for all stakeholders. Placement of pressure regulating stations and relief valves above ground and or in public right-of-way may need support by local communities to mitigate the risk of overpressurization." I want to emphasize that this did not happen in Baltimore City. It's as if BGE appeared under the cloak of night and started construction. There may have been some communication, but I'm here to say, as one of the original people that got the communities together, is that we've had people from communities all over Baltimore come to us saying, we did not understand what was going to happen. We did not understand about the safety risks of the outdoor placement of regulators on our homes. Our response was, we started to do the research. We have been researching since the beginning of February when this first happened. There was a grassroots coalition of the presidents of many of the associations, and we got ourselves together and we said, what's happening here? What is happening? And we started to do the research. We know more about gas regulators than just about anybody else in this room. We based our advice and our communications with people around Baltimore on research. We did not decide that one placement was safer than the other. We researched the safety issues. We would never suggest, as lay people, as we're called, we would never suggest that something was not safe, that the interior installation of gas regulators would be safer or as safe if we did not do the research. We would never suggest that to any one of our community members. So I wanted to just start with that before I read my statement. BGE consistently touts safety as their main argument for the outdoor installation of gas regulators. They have employed this strategy to convince city and state officials to relinquish authority over Baltimore's historic assets. I would like to begin by dispelling some of the myths surrounding that argument. To begin with, gas pressure regulators, whether placed indoors or outdoors, perform the same function. They reduce higher gas pressure from gas main lines so that the pressure is appropriate for indoor use. Both types of installations vent to the outside. I want to emphasize that. Both installations vent to the outside. And emergency outdoor cutoffs are available. Currently, all indoor gas regulators are vented to the outside of buildings using a far less intrusive PEC vent. That's the company term. They use snorkel vent, PEC vent, whatever. But there are pictures of them all over. These have been installed throughout the city, not just Bolton Hill. As we've mentioned, I've seen them installed in Butchers Hill, Patterson Park, and so on. One of the things that confuses us is that we don't understand BGE's idea of placement of regulators, period. I live on East Baltimore Street. The 1700 block has outdoor regulators. That's what triggered me into forming helping to form this coalition. The next block up, no regulators. The block beyond that, we have the PEG vents. So what's happening? Why does one block get outdoor regulators, the next block has none, and the block after that has the PEG vents? What is that? That confuses us. But we've not got an answer to that and many other questions that we have asked BGE, and so has media. However, placing exterior installations in a densely populated urban environment presents significant safety concerns by their possible exposure to vandalism, extremes in temperature, corrosion, and vehicular collisions. The Pipeline and Hazardous Materials Safety Administration, the federal agency that is responsible for safety issues related to our gas pipelines, has issued the federal pipeline safety regulations requiring that each meter and service regulator, whether installed inside or outside of a building, be located in a readily accessible location and be protected from corrosion and other damage, including vehicular damage. Gas regulators placed on the outside of buildings in densely populated urban areas are not only subject to these dangerous conditions, but are also exposed to vandalism in the form of tampering with shut-off valves, which any curious individual can research on various YouTube videos that inform the public how to shut gas flow off in less than a minute. So I suggest that we all take a look on YouTube, and you can find many videos that show how easy it is to tamper with these outdoor installations. Incidentally, those concerns are what BGE pointed to 3 years ago when they lobbied the Maryland General Assembly to limit where exterior regulators would be required under the Flower Branch Act, specifically citing how they would be inappropriate for Baltimore City. Even the Flower Branch Act includes concerns with outdoor installations. To quote, and I'm sure you've heard this before today, the Act requires that a gas service regulator be installed away from roads, driveways, parking areas, or other locations exposed to vehicular traffic or other external forces that may damage the gas service regulator. BGE continues to attempt to convince the public that the outdoor placement of gas regulators is based on industry best practice, a term that does not provide clear and unequivocal data to support that claim. Indeed, when questioned by numerous community groups and the media, BGE has never supplied this data. Clearly, BGE enjoys cherry-picking which safety recommendations to follow or not to follow, based on those that will further their relentless quest to line the pockets of their investors. It is well past time for city and state officials to protect the city of Baltimore and its citizens from the predatory practices of a company that cares more for its investors at Exelon than the customers it is supposed to serve. Thank you.
Thank you, Ms. Fitzsimmons. Next.
Hi, good afternoon. My name is Claudia Tolles, and I am also part of the original coalition that organized around this issue. And I'd like to be very clear that we organized because we didn't get answers. The quote-unquote answers that we did receive at community associations and on the street talking to contractors and the many representatives of BG&E who would show up were a mix of what you guys have yourself called word salads, and just misinformation about the mandatory aspect of these regulators and these installations. Oftentimes BGE used, not often I should say, I was arrested because of it, used their power to turn off people's gas to get consent. That's not real consent. And that is one of the reasons that we're here, is because they bullied their way, not only through Fells Point, not only on Bond Street, but in West Baltimore, in East Baltimore, and all over. And they continue to do it as recently as 2 or 3 days ago? Yesterday, in Greektown and in Bayview. They haven't changed their tactics. And they have not.
What did they do?
So they're not getting written consent. They're not getting written and informed consent. They're also telling people that they are that these are mandated, that they have to do it, and that they are being unsafe if they don't acquiesce to it. So they, at that time, I believe, did not threaten to shut off the gas, but they did use bullying tactics. Do you have the...
They told the one woman she had to have it. Yes. And
Yeah. So again, using the misunderstanding and their position as the quote-unquote authority to give information that's not true, that's not reflective of our regulations and our laws. And this has consistently happened. Again, it's why we're here. We stood side by side with many neighbors in Fells Point and then in Federal Hill, which resulted in the arrest of Sandy, Maggie, and myself for asking that BG&E not be allowed to behave unlawfully. Thankfully, the judge agreed and restored service to those who had their service cut off.
Can you sort of describe what happened to you and what led to the arrest? Because I think it would be useful for us to hear.
The charges, and I have my counsel here, but the charges have been dropped, although not in the way that we would have expected. We learned of gas shutoffs in Federal Hill. At that point, that was June 21st when it happened. I know because I had an event the next day that I missed out because I was in the slammer. On June 21st, 4 homes on Warren Avenue had their gas shut off because they refused to allow the installation of exterior installation of regulators. We knew this because we had now been able to leverage media coverage and people had our names, and so we were included in these conversations in Federal Hill. There's a coalition of community organizers, some community associations, but many community organizers. So when we learned about that, the next day, June 22nd, on Thursday, we showed up, and a dozen or so of us who were able to create, more flexibility in our schedules, because this has been very time-consuming. I think we've amassed over 1,000 community hours of service. I just want to put that out there for the record. That's what this has been. This community advocacy has been a service to our communities and to Baltimore City about informing the public, something that BG&E has wanted to keep quiet as their operations on certain blocks and then skipping certain areas. They never allowed for organizing because people were just kind of, oh, what just happened? Why did I need this? Oh, I have to have it. it, and then they would move on to another area of Baltimore City. Unfortunately, on June 22nd, when we showed up at 7 a.m., there was a slew of BG&E representatives, I think public relations, and panel, feel free to include anything details that I might be missing. We were there, we had conversations with BG&E representatives that resulted in more word salads and basically telling us that there was no option, that these had to be installed, otherwise gas would be shut off again on the 22nd as it had been on the 21st. We had different politicians and folks from the mayor's office come, and then we had a platoon of police officers that was deployed on behalf of BG&E to what we feel was intimidate the women who were there and the protesters who were there, and deter us from continuing to ask that BG&E not be allowed to turn off people's gas for failure to accept this new equipment. And I want to help you understand a timeline. In January, BG&E was in Fells Point, which is where I live. I've lived in Baltimore City for 24 years. I'm on the board of the Fells Point Resident Association and have been a longtime community advocate. So when we saw this bullying and bulldozing of our street on Bond Street, and I say our street, I don't live there on Bond Street, but it's my neighbors. I had clients, I'm a real estate agent, who were asking me questions about this, and we all started to become experts and research the information and do the work because we wouldn't get answers from BG&E. When we finally understood, after our research, after doing the work, that the behavior and that the policies, this quote-unquote internal policy, wasn't actually a state mandate or a federal mandate, we started becoming a little bit more loud and a little bit more assertive in our stance of not allowing BG&E to threaten people with gas shutoff, because they did that in Fells Point. So on June 22nd, they had a permit, supposedly, to be working on this in this area, and we stood there talking to representatives and talking to the police and the mayor's office, all of which unfortunately sided with BG&E, saying that we had to allow them to do what they were going to do, which their sole purpose was to turn off the gas, to castigate the folks who were standing their ground, saying that they didn't believe that these external regulators were appropriate for their homes. About 4:30, after being there at 7 a.m., about 4:30, Maggie, Sandy, and myself were arrested after Maggie's right here. Sandy, can you stand up? She's over there.
In the back.
You'll be hearing from her later. We were arrested and we were detained. I was released 20 hours after we were arrested, so the next day, all because we were asking those who represent us and those who should be protecting us, the police, to not allow BG&E to continue to bully our neighborhoods and our communities and our neighbors. That is the kind of behavior they continue to push forward, with maybe different words and with changing different tones, but they are still bullying these installations and making them happen through threat of safety. You were saying, Commissioner, and I'm sorry, I don't remember your name, but you were talking about not alarming the public. That's what they've done. They have literally walked into our neighborhoods, into our community association meetings, and said, this is dangerous. And when asked, as many of you have asked, why aren't you relocating the ones in Bolton Hill and in other places that are interior? No answers, which only continued to fuel our frustration and our desire for advocacy and clarity and transparency, which is, again, why we're here, not working, and trying to get the information to you, because what they're saying about communicating with neighborhoods and neighbors is not true. I made a couple of notes that I'll reference. I think BG&E mentioned a lot about how many times and how many people were at meetings and how many meetings they've had. It doesn't matter the quantity of staff or the quantity of postcards or door hangers. It's the quality of that communication, the clarity of that communication, and more importantly, the truthfulness of that communication, which we as residents of Baltimore City and the state of Maryland deserve. We deserve a company that is going to be clear. Safer doesn't mean the other one's unsafe. And that is the narrative they continue to push. And I have no reason to believe that they're going to be changing that. And thank goodness for this TRO, and thank goodness for the arrest, and thank goodness for this advocacy, because so many people didn't know they had an option, and they didn't know that they had the opportunity to say, no, I have some questions, and you have the obligation of answering them.
Commission, if I can just add very briefly, I do represent all three of the individuals that were arrested, and I want to just clarify for the record a couple of things. All three individuals were part of a group that were exercising their protected First Amendment rights concerning the unlawful discontinuation of gas service at three specific homes. This is a matter for a court. These charges have been dropped, but I should note that we pointed out to BG&E on that day on body camera that the permit they had was for the 200 block of Warren Avenue, not for the 400 block of Warren Avenue. We pointed out that they had gotten an ATP, an authorization to proceed, from the Commission for Historical Architecture and Preservation for about 100 or so addresses in Federal Hill, but none of those addresses were the Warren Avenue addresses where they were terminating service. We pointed out to them that under the gas service tariff, as well as under Maryland regulations, they were not permitted to turn off gas service simply for declining new equipment. And we pointed out that under COMAR, there is a 14-day requirement of notice that be provided before you turn off gas service. And the door hangers that had appeared the day before for the 4 homes that had their service terminated on June 21st, new door hangers that appeared on 3 residences on June 22nd, which was, we believe, the first notice that those homeowners had given. The 14-day protocol had not been satisfied. The COMAR regulations had not been satisfied. We don't think they had a valid permit for the 400 block of Warren Avenue, nor did they have CHAP authorization. And so in these residents' view, they were entitled to be on the streets of Warren Avenue where several of them lived, and BG&E did not have lawful authorization to dig into the ground or do the installations. Because they refused to move from public streets exercising their First Amendment rights, they solicited the mayor's office as well as the police department, and these 3 individuals were arrested. I don't want the commission or the public to get the impression that they were causing a disturbance or hanging on to equipment. They were literally standing on a street where BG&E, in our view, and the charges have since been dropped since we provided the prosecutor's office with the lack of authorization from CHAP, the permit that only indicated 200 block and not 400 block, as well as the 14-day notice requirement, as well as now the court's ruling that the gas service tariff does not allow them to terminate service simply for declining new equipment. It was for that reason that they were there and present. They were not causing a disturbance. They were, frankly, exercising their lawful First Amendment rights. And as I said at the time, and as I will say it now, what I believe BG&E was trying to accomplish, which is the same thing they tried to accomplish with Miss Adrienne Smith on October 27th of 2021, is to show the community that they had no choice but to agree, because if they didn't agree, they would have their gas service turned off, and if they went one step further and really pushed them to have CHAP authorization and a permit, that they would be arrested. They were celebrating that. The cameras were there and rolling when it all happened. We believe respectfully that BG&E wanted to get the message out that these regulators were going to be installed. They terminated service while we were in a hearing. The judge ordered them to restore the service of Stephen Toppings, the leading named plaintiff. They cut off his service while we were in court asking them not to. This was conduct that was a step above. I didn't think it was necessary for the original presentation, but since you've asked about it, I think it's important to clear that these people were not rabble-rousers. They were, community advocates trying to stop literally their neighbors, elderly neighbors' gas service from being terminated unlawfully.
Not to mention that one of the neighbors was away, and they were informed, BG&E was informed by us that they were away on vacation and had pets that would need the service, some sort of heating and turtles. I mean, I didn't know the details, but we knew that they weren't there and that they wouldn't be back to the property. I mean, in short, and I know, Commissioner, again, I'm terrible with names, but you mentioned and asked for the...
And I know I'm not.
Yeah.
I'm traveling.
I'm not sure I could see it at this point.
Yeah, no, I'm traveling incognito, so...
But you asked about the waiver process, something that was very near and dear to our questions in Fells Point at the Fells Point Community Associations, because we read everything and said, "Oh, look, there's talks about exceptions for historic neighborhoods." It's not that we wanted it to be exclusively about historic neighborhoods, but we thought that there was an in because it lists there. And they told us point blank, as they were ready to shut off gas on the 800 block of Bond Street to two customers. One was my client, the other one, Sarah, who wrote a very impressive letter to BGE asking about liability and asking the questions about how to maintain and what would happen if they installed it. They installed her exterior gas regulator in such a way that she now has no use of her cellar door. So, because if she were to use her cellar door, which is a very, I don't know how many of you have one, but it is a very heavy metal door, it would lay on the regulator. So, that, in our view, we thought we had a home run. We said, look, we're historic, and functionally, if you put it anywhere near this, which is the facade, because it's 11 feet wide, she won't be able to use her cellar door. That's not enough for a waiver. And the contractor told me, as an aside, we're not issuing waivers unless it's absolutely technically we're not able to install it. And I was like, how many instances of that have you had? None. So the waiver process doesn't exist for any of the caveats, that are mentioned in the NTSB and PHMSA driveways. They're installing them near driveways, near parking areas. I mean, Fells Point is notorious for its pedestrian festival vehicular traffic, and we could get nowhere. I'll end because so many have done such a great job in communicating our frustrations. Is customer acquiescence received only alongside the threat of service shutoff is not consent, it's coercion. And that is from Kate. That is exactly what they have been doing. Their quote-unquote consent has been just received basically by putting a gun to customers' head, saying that they will not have gas. Or, better yet, saying you can electrify. Who has $25,000 laying around? Not many people to electrify your furnaces and change your appliances and all that comes in with regards to electrifying. Do I want to? Sure, but I don't have the money, and neither do most of the residents that they come to saying that that's your option. No gas if you don't have an external regulator installed. So with that, thank you.
Thank you, Ms. Tolles. And finally,
Yes. My name is Saretha Staten, and I'm the Vice President of the Milton and Moffett Association. We're located in East Baltimore. These gas regulators were installed throughout the entire Milton Moffett neighborhoods. We were never given an opportunity, or we didn't see any BG&E people coming telling us that they were actually going to put these gas regulators in our neighborhoods. They just showed up, put signs on the trees, no parking in the block, / gas. So the next day they came, bulldozers, heavy equipment, everything, and just started tearing up the street. So when we asked them, wait a minute, what are you all doing? What's happening here? And we were told by the contractors that they were installing gas regulators. So I said, well, wait a minute, we don't know anything about these gas regulators. Oh yeah, this was an agreement between Baltimore City and BG&E, and we're going to install them. These will be installed. When the residents pushed back on the installment of the regulators, this is when they started to be, and you have to remember that these people live in their house. I've been in my house 43 years. These people have been in these homes for 30 years, 40 years, and even 60 years. We have some residents that were 60 years. So these were our elderly people. This was during the winter. They, because of the pushback, they told them, if you don't agree to get these regulators, then we are going to shut off your gas. This was in the dead winter time, when most of these regulators were starting to be installed in our neighborhoods. During the installation, the inside and outside of people's homes were damaged. And when I say damaged, they were damaged. They damaged their property. And then they told us that it was your responsibility to fix the damage that was done by the contractors in BGE. These were elderly people, and also my house was damaged. These houses are 100 years old. We have marble facades and steps. Baltimore City is known for their marble and their facades. They came in and put a hole, a gaping hole, into the marble facade when they went to put the gas regulators in, I guess the pipes or whatever, and the holes are like this, and when I complained, it was like, oh yeah, we can fix it. We're going to just put a metal plate over top of it. That's not fixing it. I didn't buy that property for you to come and damage my property. So they came in bullying our elderly, it was they targeted the elderly. The main people were the elderly people that were being targeted, telling them if you didn't get these gas regulators put in, that they were going to shut off your gas.
Did they fix your facade?
No, ma'am. They put a metal plate over my facade.
Could you take a picture of that
Yes,
and get that to us? Thank you.
We'll submit.
Yeah, you submit that, yeah.
We'll submit them. Yeah, and they damaged a lot of the people, property, elderly people, and told them that they would have to fix them when they went in. Some of the people, one of the presidents of the community organization, she actually had a guy to come out to fix it. These are people that's on fixed income. And they charged the $350 to fix it, and I went there to look. I was like, that's not your problem. BG&E should have fixed this. If they damaged the property, they should at least fix your property. They left our streets in disrepair. It looked like a bomb had just dropped in the street, and they did this for months. It's like they just came in and just bulldozed whatever they wanted to do, and it's like you don't have any say in what they actually do. These are our properties. We bought these homes. We own these homes, and we should be able to have an opportunity to say whether or not we wanted these gas regulators inside of the house or outside of the house. One instance, we do have our streets. The streets in East Baltimore are unique. One of the streets is East Madison Street. So that street is a quarter where traffic comes into the city and go downtown. That's the only way that you can come in through Madison Street, Orleans Street, or Fayette Street. Those are the main quarters. East Madison Street is one of the quarters where we are really concerned. The speed limit is 25 miles an hour. These people come down there 50 miles an hour because from one corner to the next block, there's no street light in between. So they're racing to get to the next street light to get to where they need to be. And the streets are narrow. The street is wide, but the sidewalks are narrow. We have a lot of unwanted foot traffic. It's a lot of vandalism there, especially at night. So these regulators are out in clear view. I mean, when I say clear view, they are out in clear view. And one of the contractors had the nerve to tell us, well, you all have these flower pots, just put the flower pots in front of them. That's not going to deter anybody that wants to tamper with these regulators. And this is what our concern is. We have had, last week, we had an accident where the man came down East Madison Street, fell asleep, hit the neighbor's car, knocked the car from in one block in the 2400 block, and the car ended up in the 2300 block, just missing that gas regulator that person had that was there. We also had an accident that a car hit 3 marble steps, missing 3 gas regulators. It's 3 gas regulators there. he hit all three of the properties. And if he had hit one of those gas regulators, I'm quite sure that would have exploded. So these are the kind of things that we are concerned about. Why would you put a gas regulators on a main corridor where we have so many accidents? And nobody never came to us. We have meetings. You know, we're the community organization. We have meetings every third Wednesday of the month. But nobody from BGE ever contacted us to let us know that this was going to be occurring. Unlike Bolton Hill, you know, their streets are beautiful. You know, they're still coming in and putting in regulators. My street has been dug up 6 times already. Just in a couple of weeks, they put a regulator next door to me. So this is our concern, is that we didn't have a choice. We didn't have a voice in doing this. And now that we know that this is what they were doing, not only to us, but to all the people throughout this city, that's not right. It's not right, and it's not fair to the people to have some kind of voice. So we're just asking you all, you know, I mean, if you want to come out and look to see what we were actually talking about. Sometimes when you try to explain things to people, they don't really get it. But, you know, if you're walking down the street one way and the person has to move over on the side in order for you to get past so they can get past, that street is too narrow. It is definitely too narrow. We have kids, we have teenagers, and like I said, we have unwanted traffic. I mean, you know what I'm talking about when I say unwanted traffic, people that don't live in the neighborhood. You know, and we also have a lot of vandalism in the neighborhood. So it's like, what did they do? Did they take in consideration what the neighbors wanted? How, you know, we live there. We live in constant fear. And this is what I always say. When you live in Baltimore City, you're always in some kind of fear of something happening. And one of the things that's going to happen is somebody is going to come down East Madison Street, hit one of those regulators or those regulators, going to blow up the whole neighborhood, and it's going to be devastating for us. But what is BG&E going to do for us?
Okay.
Thank you.
Thank you very much. Actually, Commissioner Richard has a question.
Yeah, Mr. Vigneraj, could you just quickly help me understand the TRO? I was a little surprised just to hear from Ms. Toll and others that BGE is still engaged right now with Baltimore citizens on relocation issues. So, again, I'm quite surprised to hear that. I thought things had come to a stop so we could.
Yeah, I want to be clear, and we find it remarkable as well. The TRO was very precise. The TRO issued 3 specific mandates to BG&E. Number 1, they were forbidden from installing regulators without written consent from the homeowner. Number 2, they were forbidden from threatening gas service terminations as a way of obtaining consent. And number 3, they were ordered to restore gas service to the homes that they had just shut off by threatening because of the declination of the new equipment. So,
And this is all of Baltimore City.
this is it is actually region wide. Because it is a putative.
This is BGE's service territory.
Correct.
Okay.
The judge actually asked us whether we wanted the putative class action at that time to apply just to the 14 named plaintiffs and the 120 so additional plaintiffs, or to all similarly situated individuals. And because I had just been engaged, I'm doing this pro bono, but just for about a week, we said, Your Honor, this is the 120 people we found in the last week. We would like it to apply to everyone, and the judge agreed and had it apply across the board.
Okay, so I think I understand the TRO.
How is it still happening?
Yes, so is BGE in violation of the TRO, given what Ms. Toll said about what just happened this week?
The short answer is we believe yes, but the devil is in the details. What they will claim is that they are getting written consent from people, for example, in Greektown. And we've seen the waiver where people have signed. What we learn after the fact from talking to the residents, some of them complaining to many of the people on the panel in advance, was we were told we had to get it. Had to get it is technically in compliance.
Okay, so we have BG&E here Is there somebody that can respond to this?
And if I can just say one thing before they do, because they should hear this specifically, we have already started to document dozens of examples of three things. One, individuals who were told they had no choice, they had to get it. Two, where renters were being asked
Since the TRO?
since the TRO.
Yes.
This is literally in the last 7 weeks. Two instances where renters were asked to give permission. We have literally forms where renters have signed authorizing permission on behalf of a homeowner. We have instances where they contacted the homeowner as well, but the second one would obviously be a violation. And three instances where homeowners were told we had no idea what they were doing, we didn't understand, we thought we had no choice. I want to be clear. They have not threatened what they did in Federal Hill. They haven't said, we're going to turn off your gas service tomorrow if you don't do it. What they've said is, in order to have gas service in the future, you need to have this, which is technically right, because the high pressure gas, but they're taking advantage, in our view, of what we thought was the spirit of the TRO to say, don't make people think they've got to get this unless they really want it, and don't get them to sign with this misinformation. The individual stories are jarring. We thought that was more an appropriate matter for the court, and we'll bring that up at the appropriate
Okay,
time.
thank you.
And
Again, I was very surprised to hear this because I thought
week-
the TRO covered, prohibition on these types of
To
activities.
that
so,
point, Commissioner, the week that the TRO was issued on Monday, right? We were in Greektown answering questions and talking to neighbors, and we heard a neighbor drive by. I was standing there. She was driving by. She said, "You're not supposed to be here. There's a judgment in place," using different words. And the contractor responded to that driver saying it only applies to those people who filed. So it's a lot of misinformation that's being continued.
Okay,
And
so-
Mr. Victor, you are going to take this back to the judge then?
We will, Your Honor.
Okay, very good.
Okay, so
Thank you.
somebody from BGE can respond.
Actually, Mr. Herson, if you want to attempt to address this, I don't want to put you completely on the spot, but
I think we're there. Look, I have copies of the TRO. I can pass them out to the commissioners. I have copies of the consent form that we're passing out to customers. We understand what the TRO allows us to do, and more importantly, doesn't allow us to do. We are not forcing this on any homeowner. We are providing this consent form and saying, if you're going to get an external regulator, you need to sign this form. And again, I'm happy to provide each of the commissioners with a copy.
And if they don't get a regulator,
Then-
so this is are
We
these
move on,
homeowners?
Commissioner. We move on. We will not, if they don't want to sign this form, we move on to the next house. We have instructed our crews, and if there are stories about the crews are not following this directive,
Oh,
we'll
okay,
deal
but,
with.
but I'm confused. So are these customers that have regulators now?
No.
Okay, so these are customers that need regulators because you've converted to high-pressure gas.
Mr. Nelson says there's both.
Okay, for the customers that don't have regulators, where you've converted to high-pressure gas, what are you telling them?
They have to sign this consent form that we put together after the TRO was put in place, so that understand it's very clear that they're giving us permission to put the regulator on the outside
Okay, and
of
if
the
they
house.
don't sign it, do they not have gas service?
No, we just move on because they haven't been transferred over yet to the high pressure gas system. So their gas remains on. They just have the low pressure gas line serving their house.
Okay, so you've converted over to high pressure, but you still have low pressure available to
We're in the
customers that.
process. We're in the process.
No, wait, so for the folks on the panel, let Mr. Herson talk, and then, we need one person talking at a time.
We're in the process of converting the neighborhood, the area, from low pressure to high pressure. We cannot complete that project until every customer has either converted over to the high pressure or they've elected to no longer receive gas service from us. That we're not running two systems, a low pressure system and a high pressure system. So that's why we wanted to get the consent form. Our instruction to our crews is if a customer is pushing back and says, I don't feel comfortable signing this, I don't understand this, I don't want to do this, we just move on to the next house. We're not forcing them to sign it. We're not saying we're going to cut your gas service off if you don't sign this.
Okay, and do they understand that they have a choice, that they can sign it or not sign the consent form?
That is our understanding. And we even have it in Spanish on the backside.
Okay, thank you.
If they don't speak English.
Okay, all right, let's move on from this. Any other questions? Okay, all right. So, procedurally, we're going to move to the other customers that have signed up to testify. And this will be like our normal public hearing, but a little different in the sense that I'm actually going to have a group of them come to the table and do that. But before we do that, I want to give an opportunity. There's a member here from the Baltimore City Council, Councilman Cohen. I want to give him a chance to say something. If you'll come to the podium, just identify yourself, make your statement, and then we'll switch to the customers. So the people at the table can just stay put for right now. So, Councilman Cohen.
Absolutely. Thank you, Chair Hoover and Commissioners. Thank you for holding this hearing regarding BGE's company's installation of external gas regulators and related issues. I've represented District 1
Actually, I just need you to state your name for the record.
Apologies, sure. City Councilman Zeke Cohen.
Good.
I've represented District 1 on the Baltimore City Council since 2016. Over the past year, BGE has pursued its Operation Pipeline gas line replacement program with complete and utter disregard for the communities that I represent. BGE claims that it is pursuing citywide upgrades to medium gas pressure and thus external regulators in response to complaints about unreliable gas service. While gas upgrades and new infrastructure are certainly needed in some areas of Baltimore City, I have not seen compelling evidence for a need to replace all gas lines that existed as of 2013. I hear far fewer complaints from constituents about low gas pressure than I hear about disruptions to streets and sidewalks that are not repaired in a timely fashion, sloppy workmanship, damage to homes, and poor communication from BGE and its contractors as part of Operation Pipeline. Most concerningly, BGE has threatened to shut off gas service, as you heard today, to those who have refused external regulators, which I understand to be illegal. Even following the court order, as you just heard, that has required BGE to install external regulators with permission from the property owner, I have heard multiple reports of contractors pressuring renters into giving written consent to install external regulators. In response to constituent complaints, I have repeatedly thought to bring BGE to the table and create a scalable compromise that gives communities a voice in how they are installed. I even brought a group of constituents, many of whom are here today, to BGE headquarters to have this conversation. Instead, BGE refused to listen and came with bad faith solutions, including an absurd recommendation for residents to decorate external regulators to make them look like flamingos. It has become clear that BGE will not change its practices unless compelled to do so by the PSC, legal action, or both. BGE staff have expressed to me that they are looking to the PSC for clear guidance on this issue. I ask you all, the PSC, to rule definitively and in a way that fully incorporates best practices and community input and holds BG&E accountable for the harm they have caused to our communities. Thank you.
Okay, thank you, Councilman Cohen. What do you want to take a break or do the cooking? All right, so while we're doing this transition, we're going to take a recess for 30 minutes. And then, like I said, actually, Andrew, the Executive Secretary, Andrew Johnson, will name the first group to be up here, and then you can just take a seat at the table.
The first folks are David Oppenshaw, Stephen Topping, Tony Klein, Doug Clemens, Mark Hoffman, and Jack Dana.
Okay, so if the folks at the table move off, then those folks can come up, and then in 30 minutes we'll reconvene and get back together. So, thank you.
Thank you, Commissioner.
Oh, yeah, now that it's.
Okay, back on the record. So, couple ground rules for the folks sitting at the table. I'd like you to hold your comments to 3 minutes or so, just so we can kind of, because we have a number of folks that would like to offer statements to us, and we also need to hear from the commission staff and the Office of People's Counsel after we get through this. So we're essentially just going to go right down the road, starting at the left here. State your name, and if you could spell your last name for the court reporters thing, and then just proceed with your statement. So go right ahead.
Hi, my name is Taylor Smith-Hams, Smith, S-M-I-T-H hyphen Hams, H-A-M-S. And I'm a U.S. senior organizer with 350.org. We are a global climate advocacy organization dedicated to ending our dependence on fossil fuels by ushering in a fast and just transition to renewable energy. I am here today both as a Baltimore resident and as someone who, through my work at 350.org, knows that utilities can and need to be part of the solution to the climate crisis. As I'm speaking to you today, residents of Maui continue to search for survivors from one of the deadliest wildfires in U.S. history. Just last week, devastating thunderstorms wreaked havoc across the continental U.S., killing 2 people and causing what Lieutenant Governor Aruna Miller has described as some of the worst electrical damage in Maryland. This is the climate crisis. This is the result of burning fossil fuels. We all know that we must transition rapidly away from fossil fuels and toward renewable energy. That is why the state of Maryland has committed to becoming net zero by 2045. So why is BGE planning a massive fossil fuel infrastructure build-out? Because like so many investor-owned utilities across the country, BGE prioritizes profit over people and the planet. BGE's plan to install external fossil gas regulators that residents do not want is just the latest evidence. This plan is fallout from BGE's larger operation pipeline under Maryland's STRIDE program, which has been heavily criticized for replacing fossil gas equipment before it needs to be, replicating and spending on fossil gas infrastructure beyond what is necessary for reliability and safety. Customers are being burdened with massive rate hikes to fund failing and outdated fossil fuel infrastructure that we need to be moving rapidly away from if we are going to avert climate catastrophe. BGE sees the writing on the wall. They know that we are moving away from fossil gas and towards electrification. But instead of supporting that transition, they are digging in their heels by forcing unnecessary, dangerous, and planet-warming fossil gas infrastructure onto residents and shouldering us all with that cost. BGE should be helping Marylanders electrify and insulate our homes, not hiking our rates and locking us into more fossil fuel infrastructure. The PSC's regulatory powers include a requirement to consider the achievement of our state's climate goals when supervising and regulating public service companies. It is incumbent upon you as commissioners to stop BGE from investing in more fossil fuel infrastructure and use your authority to put Maryland on a path towards climate justice. Thank you.
Thank you. Next.
Good afternoon, Commissioners. My name is Jack Dana, President of the Mount Vernon Belvedere Association.
And if you could spell your last name.
Sure. D-A-N-N-A.
Thank you.
We are grateful for this opportunity to provide testimony against a flawed policy that would make our communities less safe, more susceptible to climate change and its negative effects, and destroy the historical assets that make our city a cultural and economic hub for tourists, for residents, and businesses who want to come here. I will focus on 2 points in my testimony before this body: why commit to more gas and investments in gas infrastructure. This centers on the urgent need to move away from investments in fossil fuels towards an electrified Maryland. Now is the time to only maintain current infrastructure until we shift to renewable clean energy. We must not invest in high-pressure gas infrastructure that will commit us to methane for the next 100 years. We neither want nor need this in Baltimore. This summer, we witnessed a parade of destruction caused by extreme climate weather events, including the devastation of the Maui wildfire and the painful loss of human life. Recent cataclysmic events underscore the urgent need to take decisive action to mitigate the effects of climate change, the primary cause of which is the burning of fossil fuel, including methane, a greenhouse gas approximately 25 times more potent than carbon dioxide. Governor Moore aims to reduce dangerous greenhouse gas emissions by 60% before 2030 and achieve net zero emissions by 2045. President Biden aims to halt our reliance on fossil fuels by 2035. We should embrace these worthy goals as an opportunity to free ourselves from our dependence on a fuel that commits future generations to devastation. BGE should be required to prioritize investments that align with the President and the Governor's vision for a more sustainable and resilient future. Now I get to the local assessment here. So in March of 2023, BG&E came to our local general meeting discussing the infrastructures. In an hour-and-a-half presentation that garnered great questions, feedback from BG&E, not once were the 40 residents, businesses who came to the meeting were said that they were going to get a gas regulator. No inside, outside, unsafe, inside, outside. Were confused and still very confused. But what we did get a week later were BG&E contractors or privatized contractors knocking on the doors of 5 residents, bullying them about getting these gas regulators. Thus, a week later, MVBA unanimously voted, the city's oldest historic district from 1938, voted to join the community activism, the great work of Maggie Fitzgerald, Claudia, and Sandy from Federal Hill to advocate for our communities and the preservation of our buildings, which really do drive economic development at a regional level, but also at a local level. And we get this encapsulated in the sense that safe. All of you know Mount Vernon. All of you walk the streets. I witnessed a week ago on the east side of Madison in the 800 block of St. Paul waiting for the silver bus to head downtown. And what did I witness? A tractor and trailer on a Saturday afternoon at 1 p.m. jackknife on a pedestrian street. Where did it end up? Right on the sidewalk in front of 800 St. Paul Street. If there were a gas regulator there, what would have happened? An explosion, collapse of 2 buildings at least, and the people eating at San Pablo's Tacos outside dining. So at least 20 or 30 people would have been susceptible to that explosion. That's not safe, and there is no evidence from what we have seen from a community that internal, external is safe, more safe, less safe. What we do know, there is a right to property owners to have a decision over their properties, along with a collection of renters in this community who have also signed on as complainants who wish to live in safe buildings with gas regulators. And we feel the evidence points toward internal with an external vent that releases the gas. In concluding thoughts, I urge the Commission to withdraw support for the installation of a high-pressure gas system in Baltimore. Instead, fix existing gas lines as needed while reprogramming investments towards electrification. By embracing sustainable energy solutions, now we can reduce greenhouse gas emissions, improve air quality, promote a healthier and more equitable future for our communities and our beloved state in Baltimore City and all of our communities. I thank you for your attention to this critical matter.
Thank you. Next.
Hi, my name is Wendy Bozel, B-O-Z-E-L. I'm the president of Upper Fells Point Improvement Association, and I also have been part of this effort. And I left before they got arrested because I'm a teacher and I couldn't take that chance. But anyway, Last year, an external gas regulator was installed on my Baltimore City row home. I was not given any instructions to its maintenance, just that BG&E was responsible for its upkeep. I didn't really know what was being installed in my home, just that I wouldn't get gas if I didn't have it installed. I decided to do some research and found federal regulations and insurance company warnings. The following is from West Bend Insurance Company. For more than 125 years, this insurance company has provided valuable insurance coverages and services to home, auto, and business owners. And basically, it's on their website. These round pancake-shaped regulators ensure that the gas goes to appliances at a correct pressure. As weather turns cold, there could be problems with gas system and you might not know it. If the regulator becomes blocked or the airflow restricted for any reason, the regulators may operate incorrectly, which could potentially result in an overpressure on appliances, causing an explosion or fire. As snow starts to blow, be sure to shovel away so your regulators can breathe. Also, another insurance company said this: telling homeowners to keep your gas regulators clear, it could save your life. All regulators which have a vent allows the device to breathe and have normal operation. It also functions as a pressure relief, which we've heard earlier. For safety purposes, this vent should remain free of dirt, debris, insects, water, snow, and ice. Doing so could save your life. BG&E did not share with me any of this vital information. The public has not been educated about all the risks or about the preventative steps we need to have to keep external regulators functioning properly. And then I found this federal regulation, 49 CFR 192.353, and it states, each meter and service regulator, whether inside or outside a building, must be installed in a readily accessible location and could be protected by corrosion and other damage, including, if installed outside a building, vehicular damage that may be anticipated. So there's two different things that on my own simple research that I found. And I just wanted to add to that is I didn't know what was going to happen. It was last fall, it was October, and I thought, oh gosh, if I don't get this done, they said that I wouldn't have any heat. So I felt pretty pressured into having it done. And then the neighbors behind me I'm the 100 block of Wolf, and the neighbors that live behind me on South Chapel, 100 block, they had internal gas regulators installed. So it was pretty perplexing that 1 block away they would have different regulators installed.
Okay, thank you. Yes, sir.
Good afternoon, David Openshaw, CEO of Ligon & Ligon Incorporated. We're a BGE gas contractor.
So if you could spell your last name.
Openshaw.
Thank you.
We thank the Maryland Public Service Commission for calling this hearing and allowing me the opportunity to speak before you today. BGE's gas projects provide vital employment and work opportunities for my company in Baltimore, amounting to 80% of my company's annual revenue. The work stoppage from this TRO is having a negative impact on our business's financial security due to the interruption to current BGE projects and the indefinite postponement of planned new projects for the third and fourth quarters of this year. This disruption will result in our company having to seek utility opportunities outside of the BGE territory or in other non-regulated utility construction markets, which would impact our organization, our maintenance of our OQ certifications, and our capacity to support BGE's resource needs once normal work resumes. Worse for us, this disruption could result in crew layoffs, having a profound impact on our employees and their families. Since this is affecting all BGE contractors like us, a lack of resources would likely have an extended effect on BGE's asset infrastructure replacement program this year and well into 2024. Our company has replaced thousands of aging BGE gas services under Operation Pipeline and other gas infrastructure renewal programs. In the past 2 years, we have renewed over 400 services in historic Annapolis and Eastport without issue, and we're continuing to do it now. Working with businesses, residents, churches, and schools to accommodate architectural concerns for moving regulators and meter assemblies outside. Having witnessed the devastation of the fatal Flower Branch Apartments gas explosion in 2016, and more recently the fatal gas explosion in West Baltimore just 3 miles from our office, we fully support BGE's proactive position to follow the recommendations of the NTSB to move all gas regulators outside. That investigation report on the Flower Branch accident said, quote, "Had service regulators been located outside Building 8701, the explosion would not have occurred." It went on to recommend moving all regulators outside whenever a service is replaced, not just the regulators at multi-unit complexes and the regulators for new service installations, which accounts for only a small percentage of the services BGE upgrades each year. And having seen the frightful conditions of inside gas piping in many homes and businesses as we update their gas systems, we see inside gas regulators as being less safe than those placed outside, simply because that vent pipe can be compromised. Not intentionally, sometimes accidentally, sometimes it's built over by walls, sometimes it's used to create pull-up bars. We've seen all kinds of things that happen in there. And that's exactly what happened at Flower Branch Apartments. So we applaud BGE for going beyond the minimum of the Act and seeking to make every customer's home and business better protected from a gas leak disaster, and we encourage the PSC to support BGE's initiative. Thank you.
Thank you.
Hi, I'm Tony Klein, Kline, and I'm also speaking on behalf of my husband Douglas Clemens, Clemens. Thank you for allowing us to speak. We have owned our house at 345 Warren Avenue in the historic Federal Hill neighborhood of Baltimore since 1997. We also own rental properties in Baltimore City. Over time, we learned about the new high-pressure pipelines being put in by BGE, and as this progressed, 11 of the properties had internal regulators installed with a tiny vent and no problems or issues. Most recently, one property had to have an external regulator installed. With such sloppy work, we had to submit a complaint form online. Concrete was sprayed on the front of the facade and on the metal railing, and a marble step was cracked when concrete was removed to install the underground gas line into the house. BGE also refused to repair a hole they cut into the drywall in the basement to bring the pipe inside, saying it was not their responsibility, or the contractor. We subsequently received correspondence from BGE for our primary residence on Warren Avenue with a choice to pick our preferred regulator, and we were going to pick internal, mostly because of this. This summer, we learned that the owner's choice of the type of regulator had been removed. On nearby streets, only external regulators were being placed. The company doing the installations indicated that we would not have a choice. We objected and kept objecting, as did others on the 3 blocks of our street. We heard verbal threats about gas being shut off. On June 21st, BGE posted a notice on our front door that we had to accept the external regulator or they would shut off our gas supply. We are not home during the day. About 4 hours after they posted the notice, they jackhammered the street in front of our house and turned off our gas, which supplies our gas stove, furnace, and hot water heater. For 8 days, we had no gas service, yet we were billed for those days. We have a high-efficiency gas hot water heater with an electric power vent that ran for many days on the remnants of the gas in the lines, yet after the gas was turned off, we did not have hot water. Who knows the long-term effects of this on the hot water heater? We just wanted to be able to choose internal for our regulator. We felt that this was a vindictive and coercive act to force us into accepting something that had been offered differently for many years, only a few blocks away. For such a company to be bullying and forcing people to bend to their will when they had previously allowed the same thing to move forward just blocks away is hypocritical and untenable. For BGE to treat us without respect or dignity after being reliable customers in Baltimore City for the last 37 years is egregious. And this has happened all over the city, as you have heard. For all of these reasons, I wanted to testify today against BGE. Thank you.
Thank you. Yes, sir.
Hi, I'm Mark Hoffman, Hoffmann. I've worked in the HVAC industry since 1989. currently a semi-retired consultant for a company located in Rochester, New York. I moved to the Upper Fells Point neighborhood in 2016. Over 30 years, I've attained numerous certifications and attended many training classes in the HVAC industry. I've performed maintenance and service on both residential and commercial gas-fired systems. I have installed and supervised the installation of natural gas piping systems in both residential and commercial buildings. I have supervised crews installing multiple thousands of HVAC systems over the years. In my experience, it is a misguided plan to install natural gas regulators such as the Itron B42 in front of row homes in densely populated parts of Baltimore City. Locating natural gas regulators on pedestrian walkways makes them vulnerable to incidental damage and exposes them to tampering. In regards to tampering, the Itron B42 regulator has a convenient dust cover on the front, which is easily removed by hand. Under the dust cover is the access to a slotted screw. This screw, turned either clockwise or counterclockwise with a standard screwdriver, is the adjustment for the regulating internal gas pressure downstream the line to the gas appliances in the home. By rotating the spring clockwise, you will increase the gas pressure, and rotating counterclockwise will decrease the gas pressure. There are many types, models, and ages of natural gas appliances installed in homes to cover all possible scenarios. Most all require a steady supply of gas pressure measured between 5 to 7 inches of water column, or in layman's terms, 0.18 psi to 0.253 psi. Unauthorized adjustment or malicious tampering may cause unacceptable operating conditions in the natural gas appliances. Older furnaces, boilers, and water heaters, especially those with a standing pilot flame, can be negatively affected by changes in gas pressure, resulting in the production of carbon monoxide. Too low of a gas pressure will cause a flame producing soot. The following of a heat exchanger due to sooting will ultimately produce high amounts of carbon monoxide. Conversely, gas pressure that is too high can create a flame that impinges on the heat exchanger, also creating a dangerous condition in carbon monoxide. Obviously, either one of these conditions is potentially lethal. To reduce the possibility of tampering, and in the interest of public safety, I recommend that external gas regulators should not be installed on the front side of row homes that have no barrier from pedestrian walkways. I would offer a compromise waiver exclusion that says if a customer believes that an external regulator could be exposed to tampering, the customer could have the regulator installed inside the home. Thank you.
Thank you. So, if you can call the next 6 names, and I would just ask you folks to sort of move off, and then we can allow for the next group. Thank you very much.
Doreen Hartley. Adrian Smith. Ann Craig. Harley Flack. Joan Floyd. And Stacy Jacob. I don't see Stacy. Janet Blair.
Okay. Oh, yeah, that's her. All right, and we'll start it on the left, on my left, and again, just state your name, spell your last name, and proceed ahead.
Sure. Doreen Hartley. Spelling of the last name is H-A-R, T as in Tom, L-E-Y. Chairman Hoover and members of the commission, I am president of NPL East, which is a Century Group, a company contractor that has worked for BGE for over 28 years. So essentially, we are one of those outside contractors often referred to throughout these hearings. BGE is NPL's only customer in the Baltimore area. Therefore, we are an integral part, or they are an integral part, of our local success here. In support of BGE, NPL has increased crews and staff over time, over 28 years, in fact, to assist BGE in its effort to replace its aging infrastructure. We currently have 185 employees in Baltimore performing work for BGE. I should note that this talent is sourced in the Baltimore metro area. NPL has invested nearly $19 million in tools, trucks, and equipment necessary to complete BGE's work plan. NPL has leased a multi-year building in the yard near Hawkins Point necessary to complete the work plan. NPL has partnered with BGE to enhance opportunities for DBE vendors throughout the Baltimore metro area. Specifically, NPL utilizes over 20 DBE vendors in support of the utilities work. Specifically in this area, we have invested over $18 million with DBE vendors in 2022, and we forecast to spend similar amounts in 2023. Obviously, BGE's work plan is an integral part of achieving those DBE goals. NPL has assisted in the restoration of power in the aftermath of severe rain, wind, and snowstorms for our utility customer. And lastly, NPL is active in the Baltimore community through volunteerism and philanthropy. Throughout the long tenure of our partnership, as you can imagine, we've experienced many operational challenges along the way. However, I must say the impact of this current work slowdown and shutdown associated with the location of gas regulators is proving to be by far the most difficult to overcome. We have already had to reduce the number of our NPL gas crews in the Baltimore metro area. This has also resulted in a halt in our hiring of new crews, thereby negatively impacting our ability to hire and train local talent. We had to reduce the number of DBE crews who work under our company's tutelage. Our DBE vendors are also laying off employees as their workload has correspondingly slowed and/or stopped. Our work has become obviously less efficient as we have more starts and stops in our processes as we strive to resolve customer issues and concerns as you've heard about today. Our greatest concern is that the events in this current situation create uncertainty in our construction industry, making it much more difficult to hire and recruit talent as it is today. Bottom line, navigating these choppy waters is not sustainable much longer. We are dependent upon BGE for a steady stream of work to maintain a profitable business here in the Baltimore and metro area. We have really invested for the long haul, as evidenced in my comments, and we are active in the local community. The longer this takes to resolve this matter, the more it impacts our long-term plans for continuing to work in Baltimore and specifically for BGE. So our appeal today is for an expeditious process in terms of decision-making. On behalf of NPL, I ask the Commission to consider the impact this unresolved issue has had on the sustainability of its local contractors who help feed the local economy. Please, I implore you to expeditiously resolve this matter so we may return to our work of safely enhancing the natural gas infrastructure throughout BGE's territory. Thanks very much for your consideration.
Thank you.
Hi, good afternoon. This is not my first time here, so I recognize some new faces. My name is Adrienne, that's spelled Adrienne, last name Smith. And I was here 5 months ago in March. And one of my neighbors, our neighbors dropped me down here because we have an extensive documented history with the Public Service Commission from last year. Unfortunately, we're still trying to wonder what happened because I came here, and I recognize this gentleman because it was not an open hearing, and there was a lot of discussion for 2 hours about electric cars and recharging stations, which is great. But I was allowed to speak, and thank you again. The gentleman at that time stopped me as I had described in brief what you've heard a lot of so far today, the repeated stories and testimonials about tremendously terrorizing behavior of contractors and subcontractors, inflicting unjustifiable property damage, really unsafe, behavior, because it's not following process in the basic way of safety, smoking while you're drilling, smoking on the job. When I got to the part about us on our street in 1600 block of Smallwood, about it should not come to black women, head of households, and we're older, being in the street with these contractors who seem to be, there's no independent oversight. The gentleman, asked me to wrap it up. So I didn't get a good feeling about that, considering that we had already written complaints to the Public Service Commission. And I will say this, I'm pleased to see a difference in approach today. And perhaps because I don't know what it is that it was not taken seriously, not during the initial filing of the complaint by our neighbors, the emails, there was no follow-up by the commission, and bear with me, please, after for over a month, when I asked, and you can check the records, when I asked that they please, people there at that time, he's not up on the screen, give the same amount of detailed attention to us and our situation, our homes and property, as to what I had observed to the electric car situation. So I called a month after that to a regulator, Mr. Sproul, and then I received a call from a woman, Linda Hurd, who I guess still works for this agency, and she called me, and the interesting part was that she approached me as though she'd never heard of my name, which was kind of hard because we'd had copied Senator Markey, who was one of the authors of the Federal Safe Pipeline Installation Act, which directly addresses the interaction between the neighbors, consumers in the community, notification. It's very straightforward. Anyway, she wasted 35 minutes of my time, and then she said she had to go to a meeting and excused herself. But she actually is on quite a few of the emails. I don't have the case number in front of me right now, but we had extensive interaction before we went to court, and then following that, because our gas had been cut off, the sloppiness, you cannot possibly overstate the issues, and I won't go into a lot of detail now, but we didn't see any safety, we didn't see any concern for safety. We had to fight every step of the way to get inspectors to come out for the processes that were needed. Also, I want to make you aware of the level and quality of that's different depending on the area of who the contractors are. And I don't know what the procurement process is that Baltimore Gas and Electric / Exelon uses, but ultimately, as our attorney stated, we missed Thanksgiving, we missed Christmas together. My sister and I lost our parents within 10 months of each other right before COVID. And anyway, when they came out, the crew came out that week, And we were stood up repeatedly. I don't like being blamed. Nobody likes to be blamed when it's not your fault. And so all of this is outlined in our complaint, which was summarily, quickly discharged at this agency. And I'd like to see that changed. So anyway, when they came out, a crew came out smoking, doing all kinds of unsafe things. And when we asked for them to please stop smoking, they walked off. So I think that the Exelon should be questioned extensively about their own racial bias. I've heard that some areas are okay. Ours is a historical area, but we're not designated in that way for other reasons. But anyway, they've really, we felt like that we were failed. The black community was failed at every level at that time, which is what my sister called me and said, get down here for March. And we had really, thought that someone would respond, and nothing happened subsequently to that. And so, once, how can I put this? Once I saw the 3 Caucasian ladies who were arrested, and I was contacted because people were still very upset. Our community is really, really damaged. Right now, we don't have our gas, our mother's gas oven is still not working. They don't want to fix it. It worked fine before. They told us we had to have a second gas shut off because we never had gas coming out of our home. And it took forever to get the contractors to come back. And this is not just us. So I'm speaking for a lot of people in our community that are shut-ins. And, the ugly thing about it is that I don't know how soon Baltimore Gas and Electric is really going to say, okay, we made a mistake. And don't lie to people. Be upfront. We put all of this into our case. And I would like to hope that with the new faces on this panel, that you're going to, do the job so that, we can see that there's some equitable and substantive oversight and resolution. So I will stop there, but I hope you pull the case.
Okay, we'll look into it. Thank you.
Mr. Chairman.
Yes, sir.
For the record, all of the meetings of the Maryland Public Service Commission are open public meetings in accordance with the Maryland Open Public Meetings Act, the Sunshine Law.
Do you remember me? I came in, but he put me on the schedule. It was an addition, so it was not for, because I objected to the rate hike increase also.
Yeah, that's fine, but I'm speaking to the chairman.
I understand.
I'm speaking for the record.
Yeah.
All of our meetings are in accordance with state law and are open to the public. And to be honest with you, we give great deference to the citizens of the state to come in before our agency and speak, more so than we do lobbyists or other moneyed interests.
Okay.
And I think it was important to say that, Mr. Chairman.
Okay.
Well,
Thank
you for
Thank
saying
you.
that.
Okay. Yeah, okay.
Okay.
So, go right ahead.
Good afternoon, Commissioners. My name is Ann Craig, ANNECRAIG. I'm a board member of Fells Prospect Community Association, and a lot of this for me has generated just a lot of questions that I don't think have been answered satisfactorily, and some of them touch on a lot of different things that we've talked about. We've been told that we have to get external gas regulators because of the high pressure gas lines, but has there been a satisfactory explanation of why we need high pressure gas lines? Where's the data and evidence to support that upgrade as opposed to lower medium like we have now? Of course, we're still waiting for safety data to support why external regulators are more safe than internal regulators. 3 years ago, BGE testified in front of the legislature about how the external gas regulators weren't appropriate for dense cities like Baltimore, and yet that no longer applies. So how does that change? Different than that, I understand that there's a contract when they do their work, they, meaning the contractors, whomever, have to repair streets, sidewalks, things like that. But they only repair the exact spot that they did. So you can walk across a crosswalk, part of it's repaired and it's been repainted and the other part hasn't. Or the patchwork that we have along our streets and sidewalks, and it just makes us look like a bad quilt, and it doesn't actually increase the quality of our city at all. And who holds BG&E accountable when they don't repair things? We know there's complaints of streets, sidewalks, homes, property not being repaired, but who holds them accountable if it doesn't happen? I was listening to a BG&E spokesman talking on WBAL on August 1st, and he stated that customers would end up only paying something like 3 cents a month additional on their bills. It doesn't seem very likely, but I think the questions are, what is the true cost of this project? What is the actual cost to us as the customers and residents? And what is the profit difference between installing the high pressure gas lines and external regulators versus replacing the current type of gas lines and pressure and the internal regulators? What's going to be the cost to the people who are remaining customers when the people who can go to electric appliances? Because some people will be able to and lots of people won't. The burden of that may go to the people who are still left using gas. Well, how will that affect them? Why are so many places fighting the exact same type of regulators like York, PA, Montgomery County, Providence, Rhode Island, New Jersey, if these are so desirable and safe? Another question, what happens to the old gas mains once we don't use them and they're out of commission? How is the utility company allowed to push off the safety maintenance of external regulators to the homeowner? Yeah, I get that one. Sorry. Yeah, we know that. Anyway, so, and the same thing with liability. So we need some real answers to these questions and not facile answers from BG&E that they keep repeating that the danger is not the external regulator, but the fast car. When I was leaving a meeting in the spring at, in Little Italy with BG&E representatives, I really felt like the Baltimore and Baltimore Gas and Electric no longer applied to us. It wasn't about Baltimore at all. And lastly, people have been fighting up for 2 years, like Ms. Smith, and that includes partly PSC, CHAP, city and state legislators who have been really late to respond to a lot of residents who've been fighting for a long time. And I don't believe they've been served well. And so questions need to have been asked and should have been asked and need to be answered, not accepted at face value. BG&E says it's safer or it's warranted without that. And by not responding, that leaves them to just continue in their manner of, intentionally bullying people or forcing people to get things without any options or choices and not thinking about the city as a whole. Anyway, thank you. My questions are online too.
Thank you. Yes, sir.
Good afternoon, Chairman Hartley and honorable commissioners. My name is Harley Flack, F-L-A-C-K. I'm the president CEO of Stella May Contracting. We are a minority subcontractor that works with BG&E. And thank you for holding this important hearing regarding the Regulator project. I'm here to offer an economic impact statement regarding Stella May Contracting. We were founded in 1995 as a certified diverse minority company in the state of Maryland. Since our founding, Stella May has grown to become a well-respected, deeply experienced heavy civil utility contractor within both the Baltimore-Washington region. We have achieved our long-term growth objectives and attribute our success to a relentless focus on strategy, safety, our expectation of high-quality work, and the ability to hire and retain top talent. Stella May prides itself on our commitment to safety for our clients and the constituents we serve. Stella May is pleased to work with companies like BG&E who are committed to safety of their customers as well as their workers. As a valued contractor for Baltimore Gas and Electric, I sit before you to share Stella May's perspective regarding workforce development and hiring in the Baltimore region, along with the overall economic impact to our company. Stella May Contracting has 2 active main replacement projects, which include relocation of regulators. These projects were awarded in the spring of 2023, with projected completion dates in the winter of 2023. The duration of these projects has been factored into the company's strategic and human resource development planning. Stella May's hiring strategy, coupled with its diversity, equity, and inclusion initiatives, are deliberate. We have hired employees to create agile teams specifically tailored to this program's needs. This includes project managers, superintendents, and project coordinators. These are all people who depend on the work of this project as well to support themselves and their families. Beyond their contributions to this project, our team members continue to gain invaluable skills. These employees will obtain operator qualification or OQ qualifications, equipping them with safely introducing gas to gas-powered appliances, an investment in their growth and expertise that will yield long-term benefits to all of those we hire in the city of Baltimore. To meet the baseline schedule, we initially assigned 4 service crews to each project. However, due to the disruption, we have reduced our resource allocations to 3 to 5 service crews as needed. We anticipate it will be challenging to meet the baseline finish date of the winter of 2023, which will adversely impact planning for project operations and crew assignments. Financial impacts cannot be quantified at this time. Stella May has spent several millions of dollars in equipment and training the resources for this project. However, delays, stoppages, and disruptions have historically slowed the growth and development of our company. As stated previously, Stella May is committed to safety of all of our clients, customers, and those we work with. Thank you for your time this afternoon.
Thank you. Yes, ma'am.
Thank you very much. Sorry. My name is Joan Floyd, Floyd. And I just want to start by saying that several hours ago, BGE gave an initial presentation that I thought made a really good case for phasing out residential gas. I also know that everybody can't afford to do that right now. A lot of people cannot, which has already been said. With my comments, I hope to reinforce some of what you've already heard and add a few things as well. This isn't just between a customer and a gas company. On a row house block in Baltimore, even a single piece of above-ground gas equipment near the curb presents a problem to everyone on the block. We are constantly at risk for vehicles running off the road and onto the sidewalk or even into a house. There was a car into a house on my block very recently. The last time, the time before that, it was a fuel truck. And it's not just vehicles and crashes. When you construct outdoor above-ground gas equipment on most row house blocks, you're putting it within reach of everyone. The rule that we hear about keeping outdoor equipment 3 feet away from harm is instantly broken when you place this equipment within 3 feet of the public right-of-way. You cannot expect or require a homeowner or a gas customer to control or be responsible for what happens in the public right-of-way. Now I want to get to my main subject, which is the construction of above-ground gas equipment in the right-of-way. That is the scenario I've seen the most in Baltimore City so far. And yet in the months I've been following this gas regulator issue, I have never been shown a citation of any authority that has allowed these things to be constructed in the public right-of-way, even without the homeowner's objection. Nothing has been shown to me. And yet it continues to happen. BGE continues to put these things in the public right-of-way. I know that neither a gas customer nor a homeowner can give BGE the green light to construct above-ground gas equipment in the public right-of-way. As customers and homeowners, we don't have that authority. Now, I suspect, right, that PSC doesn't tell local jurisdictions what to do, and maybe local laws and regulations and protocols and liability issues aren't of interest here today. But I'd like to turn to the gas service tariff, which has a couple very interesting things to say. The gas service tariff says that the customer is only responsible for equipment that is on the private property. And it also says that in no event shall this above-ground equipment extend beyond the private property line, beyond the customer's property line? That is in 6.11 of the gas service tariff. That's where I found it. So again, given the nature of the built environment in Baltimore City, I do not understand how any of this has been allowed to get to this point. Now, I was interested in the question earlier about...
Can I just interrupt you for a
Yes,
second?
ma'am.
So you have an outdoor regulator that was installed on your property?
No, ma'am. I'm in the pipeline later on.
You're in the pipeline.
I'm going to...
Oh, so you're going to.
I'm looking ahead.
Okay, and when the regulator is installed on your property, is it going to be on your property or it's not going to be on your property?
I'll answer your question directly by saying my neighbors, it could be either way because the nature of our block is several different types of houses and different setbacks, and some have no setback. My own...
Miss Smith, do you have a regulator on your property now? Are you Miss Smith? Yeah. Do you have a regulator on your property right now?
We do.
Yeah, and is it on your property or is it on the city right of way?
It's on our property.
Okay.
May I?
Sure,
Okay.
go ahead.
But if I could just so I would be interested in knowing for the people who are here if any of you have regulators that are installed on city right of way as opposed to on your property.
Okay.
Spoke earlier.
You do.
Yeah. Okay.
Okay. Thank you.
Yeah. Right.
Okay. Thank you.
So, oh, I'm sorry.
And I hate to hijack the hearing, but if just very quickly, BGE, can you respond to my question about whether...
Mr. Chairman, I think it's really important to have the witness finish their testimony.
I'm sorry, but after this is done.
Okay.
But I appreciate the interest. Believe me, I do. So in line with that concern that I have, and the commissioners had a question earlier about for BGE about their engagement and what comes first, and how they notify people. I have a little bit of insight into that because I said earlier I'm not one of the affected neighborhoods right now. I'm not in one of the affected neighborhoods right now, but I was trying to see if I could get out in front of this issue, and actually, there was an initial notification that I did receive at my house, because BGE it seems that BGE may be starting this whole process by applying for and obtaining a stormwater waiver, because that's what the notice that I got was. It was about a stormwater waiver that was being obtained, and well in advance, apparently, of any kind of work being done in the street. And so being aware of what was going on, I personally inquired with BGE about their plans for when they get to my neighborhood, which is a row house neighborhood. And after I used the suggestion of how to get in touch with them that was on that particular sheet that I sort of remembered getting it several months ago, and I pulled it out, and there it was. So after initial email correspondence with BGE, I asked if BGE will honor the gas service tariff, the portion that I had found, and not construct gas regulators in the right-of-way. I was trying to see if I could establish a kind of a baseline or an initial sort of common principle that I could understand that they would be proceeding under. So they wrote back and asked me for clarification of what I was referring to. So I sent them the specific citation, 6.11 of the gas service tariff, and that was on July 27th. And there has been no response. That's the end of my paper trail. Now, in my experience, when you present an issue like that, and something that is on paper and authority. And the respondent knows that they have a good answer that they can support, that is valid, that is legal, and they're willing to commit it to writing, you get that answer. I haven't gotten the answer. So that is my testimony today. Thank you.
Okay, thank you. Yes, ma'am, go ahead.
I thought she was going to ask her question.
No, we're going to finish it.
Oh, okay.
So you go right ahead. So
Well, pretty much a lot of what
actually,
I want.
I need you
Oh,
to.
I'm sorry.
Yeah, state your
Janet-
name. Yeah.
Janet Blair, Blair.
Thank you.
Pretty much most of what I wanted to say has already been covered by most people, but I think, Mr. Richards, when you started your statement and you said people don't trust BG&E anymore, you are absolutely right. Because I remember when BG&E used to have a key to my basement, and they could come in and read the meter. Then they went to the cards, and I had to fill the cards out and send it to them, and then they went to this electronic stuff. But the whole thing is, everybody has been very polite and not talking about the money issue. And I know money is the primary reason that BG&E changes everything. They don't change it in our favor, they change it in their favor. So if the regulators are going to leak, whether they're inside or outside, if they're inside, you can get a gas detector to tell you if it's leaking so they can fix it. And they're safer inside. I don't care what they say. But for BG&E's purposes, if they have to put them inside, especially if you're dealing with some of these, and I know you guys, I hadn't thought about the contractors being here, but I'm glad you're here. You're probably nice people, but they got a lot of nasty dogs out there. I mean, people who are just, they want to be mean to people. They want to stand over top of people and make them cry.
Yeah.
And maybe because that's the only way they make their money. If they don't get the job done, they don't get paid. I don't know why they act like they do, but they do. And that is the problem, that people cannot trust that what is being said to them is the truth. And that is the biggest problem of the whole thing. I mean, what she said is very true. If they came and put a regulator at my house right now, according to my land deed, it would be on public property. So how do you turn around and say that I got to be responsible for something that you put on the sidewalk? Now you say it belongs to me and my insurance is going to change and everything else is going to change because it's a piece of equipment that you put there to make your life easier, and now I'm responsible? It just doesn't make any sense. Gas used to be natural gas, clean gas. Now it's bad gas. Okay. For whatever reason they don't want to do it anymore, I'm okay with that. But just tell the truth and not so many varying stories and so many horror stories and so many things that are just not fair to the public.
Thank you. So, next.
James Prost,
That's the next group.
Terry Aston, Scott Donadio, and Eric Holcomb.
Oh, okay. All right. Actually, we missing? Oh, wait a minute. So, yeah. So. All right. Yeah. No. Come. Write them. We got plenty of room. So. All right. We'll start with you, sir.
Good afternoon. My name is James Prost. I'm a resident of Bolton Hill, and I'm a board member of BHCA, Bolton Hill Community Association. And I'm speaking on behalf of both myself and the association. They've designated me as the one to speak to them. They are on the record as opposing BGE's actions related to the relocation of gas regulators. I frankly became a lot more knowledgeable about gas regulators and pipelines than I ever thought I wanted to be over the last several months. And the more I became knowledgeable, the angrier I got at the actions and policies of BG&E. I'd like to first say that Bolton Hill, as you would expect, is against the installation of external regulators because of the aesthetic, economic, quality of life impacts in a historic district. But that is by far not our number one issue. There are so many issues, and I'd like to just talk about 10 issues. One is misstatements. So many misstatements by BG&E that you have to have an external regulator. That's not the regulations. That they need to support higher capacity when you got a city that says reduction in population and we're moving away from natural gas. I don't understand it. The need to provide enhanced service. I don't think whether it's high pressure or low pressure doesn't enhance my service at all. It's the gas works or it doesn't work. It comes or it doesn't come. They've said safety is their number one choice. I believe it's 110 years in our neighborhood since they started changing gas pipelines. I think they would have done it earlier if they had some question or number one concern was safety. And if number one concern was safety and you can't have an exterior regulator, I'm very happy they installed an internal regulator in my home, but am I less safe? They didn't tell me I was safer or less safer by installing this regulator. There are clearly no safety justifications that say you have to have an exterior regulator. I think the data is on the contrary, but what happens with an exterior versus an interior regulator, the liability changes, and all of a sudden BGE isn't responsible. They misquote the flower branch thing. If you really get into the details, there's like 24 reasons of why flower branch exploded, and it's a 50-year-old system, and they say maybe it wouldn't have happened if there was an external regulator. Well, you know, I expect when BGE installed an internal regulator, they did a proper job. Just as I expect the guy in the garage did a proper job when he changed my brakes. And I'm not responsible for them doing a bad job, and I don't have to have my neighborhood ruined and have other potential safety problems because they want to get rid of the liability. They don't want to be responsible if they screw it up in terms of the installation. Equity issues. I'm happy I have an internal regulator, but I'm embarrassed I have an internal regulator. And people who don't have the income I have and a different color skin of I have to have an exterior regulator. It just doesn't make sense. And there are cases and cases you could point to, Union Square, Bolton Hill versus West Baltimore, where if it's a white, more affluent neighborhood, I guess we'll have to install them internally. If it's a black, less affluent neighborhood, we can install them externally. Threats to terminate gas service is unconscionable. It's not allowed, and they just bullied themselves as they bully themselves through. Economic considerations. The public Office of Public Counsel, I'm sure, will provide you the information related to it. But why are we spending $15 billion when they didn't spend diddly since 1834, when they put the first line in? They didn't reinvest in it. And now they want the user to pay for a system that doesn't necessarily make sense, that they haven't documented the necessity of completing the whole system. My understanding is that the reason we had our lines changed, and it's not all of Bolton Hill, it's two streets in Bolton Hill, they changed the lines. And why did they change the lines? I found out. The sniffer vehicle found there were gas leaks. They didn't change it because they had this $35 billion-dollar system. They changed it before it exploded and accelerated it. And I don't know if they're installing it because they're trying to recover the money that they're going to expand. They want to enrich the stockholders, or because it's a critical necessity. And finally, communication. It was interesting. The AGA, who is supportive of their client and they're the lobbyists for them, is in favor of BGE's programs, as is the subcontractors. If I was a subcontractor, that's my livelihood. Sometimes I pick the wrong business to get into, and some of these companies may. I do feel sorry for them, but that's, we're not going to build things that we don't need to keep contractors done. But the total lack of communication with the residents of the city of Baltimore, and that's a strong point I read in the AGA report, that they have to communicate with the citizens, and that's what they have constantly not done, and kind of dug their own hole and got everyone all flustered and angry because they just failed to communicate. Thank you.
Thank you, sir. Yes, ma'am.
Good afternoon. My name is Sandra Seward, Seward. I've been a resident of 204 Warren Avenue in Federal Hill for the past 35 years. I want to share the story of my arrest on June 22nd, 2023, on my street for peacefully protesting the termination of a neighbor's gas service. The neighbors did not grant permission for BGE, the utility, to install an internal gas regulator at 413 Warren Avenue. That day, a group of citizens gathered on the street starting at 7 a.m. There was an area on the street that had been designated for penetration, and the contractors were ready to commence the work at approximately 9 a.m. Due to our presence, the work could not be started, and a standoff developed. The contractors were soon joined by other officials from the utility to discuss the problem that was developing. Then they were joined by numerous uniformed Baltimore City police officers who then were supplanted by their superiors, captains, majors of Baltimore City Police that were identified by their brass epaulets. These discussions and the battle lines, the city citizens were on the south side of the street, all the officials, BGE, the mayor's office, the police department, all stood on the other side. And this continued throughout the morning. This group was later joined by members of the mayor's office, Monzi, and the city councilman. Our group continued to stand fast in the area until 4:30 p.m., when it became evident that a decision had been made by the utility, and subsequently the mayor's office and the police department and the three of us who refused to leave the area were to be removed off the site and arrested. The decision to forcibly arrest us by using zip-tie handcuffs and aggressively, they pushed me, taking us in a police van to Baltimore Central booking, was an example of the influence and the extreme abuse of power that the utility company felt they had, and it was supported by the mayor's office and the police department. The mobilization of the police to this situation in light that the police department is not responsive in my neighborhood to calls for action regarding traffic disruptions, drug distribution, kids coming up to the park, dismantling the benches at the park, illegal dirt bike aggression in the area, is an obvious irony and completely maddening to those of us that live in this area day to day. The fact that the utility coerced the mayor's office and police department to hold the three of us overnight 19 hours in central booking further underscores the power and influence the utility holds in the management of the city government. I've lived there for a long time, and I'd never seen anything like it. We had an open case with the PSC. We had filled out the forms, as had my neighbor, Steve Topping. When we got out of jail the next day, the Friday, that was the 23rd, on the 26th, I was greeted by a group from BGE. Now they were turning off my gas, okay, that morning. 5 police officers arrived to do so. And I said, I'm not getting arrested today, okay? I said, but I have an open case with the PSC. And Mr. Topping had gotten a letter that said, since the case was open, you can't turn off our gas. He had that in writing. They went to the other side of the road, talked about it, and came back and said, we're doing it anyway. So that day, the 26th, my gas was cut off. Our advocacy on June 22nd propelled this citywide issue. It brought to light the inequities throughout the city. It actually ended up being a good thing for this cause. Citizens are now educated regarding the long-term impact of the utility company's flawed plans for external regulators. This hearing allows us to educate it all about what we need to do, what's right for our city. It is a crisis that is an opportunity. On June 22nd, why were we, the citizens, ignored and held responsible for protesting a flawed policy? As a result of this journey, the level of understanding by our local leaders, numerous neighborhood associations, and most importantly, all the citizens of the city, notwithstanding their location, have been enlightened by this situation. I'm not a researcher, but the team that I am part of in this city has done an amazing amount of research. We know the truth, and we desire a thoughtful outcome based on data, not intimidation, force, or power. Thank you.
Thank you. Yes, sir.
Yes, thank you, Commissioners, for the opportunity to speak. My name is Stephen Topping, Topping. I'd just like to highlight on some points that were in my written comments. BGE has already advocated that Baltimore is not an appropriate city for installation of external regulators, and law has been enacted in that regard based in part on their advocacy. Gas regulators are part of a meter assembly and are part of meter equipment. A gas regulator is a defined part of gas meter assembly. 6.1 of their tariff does not apply only to meters. It applies to meter equipment and prohibits placement of meter equipment beyond the property line of the homeowner. That's the front facade of most city row houses. End of story. Additional BGE documentation confirms that equipment, including regulators, not be placed beyond the property line. Also in the tariff, discontinuance of supply for cause 2.4. Gas turnoff reasons do not include the customer's refusal to have an external gas regulator installed. My gas was turned off without notice in a retaliatory manner on the day of the circuit court hearing, requesting a temporary restraining order. Also in the tariff, reasonable access does not imply a right to install new equipment that is not required by law, that presents safety risks in an urban environment, that requires major construction on streets, sidewalks, and drilling significant holes in houses that can potentially cause irreparable damage, especially to our historic homes. And that requires municipal construction permits that the property owner has not requested and have not been granted. BGE has already installed many internal regulators, which will remain. BGE has openly stated that it will not reverse regulators that have already been installed internally. Larger issues of safety data aside, that should tell the PSC that internal versus external installations is not a significant safety concern for BGE. BGE is required to abide by local laws and regulations. The IBC mandates and BGE accepts in its policies and documentation that BGE is not exempt from local regulations. We are subject to stringent historical preservation obstacles. CHAP has now, far too late, placed on record that they oppose external placement of regulators. BGE must not be allowed to benefit from or circumvent regulations that bind us as homeowners in Baltimore City. BGE asserts external regulators align with laws and regs in PA and DC and is a best practice. PA allows internal placement in locally and nationally designated neighborhoods, historic districts, and that's in the 52 PA Code Section 59. DC municipal regs state the utility shall employ best efforts to avoid installing gas equipment on the principal facade and to place the equipment to the rear and secondary facade. These facts are notably absent from BG&E's comments submitted to you, the PSC. All neighborhoods and homeowners should have 24 months to decide, finance, and prepare for electrification. The fact that my gas was turned off in one day without notice really doesn't give me much time to switch to electrification. Also, as homeowners, we do not want medium or high pressure gas, and we certainly don't want to pay for it. OPC has advocated for a 24-month hiatus for certain neighborhoods to prepare for electrification. That should apply to all neighborhoods and all homeowners equally. No new regulators should be installed for that period of time unless homeowners want it and sign for it. It cannot have been intended that BG&E's desire to install external regulators for its own business purposes would be allowed to take precedent over. And it's the unified concern and opposition of Baltimore City government and related agencies as recently expressed. The OPC, which advocates on behalf of those who are ultimately charged with paying for BG&E's desires and which is strongly opposed. Widespread and ever-growing community opposition to external regulators and historic imperatives, all of which should outweigh BG&E's desire in these specific circumstances. In summary, everyone has weighed in before the Maryland legislature on safety and risk of external gas regulators in dense urban settings. FSMA has, BG&E has, the PSC has. The Maryland legislature has set the policy for gas regulator installations. It does not include a private utility company mandating which single-family homes get internal and or external regulators, period. Thank you.
Thank you. Yes, sir.
Hi, my name is Eric Holcomb, Holcomb. I'm the Executive Director of the Baltimore City Commission for Historical and Architectural Preservation, CHAP, and I'll just read you a few paragraphs here. The Commission for Historical and Architectural Preservation was created in 1964 to preserve the historic character of the city by guiding the rehabilitation of buildings and the revitalization of city neighborhoods. Currently, the city has 38 local historic districts containing more than 15,000 structures and more than 210 Baltimore City landmarks. Article 6 of the Baltimore City Code requires that CHAP review and approve all exterior changes in local historic districts, including the exterior installation of gas regulators. The exterior installation of gas regulators detract from the historic character of historic districts and involves the boring of holes in historic fabrics such as brick, marble, or limestone. CHAP and the residents of Baltimore's local historic districts work extremely hard to protect, maintain, and enhance the historic character of their neighborhoods. The installation of these gas regulators, especially on the front of row houses, harms the careful, sometimes decades-long work of the neighbor associations and CHAP. Thousands of locally designated properties are located in dense urban neighborhoods with facades that are set back less than 10 feet from the street, and many of them only 3 or 4. The exterior installation of these regulators reduces the curb appeal of historic neighborhoods. From an historic preservation and neighborhood revitalization perspective, exterior installations of gas regulators work against the mission and goals of CHAP. So please consider these historic preservation issues by allowing for the safe interior installation of gas regulators that will help preserve the character of Baltimore's historic districts. And also, please provide us with clear guidance on the safety issues, including the real threat of damage to exterior regulators by vandalism or vehicular damage. Thank you.
So, a couple questions. First off, I think you said you had 38 specific neighborhoods that are...
We have 38 neighborhoods that are local historic districts. We have approximately, I would say, 86 National Register and local historic districts in the cities of Baltimore. That's more than a third of the housing stock in Baltimore. And we could double.
No, I understand it, but so could you provide to us the 38, the specific listing of the 38 designated neighborhoods, so that we just have that for our record?
Sure, I can email it to one of your staff.
And that's fine. You can send it to the executive secretary, so that'll be fine. Second question, just so I understand your authority. I'm familiar with the city of Annapolis and its counterpart, I guess, to your organization and its authority over what people can do to the houses that are located in the historic part of Annapolis. Is your authority similar or different? I mean, their authority essentially is that you can literally do nothing without their approval to the exterior of your house if you're in that historic area.
All exterior changes in a local historic district needs to be reviewed and approved by our office. There are a few exceptions. Maintenance, no. Fix it, repair. If you want to put down a different tread on your wooden steps in the back, that's fine. And we do not get in the way of the housing official when he deems something that's an imminent threat to public safety. Those are like the only three things that we don't review.
All right, but pretty much everything else,
everything else,
you have say-so over what happens to the house.
Correct.
So, okay.
So did you weigh in on BGE's proposal to put regulators outside the homes of these historic buildings?
We have been dealing and working. We have been working with BGE probably for the last several years. We had long, detailed conversations before the Bolton Hill got their regulators. We had a public hearing, informational hearing, back in March of 2022 about this. I was in contact with your staff about it, so we were having contact when that happened. So there's been a lot of things, but did we weigh in on a plan? No, I don't know what the comprehensive plan is.
Okay, so your office has not approved any changes to the structure, the external structure, by installing an outside regulator.
We have reviewed and approved BGE applications for the installation of exterior regulators. Yes, in local historic districts, under the assumption and guidance with the PSC that this is a safety issue and safety trumps preservation, which I'm finding out that may not be the case.
Okay, and then when was that decision made?
I think that we had our informational hearing on March of 2022.
Okay, and did you issue a paper decision on this?
There's a letter of the hearing, there's the video of the hearing, and there are what we call authorizations to proceed for the individual houses that received these.
So can you share that with the commission as well?
Sure.
Thank you.
Can you email me everything I'm supposed to give you? All right.
Yes, he'll in touch and let you know how to let us know. Okay, I think that's all of the public commenters that we have on our list. So we're now going to move to the Office of People's Counsel. So I just ask the folks at the table to move back into the audience and ask the representative of OPC to come forward. customers. Oh, sure. So just reintroduce yourself for the court reporter. So.
Good afternoon, David Lapp, LAPP for the Office of People's Counsel. And go ahead.
Mark Shebist, Assistant People's Counsel. Last name is spelled S-Z as in zebra, Y-B-I-S-T.
Michael Sammartino, Assistant People's Counsel.
Thank you. We appreciate the opportunity to be here today, and it's been a long day, and I'm going to try and work through. I had 5 minutes. I have a couple additions based on some of the discussion today, but I'll try and keep it close to that and
we're
be available for any
your
questions.
Time. We're fine.
The commission is presented here a narrow issue about where new regulators should be installed. But that question cannot be entirely divorced from the larger issues of state policy on the economics of gas, including the impact on ratepayers, the safety of gas generally, and the future of gas, including Maryland's climate goals. These issues are not why we're here, but the decisions made in this proceeding can't be divorced from those issues. I'll focus on 4 points. The first, I want to discuss a moment the placement of gas regulators as a safety issue. And what should be clear is that from all the discussion today is that gas poses inherent safety risks. The pictures we saw this morning that BGE displayed on the screen show the inherent risk of gas. And those risks don't disappear regardless of whether the regulator is placed inside or outside. All we're talking about here are incremental differences in safety. Our analysis of the data confirms that the damage from indoor gas events causes greater property damage and more safety risks to people, even though there may be fewer events indoors than outdoors. So we think it's appropriate for BGE's base policy to install regulators outdoors. We have to recognize, though, that BGE has installed thousands of regulators indoors up until very recently. We heard February of 2022. And that practice is accepted under federal PIMSA regulations. Given that acceptance by PIMSA, we make recommendations in our comments for how BGE should have a more flexible, transparent, and accommodating approach that enables exemptions to outside placement when those exemptions continue to meet the PIMSA standards. In any case, gas leaks inside or outside, whether at low pressure or high pressure, are extremely dangerous. Any work or changes to the system, even when overall they may reduce risks, those changes themselves contain risks. BGE acknowledges in one of its discovery responses that a gas regulator itself is, quote, one potential source of gas leaks. This does not mean that regulators are a bad thing. They're a good thing. They reduce pressure. But it's the point is that any of these changes can introduce additional risks, maybe lower, maybe higher. And a regulator is just one measure that gas companies must take to protect customers and the public from the inherently dangerous activity of consuming gas. Second, the safety issue is just one of a number of reasons customers should be given time to consider their options, including electrification, rather than remaining on the gas system. Customers may want to electrify for safety, economic, health, or environmental reasons, or because of state or federal policy is moving in that direction. Electrification is the only way to eliminate the risk of gas in the home. This is why we focus in our written comments on providing customers ample notice, including a time period in which BGE delays continuing replacement of the high-pressure mains which require the installation of the regulators. Customers must be given notice and time to consider their options, including electrification. The 4 to 6 weeks BGE has in its timeline in its comments is nowhere near enough time. And BGE's responsibility for maintaining a safe system continues throughout that delay. This morning, BGE misstated several things about our comments. We are not suggesting that low pressure system exists indefinitely. BGE said that there will be a ton of leaks with a 2-year delay. But we should be aware that as of July, last month, July 2023, there's 839 miles of low pressure pipes on BGE's system in Baltimore City. 839 miles. BGE's replacement plan lasts another 20 years. So it must take actions now to address those tons of leaks with or without a delay. It's moving at about 42 miles per year. So there are many, many miles of potentially leaking pipes. So it must address those. It must address those safety issues now. It can't wait till year 17 or 18. A slowdown or delay in the replacement of the mains does not mean that all of BGE's work must stop. For example, as discussed earlier this morning, it can accelerate its rate of relocation of regulators for multi-unit housing consistent with the Flower Branch Act. Third, BGE's comments explain that the cost differential of placing regulators outside rather than inside is relatively small. They say $5 million in 2024. I want to be clear, this is important because there hasn't been a lot of discussion today about the cost. That $5 million in 2024 adds up every year. My colleague here described it yesterday as if you decided you were going to do a pull-up every day and add a 5-pound weight on your back every day. It gets pretty heavy pretty quick, and that's the way this $5 million adds up. Right now, there is no economic test for any one of these investments. Every one of these houses is invested in on a case-by-case basis, much like much of the gas infrastructure investment. There's not a more holistic look at it. That's not this proceeding, but the gas regulators, each individual house is another investment. If a customer wants to electrify, and it has this work done, the entire cost of that work, which means the service line, the meter, the regulator, and all the labor that comes with it, all that can be avoided if the customer is going to electrify. If the work is done and the customer electrifies, those costs are stranded. They are left to other customers to pay. We did some analysis based on discovery, and I'm happy to provide additional information following the hearing because some of this is not in our comments. We weren't able to pull it together by the deadline on Friday. But what it shows is that the average cost of the regulators, the meters, and the service line for each individual house, including the labor, is since June 2021, is about $6,343. Now, at the average customer's rate of usage of gas, 55 therms a month, it takes about 10 years for a customer to pay off that $6,343. But that's not actually the whole picture because that doesn't include the return on BGE's investment for those costs. Once you add that in, the cost comes up around $23,000 per household. The numbers that we received in discovery show that in 2019, and I'm just again talking about the services, the meters, regulators, and the labor to put in that work. In 2019, 140.7 million. 2021, 122.02 million. 2020, that was 2021. 2022, 133.4 million. And the average cost doesn't necessarily reflect the entire cost. These are very case specific, so some are a little low and some are as high For some neighborhoods, it appears that the total costs are upwards to $30,000. So these are numbers that we should be looking at closely as we consider these investments. Again, each house is an investment, and these costs can be avoided. The fourth point, and I'm wrapping up here, is that you heard BGE this morning explain that its flower branch activity is separate from Operation Pipeline, from its work, this replacement work. BGE is setting its own priorities internally, and it can change those priorities. It's not a coincidence that BGE's priorities prioritize what's most beneficial to its investors, and that is the capital investment, getting the costs into rate base, and all these costs go into rate base. Repairs generally do not. That's not a coincidence. The PSC, you have authority to supervise and regulate the public utilities in the public interest. The PSC, we ask that you consider the rate impacts of these investments in addition to the safety considerations. The helmet analogy we heard earlier is an important one. We can buy a helmet that meets the standards, or we can exceed those standards, and every year there's going to be a new helmet. I'm a bicyclist. You see these new helmets, they get safer and safer all the time. And of course, we want to invest in safety. That's very important. That's a top priority. But with gas, there is nothing that is safe. If we're going to look at what's most safe, that's electrification. And so we have to make balanced decisions on these issues, and we can't do it disregarding the costs. The impacts of a 2-year delay are outweighed here by the public's interest in receiving advance notice of BGE's infrastructure projects that directly impact their opportunities to take the most safe action of electrifying. We appreciate BGE's concern about safety, and we appreciate all your time and attention to this challenging issue. And we're here and happy to answer any questions that you have.
Mr. Chairman?
Yes, sir. Go right ahead.
Yeah, okay. So I'm going to repeat what I said to Mr. Vignarajah, because I think it's important for this to really be embedded. As you remember, Delegate Dana Stein and I were big supporters of electrification, but we weren't able to convince our colleagues to include it in the Climate Solution Now law, which is unfortunate from my point of view, but that's the legislative intent. And so while I completely agree with electrification as being the future, I just don't see it as directly our policy call here at the Public Service Commission. I understand that the law that I wrote, which I had to be reminded by my new best friend, Commissioner Richard, that we are instructed by the environmental laws to bear in mind climate change and the findings of the IPCC when making decisions with respect to utility regulation, and I of course take that very, very seriously. But the STRIDE program in particular is a controversial program in the legislature. There are many people, who oppose it, and many people who support it. I'm not going to debate that issue here today, except to say that this is a very large conversation that we all have to have. I'm not convinced that we should have a moratorium in order for us as a commission to do our job in making sure that the policy comes out correctly. I understand your motivation in it, and in many respects I agree with it, but I need to be convinced that we have to do a moratorium. And so while BG&E had an opportunity to explain why they thought it wasn't a good idea, I'd like to give you an opportunity to expand upon why you believe, with specificity, as to why you think we ought to entertain that. So thank you, Mr. Chairman.
I appreciate the question. It's a good one. the electrification provisions that as I recall, that were not enacted were about requiring electrification standards for new buildings. Right. That there is no law that prevents customers, of course, individual customers, from choosing to electrify. And customers are doing that. We've done a report available on our website if you haven't seen it, but that shows that since 2010, we have a graph showing from 2010 to 2020 that customers, that gas is already losing market share to electrification for home heating. So heat pumps in particular are growing in market share, and we have heat pump technology that is quite advanced right now, and that can go to cold temperatures and does not require backup heat. So that is happening. And this commission does have, its primary role is to protect customers from unjust and unreasonable rates. And all of this rate impact from gas, I don't think that the commission can go about setting rates and approving gas infrastructure projects that are detrimental to ratepayers, to customers, over the short or long term. BGE's distribution rates have more than doubled since 2010. They are going to continue to rise, and that's separate and apart from commodity cost. You can just do the math and see, and we've done that math in our reports. And we think the commission has a duty to consider that as it goes forward. So we talk about electrification as an option, but we're not asking the commission to require anybody to electrify. We're asking the commission to consider the infrastructure spending that gas companies are doing and the impact that electrification that is happening sua sponte, on its own, is going to have on those rates. And we can see that customers are already moving away from gas to electrification, which means that those costs have to be recovered from fewer customers. And we can also look at where policy is going. And policy clearly is going in the direction of electrification and reducing greenhouse gas emissions.
Well, I'm sorry. Go ahead. I thought you were
So there's two things driving electrification that are not being driven by the commission. One is just technology, and the other one is policy. And both of those things mean that customers are leaving the gas system, which means that gas rates are going up, up, up. As each customer electrifies, they're buying less gas, which means that rates increase for everybody else, and it creates the real possibility, if not substantial likelihood, of stranded costs.
And I agree with virtually everything that you have said, but we as a commission are obligated to text of the legislatively mandated requirement that we keep greenhouse gas emissions in the back of our mind, to have our decisions be informed by that. And yet I have to say that, we have the stride law that really directs a great deal of what we have to do. And so, as my good friend and former antagonist, Commissioner O'Donnell, would point out, it's our job to follow those stupid laws that people like me passed.
Yeah, I'm happy to address the stride statute.
Sure.
Specifically. The stride statute says it's all in the permissive. So first of all, it says a gas company may file a stride plan. It's not obligated to. It also says the commission may approve a stride plan. It's not obligated to. And more than that, the commission has to find that the stride plan is prudent and is reasonable. And we're not here suggesting that BGE should just cancel its stride plan. We've, as you all know, we've asked for a gas planning petition. We think that The whole picture needs to be examined, and that's not what we're doing here. But there is no obligation of the commission to approve a stride plan. There's no obligation on the part of a utility to do one. The gas utilities, mind you, do have an obligation to provide safe and reliable service. And we're not saying that there isn't aging infrastructure that may need to be replaced, may need to be repaired, may need to be shut down. But that all needs to happen in a plan. Right now, we're sort of blindly moving forward, and we're making decisions, or decisions in the past have been made on an asset-by-asset, case-by-case basis without looking at this bigger picture. These gas regulators are depreciated, and the meters are depreciated over 35 years. The service lines over 50 years. Does it make sense for the commission to be approving infrastructure going in the rates when the state is saying, hey, we need to get off gas in order to meet 60 by 31? We can't be consuming the gas we're consuming right now. By 2045, that's before the time, well before the time, this infrastructure is going to be depreciated. So it's hard for me to understand how it can be reasonable and prudent to be approving these investments that are based on an expectation that gas consumption is going to continue today at the same rate 50 years from now. We don't think that's reasonable and prudent.
Okay, thank you very much. Thank you, Mr. Chairman.
Okay, Commissioner O'Donnell.
Thank you, Mr. Chairman. So I've been waiting to follow up with you, Mr. Lapp, on this point. It's not the first time we've had this discussion. It's not the last. And you see two former officers of the legislature kind of like mind here, of different ends of the political spectrum in this regard, I think, without being presumptuous, I hope, Commissioner Barbaday. I know that we all take an oath of office, and that oath of office says that we obligate ourselves to effectively, to faithfully, diligently and faithfully, without partiality or prejudice, execute the laws of the state. And the kind of practice du jour, and not just in state government, but in federal government and local government, is to kind of downplay the ones we don't like and upplay the ones we do like, and that kind of like obviates our obligation to diligently and faithfully, without partiality or prejudice, execute the law. Because we don't get to pick and choose, right? So we have to, it might be popular to say we're going to come off gas, but we have to do that in a measured fashion. Certainly not in this proceeding. We have other proceedings. We have stride proceedings. We have rate cases. We have other things. But this, where you stick a regulator, is going to determine the future of gas in the state of Maryland and its policy? How in the heck does that diligently and faithfully, without partiality or prejudice, execute the laws of the state? It doesn't. I don't care. There's just no way it does. So I know you have a charge to execute the environmental laws, but there are safety components of the STRIDE program, not the least of which is methane leakage, not the least of which is water intrusion into the systems, not the least of which killed a young person in Amherst, Massachusetts. And thank God it wasn't a daycare filling up with gas when there were kids there. Because I don't think you'd be singing this tune right now. So what say ye?
I completely agree that we should be operating in a measured fashion, and that's why we've asked for a gas planning proceeding, because there is no planning going on right now, except really what's going on at the offices of Exelon and BGE and AltaGas and NiSource. That's where the planning is going on.
So you and I understand the whole. We've not the first time we've had this discussion, but here's why I think it's irresponsible to have it like this. With all due respect, it's irresponsible because these citizens who have valid concerns, who are obviously upset, are being played upon with their emotions are being played upon by those who say the Public Service Commission needs to outlaw gas expansion. Baloney. The legislature didn't say we could. The legislature said we could have a stride proceeding. The legislature did say we should upgrade infrastructure. Take a look. This is one of the few laws where I saw a very clear statement of intent, I think, if my memory serves me correctly. But these poor people, they're being preyed upon as if we have the authority to step in the shoes of the legislature and overturn what their clear intent was. One of the legislative leaders who said they tried didn't get the imprimatur of the legislature to do so. And so I think it's irresponsible to play upon people's emotions to advance your cause. Maybe make yourself look popular, but it doesn't do anything for the public interest. Zero. What say ye again?
This is we have. I would just say we have sincere concerns about the customer impacts of the infrastructure spending, about the stranded costs, which you don't have to take my word for it. The Wall Street Journal has reported nationwide the potential for $150 to $180 billion in stranded infrastructure costs. I'm hoping I can address the Amherst.
Like the Public Service Commission doesn't have that concern. We certainly have that concern. That doesn't obviate our obligation, though, to faithfully and diligently carry out the law without partiality or prejudice. We have that concern. It's part of our bigger charge.
If I could just address the Amherst, Massachusetts issue, and that's the explosion that occurred, I think it was in 2018, September 13, 2018. And this Amherst explosion, and you saw the pictures from BGE this morning, and this was due to an overpressurization event. And this is often used as a reason why we need to change the low pressure system to a high pressure system. And to me, yes, there was a problem with high pressure gas getting let loose on a low pressure system. But this really shows the challenge in dealing with anything with gas, because what was going on there that led to that accident was the work that BGE is talking about here. They were transforming their low pressure system to a high pressure system, and there was a contractor error that left a gas sensing device on a low pressure pipe that was disconnected, and then signaled that when it was disconnected it dropped to zero, and it ended up sending high pressure gas into a low pressure system.
I get it.
Commissioner O'Donnell, let's let him finish the question first. Finish the answer.
I guess I don't want to get into a debate about it, but I want to give you the site because the story is there. You can see that it's a contractor error. This wasn't a low pressure system just sitting around not being worked on. This happened because of an error in how the work was being done. Now, I'm not suggesting that that's going to happen here. The site is 85 Fed Register, 61,000. 097 61097.
I know what happened. I get it. You're not wrong. You're correct. But I will tell you that these systems, when they do overpressurize, are inherently unsafe, and there is no fail-safe to stop them like a pressure regulator has, which provides relief protection. There is none. There are other safety issues as well, including methane leakage, leaky systems, water intrusion. I mean, these things operate at 7 inches of water column, if you want to talk about engineering terminology. 7 inches of water column, you know, I can burp more pressure than that. So, bottom line is, I know what happened technically. That's not an issue here. The issue is these systems are old, antiquated, and need upgraded, and that's the position of the legislature. And until such time as they change that, I just think it's irresponsible for officers of this state to run around giving people false hope that we're going to somehow, the PSC has the authority to outlaw gas usage, because it doesn't.
Respectfully, Commissioner, OPC's position is not that the PSC has authority, and we're not asking the PSC to outlaw gas usage. We are simply asking the Commission to consider the impact on customers, as well as the state's climate goals and where technology is going in approving projects as you go forward.
Every day. Thank you, Mr. Chair.
Commissioner Richard.
Since the hour is getting pretty late here, I don't really have any major questions, but I did want to kind of go to the OPC recommendation. I would call it your 4-point roadmap to a possible way of moving forward. Do you have anything you would want to add to the record as far as how we would go about that? Do we is it just in an order, or do you see a work group of some kind? What would be the next steps again to as expeditiously as possible, provide the guidance and the direction that we're being asked to provide today by pretty much all the parties. But again, as I stated earlier, I do like this approach, but I just want to make sure we have in the record how we would proceed.
I think we think that the Commission can go ahead and make some preliminary decisions, but that there are issues that are probably better dealt with in a longer term. Like if the Commission would agree on a 2-year moratorium, we think there should be some additional work with stakeholders with the Commission's guidance on what that might look like in terms of what work should continue to proceed, what should be the goals of leak detection, and other matters people might raise.
Okay, I appreciate that. Just so we can flesh this out, it might be something again the Commission might want to consider again your roadmap. But if you have any post-hearing advice on that, I would make a request for that.
I would say we certainly were, given all the other things going on before the Commission right now. We were somewhat rushed in terms of pulling together our comments, and would be happy at some point to supplement them, although we have other deadlines pending as well. So.
Right. And just in some of the, are there areas of cost that you're particularly concerned with? I mean, as we look at this program, we've talked a lot about just the communications and the outreach effort, and the fact that we are here today because there seems to be just, something that's really gone awry. I mean, we have just a widespread opposition, and that may have led to a lot of costs, additional costs to the program proceeding. And then there appears to be a lot of damage to homes that needs to be addressed. And I'm not really sure if this is already inside the budgets, or if we're looking at additional costs that homeowners may be owed, again, to repair some of the damage. Are there any comments you have on that we should be thinking about at this point, or other areas of cost recovery that, again, you'd like to alert us to?
Nothing jumps to mind, and I'll be. We are very concerned about the anecdotes that we've heard about damage to customer homes, about the BGE's responsiveness. A lot of things, and we frankly have not had a lot of time to dig into individual cases. but certainly think that those deserve a closer look, and there may be cost ramifications of some of those issues for sure.
Okay. And I just want to state for the record, I know there's been some discussion about what we, should be doing as far as like state policy, but I would just like, I think you've made some good points. OPC has made some good points in the past about our enhanced, I guess, requirements under 2-112 as far as our responsibility to supervise and regulate utilities. And I believe in that. We've been recently given very direct, clear direction from the legislature that we are to consider climate change, that we are to consider the IPCC, and that we are to consider, in all of these state policies when we make any decision regarding our responsibility to supervise and regulate utilities. And would you agree that what we're doing today falls clearly under that umbrella?
Absolutely. Your decisions here are affected by everything in 2113, including the consideration of the environment, and we are certainly appreciate the Commission taking this issue up, and we hope you do consider that component of your obligation in moving forward on this regulator issue.
Great, thank you, and thank you for correcting the site. So it's 2-113.
2113.
Okay, sorry. Thank you. Appreciate that. Thank you, Chair Hoover.
Commissioner Slushman.
Just really one question. Hopefully it's just one question as opposed to follow-up questions. If we don't follow a 2-year moratorium on replacing the mains, what would OPC's position be in terms of can we have, for example, a moratorium on regulators? Can you replace mains but not implement high pressure right away? Is there sort of a path forward that doesn't necessitate replacement of or deployment of the regulators, and then if we do, I'm assuming you favor flexibility in terms of making decisions about where it's placed, whether inside the home or outside the home.
Yes. I'll just the last point first. I think it might be page 18 in our comments,
Right,
where we lay out what we think should be considerations in terms of exemptions to a base policy of installing them outside.
Okay.
As far as of alternatives in lieu of a delay or a moratorium, I think we would want to look more closely. We haven't had the opportunity to look at it too closely of what it would look like to have essentially two systems going. I think there could be costs, high costs associated with that.
All right.
I think that may be the only alternative other than requiring everyone to have regulators either inside or outside.
Okay. If you can think about that. I know we gave you a very short window for providing comments. So.
Absolutely.
Okay, thank you.
So one question for me, and you referred earlier to anecdotal comments. One of the things that came up during the course of the day was this issue of BG&E terminating people's gas service for those who refuse to allow the contractors into their house to do the work. Now, obviously, and they did this under the auspices of the tariff. The tariff was established, I'm assuming that provision was put in there mainly for safety reasons, to make sure that the equipment was available and could be repaired and things like that. I'm not sure it was envisioned that it would be interpreted the way it's been interpreted in this situation. So have you had any thoughts about ways to maybe refine the language of the tariff to still maintain its purpose in providing safety and access to the equipment without necessarily maybe having it applied the way it's been applied in this situation.
I guess the the question is whether the regulators are a new regulator is new equipment or whether it's a modification of existing equipment, and I think we would agree that the tariff is ambiguous on that point, and clarity would help everybody. I think that if the commission would move to adopt a more flexible policy, more aligned with the PIMSA, with PIMSA requirements that do allow indoor regulators, that may obviate that concern. And so if I think the reading of that tariff is furthering, the argument that they can't come in to do the installation, and so I think it might the problem might be ameliorated a little bit if the commission would require BGE to be more flexible in the exemption policy, but it probably should be clarified to address the regulators as well.
Okay, good. All right. So why don't you stay there, and why don't we have staff come forward to make the final presentation of the day. So. All right, Mr. Spivak, go right ahead.
Thank you, Mr. Chair. Good afternoon. Mr. Clemenson will be doing most of the speaking for staff in terms of giving staff's presentation. I would just, for the record, I'm Lloyd Spivak, staff counsel, and with me is John Clemenson with the Commission's Engineering Division in their gas pipeline safety program.
Okay.
Afternoon. In preparation for the hearing, staff conducted performed a review based on the criteria set forth by the Commission, the 5 items of interest, which involved some data requests to the company and some outside research. We provided comments on those 5 criteria. As most of the stuff has already been addressed, I won't delay or reiterate those items. However, so I would say we are open for questions at this point in time.
Okay, fair enough. Commissioner Barve, any questions?
Nope, I'm good.
Commissioner Richard.
Wasn't expecting that. So
Yes,
let me see if such. But I probably wrote a few down on my notes here. Why don't let me open the testimony and I will get.
Commissioner Sussman, go ahead.
Yeah.
And I'll come back to you.
Okay. Yeah.
Okay, so Mr. Clemenson, are you familiar with the construction manual? Because I think you actually attached it to your testimony.
I attached the piece that was in reference to the regulators being installed that BG&E had provided.
Right. So, and my understanding is that staff participates. It's the staff participate in dealing with exemptions only for multi-family regulators, or would you deal with all exemptions for all customers that would be having regulators placed on the outside of their homes?
We were only given the authority for the multifamilies.
Okay.
However, if it was decided that that the commission wanted us to take and handle single-family homes, we could also do that.
Okay, but that's not something that you do right now.
Not at this point.
Okay, but you're familiar with the policy that's in place that BGE has developed.
Correct.
Okay, so if I can take you to page 3 of that policy, we had talked earlier
about, I think we talked with BGE about any exemptions. And I thought that there was a discussion about how there wasn't a policy for exemptions, but I'm still still going through lots of paper. So this actually was something I had a chance to look at. So this does seem to have a list of potential exemptions that could be applied when considering whether to allow a customer to have the meter installed inside. Is that your understanding?
Well, before we get there, I'm assuming you're referencing BG&E's
That's
process?
That's right. So it's exceptions to the BGE outdoor meter assembly location policy?
Okay, the AMBE, okay.
Okay. So do you have that?
Yes.
Okay. So among them is a National Historic Landmark Registry. So there is some sort of discussion about that. But I actually wanted to draw your attention to number 6, where the location extends beyond the customer's property line or utility right-of-way. So do you see that?
Which page is that? Is it on?
That's on page 3.
Page 3 of 12? Or
Uh,
are we back at the procedure?
Well, I mean, do I have 12? I have 10 pages, so
Okay,
it's...
so that's the actual installation procedure, okay.
That's right.
All right, sorry. Page 3. Yes.
Okay. So, among the considerations is whether it will extend beyond the customer's property line or utility right-of-way. So is it your understanding that when considering location of outdoor regulators, whether it is outside the customer's property line is a consideration in giving an exemption for bringing it inside?
According to what they have here, it is, but it also, from what I'm reading, it relies on that utility easement, so there could be some overlap.
Okay, so
there.
that's what, and the easement would be, is a sidewalk considered an easement for a utility?
It can be.
Okay,
It just depends on how the jurisdiction defines a utility
okay,
easement.
so I'm talking about Baltimore.
Right.
So in Baltimore, is a sidewalk considered an easement for these purposes? Or how does the utility get an easement for citing a regulator on a sidewalk?
I think I might give a shot at that. I
That's-
can't say I'm expert.
Okay.
But I think that would actually be a function of the utilities franchise. And for BGE in Baltimore City, that's going to go back a very long way.
Okay.
An old document, but it may very well be, a very historic sort of situation.
Okay.
So it's hard to say exactly what it would be.
And BG, I don't need you to get up and answer that. If you could actually answer that question, submit that to the commission, that would be incredibly helpful. Thank you. Well,
All right, you gotta, actually, go to
Just as a point of suggestion, after the presentations, there have been a lot of statements made.
Well, actually, I think I know where you're going. So my thought is that when we get done with staff, I was going to come back to you.
Perfect.
So, okay.
And then we can address your
Sure.
question.
Okay. We're fine.
That's fine. That's actually really all I have.
Okay. Commissioner O'Donnell.
Thank you, Mr. Chairman. Mr. Clemenson, thank you for being here. I think you and Mr. Spivak were there, the chief engineer at the time, some years ago when this issue was first briefed to the commission that we may have a problem in this regard. If I recall, and I'm asking to make sure that my memory, maybe not the greatest in the world these days, which has its pros and cons. But if my memory is serving me correctly, when this was briefed to us originally, I think our options were kind of characterized as bad and worse. Does that sound right to you? Does that ring a bell with you?
In what regards? Are we talking just the regulator and the
To our
placement
options
of?
to correct, in regard to our options to correct.
Unfortunately, that is not ringing a bell at
And
this
to
point
come
in
into
time.
compliance with the PHMSA requirements with regard to installation.
Well, as far as their requirements, I mean, obviously they have to follow those, as far as the installation of the
We
regulator.
didn't have an option there. They had to do it.
Yes, they have to follow whatever the regulations spell out in that regard. Yes,
Right.
there's no.
So there were no good options, is my point.
You could say that.
I think you said it. I'm just trying to make sure I'm remembering it correctly.
I don't recall saying it, but I'll default to your memory. Yes, it's been a while, and I've seen a lot of things in between. Sorry.
Mr. Spivak, and me too. Mr. Spivak, do you recall that, perchance?
I actually do not as well. And again, I'm happy to defer to your recollection on that.
No, that's fine. That's fine. Well, you don't have anything to contradict that. I think that that's kind of true, because I seem to recall, based on that, saying the day will come when people get up in arms and some enterprising people will take those emotions, which are honestly arrived at. These are good people trying to protect their interests. And it looks like government's stepping on those interests, as it so often has a way of doing, this way through the utility. But that someday the day would come when we would have the finger pointed at us and say, the PSC told us to do this, said we had to do it, when it was based on the premise that we didn't have any good options in the first place. And that's my point. I think that's true. I think we were told that back then, and it's unfortunate, but here we are again. And I tried to find early on in these proceedings today a kernel that would germinate with a little bit of hope and TLC a solution, but I don't know. We've been pretty far afield, and people's emotions have been cranked up, I'm telling you. So I don't even know if that's possible at this point anymore. But I wish it was, because not only do we have to consider cost, we have to consider safety, we have to consider the environment, we have to consider a lot of things. As you know, staff has one special interest, although you're probably the broadest of all, but still special. OPC has another, the advocates have another, the utilities have others. But we're the ones who have to balance all those interests, all those competing interests in many instances, to make a decision in the public interest. And I just say all that to say, I want people to, when they leave here today, to understand we're wrestling with a bear here. And we understand that. I've understood it from the beginning. You don't go through the legislature for 21 years realizing what's coming down the track, and it's not the light at the end of the tunnel. It's what's coming through the tunnel at you. So I want people to understand we're trying to do the best we can. We're trying to take into account your elected officials' wishes, because, again, as I said earlier today, they've been heard loud and clear. And I just, Mr. Chairman, thank you for indulging me, and I wanted to thank the citizens for being here today. Thank you.
Okay, Commissioner Richard.
Thank you, Chair Hoover. I just scanning over your testimony. Maybe you could just, kind of reflect on your testimony and what you've heard today. Is there anything, if you wanted to complete the record, or is there anything that you've heard today that you think bears, emphasizing something in your testimony?
I would say in that regards, is the two scenarios that have been discussed today quite extensively, the inside versus the outside, exterior versus interior. they both can be safe if they're done correctly. They must be installed correctly and they must be maintained correctly. Now, that being said, each of them have their unique inherent risks associated with them and consequences that are a little different from each other. And I know it's a great issue with the people that they don't want them on the outside of the house. They don't feel it's safe. But the PHMSA recently partnered with the Gas Technology Institute, which is GTI, to come up with the best practices for inside regulators. And basically, the practice was that, or one of the suggestions was to incorporate that in their distribution integrity management plan, which basically, in a nutshell, says know your system, look at the risk associated with the various characteristics of your system, and take steps to eliminate those risks and therefore reduce consequences. So that was the main thing that was gotten out of that. But again, inside there, they also did state that they felt that outside regulators, let me go to my, so I don't misquote them. It's on page 8 of it. It basically says the study also indicated there are several, well, not that one. Excuse me, where did it go? Oh, here it is, page 9, sorry. The study indicated 2 other items of note from the study are that GTI in table 17 of the report indicated that threats on piping upstream of the inside servicer are greater than the threats on the piping downstream of the inside regulator. And the risk of the inside regulator is greater than comparison to the outside regulator. Now, as part of the DEMP plan, it is, again, up to the operator to evaluate those risks and take the steps necessary that they feel to alleviate those risks.
I did have one point I want to raise that was kind of in response to something that was asked of the Commission earlier, which is that the service, not that the COMAR regulations and or the tariff be read to say that the service can't be turned off for refusal of allowing to BGE to install some form of new equipment. And I would say, as Mr. Lapp said, there is definitely some ambiguity in the language there, but I would urge the Commission to consider the ramifications of accepting that reading or moving that reading forward, because it would give people, it would give an individual homeowner the ability to basically stop dead in its tracks a whole raft of mains replacement that's scheduled to go on, and that might be detrimental to overall safety. So that's just a concern that you may want to consider there before, with respect to that reading.
Well, since I brought it up, let me follow up on that, though. I mean, I guess the concern I have is that the way the tariff has been interpreted and applied by BG&E in this situation appears, at least to me, to be somewhat draconian. And I'm concerned that, this not be used in that method. But I understand, your concern about it's going to be very difficult to try to word this tariff to sort of prevent those types of things, but still allow everything that needs to be done.
I think that's precisely it, Mr. Chair. Your concern is more than legitimate. BGE certainly seems to have used that provision this time around in a very strenuous manner. And it may not have been called for, but like I said, it is a balance that's going to need to be struck there. I just wanted to kind of give the other end of that.
So I guess the question is, it's not. I understand your concern about giving somebody sort of license to stop BG from doing anything that they want to do on the property. The question is, can they use the disconnection as the tool to force the customer to do something. And it may be that we can sort of find a path forward from a consumer protection standpoint, and we might want to limit the options for using that, or limit it to just, to non-payment, but still not make it clear that a utility has the right to go on to property to make changes, but not to have the two connected.
I'm not sure you'd necessarily want to go that far. For example, there are some situations where you definitely have safety issues that can happen. You've got situations where customers might be caught stealing electricity. And Comar has a set of fairly fine-tuned situations where terminations are and are not allowed, and whether they require notice or not, and what those situations are. And I would just say you'd want to use caution before changing those provisions.
Right. Thank you.
Okay. Anything else from staff?
I think that's all we have for the moment.
Okay, so Mr. Ralph, I said I'd give you an opportunity, so
Would it make, sorry, Mr. Chair, would it make sense, because I think there's a number of different items that need to be addressed by a couple of us.
oh, a couple. So not just you, but some of your folks.
It would make sense.
Okay, so actually,
because you all may have questions.
yeah, I understand. Yeah. So I guess, but just don't go too far, Mr. Spivak, just in case in case we get sort of back and forth on some of this. So.
And Chairman Hoover, I don't need an opportunity to readdress the commission unless necessary. There is one point that I'd just like to clarify in light of what the OPC has said. I can do that at the end. I'm happy to wait. Or if I could just have literally 90 seconds to clarify
All right.
that.
Well, why don't you, since you're dealing with what Mr. Lapp said, why don't you deal with that right now?
Thank you. I want to make clear that the position of many residents and the plaintiffs with respect to the moratorium is relatively open. We are certainly open to the moratorium, but, and I think this is important, our greatest fear is that if there is not a moratorium, if that is not the direction that the commission goes, that there be clarity on a couple of specific things. Clarity about the fact that the tariff does not allow them to cut off service. I think we've made that clear.
Yeah, so.
But the last one that I want to dwell on has to do with a back and forth about whether or not there ought to be a baseline for which you apply to exemptions. There are two ways in which the commission could fashion this. The commission could fashion this as the assumption is it's going to be one way and you can apply to get an exemption from that. Or it could be that in order to do it, you have to have informed and written consent. The reason why we urge the commission to not go with an exemption application is twofold. The first is that we fear, especially in Baltimore City, that that will disproportionately affect certain communities. It is not an accident that certain communities were able to get exemptions and were able to push back when other communities tried very hard and did not. In terms of knowledge about how to apply for an exemption, there are numerous examples in Baltimore City where certain things get applied for. They're available for everyone, but only certain communities end up getting it. That is why we urge the commission, if it concludes, as we submit, that the safety question is at least an open one, that it is, two different bike helmet options, and not one is plainly superior to the other in all circumstances. We would just ask it not to be set up such that you have to apply, because candidly, everybody in Federal Hill will apply and get the exemption, and 50% of the people in West Baltimore won't even know that they can apply. And with that, I just want to clarify our position.
Okay, understood. So, okay, Mr. Ralph, go ahead.
Thank you, Mr. Chair. Again, David Ralph on behalf of BGE. There were a number of comments, and I appreciate the opportunity to get to respond to those comments. First, I want to respond to the comments by customers regarding their interactions with contractors. I can't, as I sit here today, I have to take those comments at face value and you know, we are concerned as well about those comments, and we will continue to investigate and look into those. And I want to ensure the commission that we do take those comments seriously. There was also a comment regarding liability. I think it came up a couple of times, that somehow BG is doing this to fend off liability in terms of external or internal regulators. Nothing can be further from the truth. And in fact, the law does not support that. The liability issue is very simple. If a vehicle damages is the cause of anything, it is the vehicle that is the one that's responsible for the damage, whether that's indoor equipment or outdoor equipment. The liability doesn't change. If BGE's equipment, whether indoors or outdoor, is the cause of whatever the problem is, that liability, that obligation is with BGE. That doesn't change. So this notion that somehow the placement of a regulator has any bearing on liability is simply unfounded. Then there was something that amplified the concern that I raised in our presentation, which is the opinions of laypersons regarding pipeline operational safety issues and engineering. It's concerning because it does, as I said, have the potential to mislead the public as to important safety issues. So I would like you to hear from a couple of us today regarding the issue of the safety issues that were raised. First, actually, let me go to our consultant here, who's a former PHMSA official who actually wrote the DIMP statute.
Well, actually, before you start down that road, you know, we're not a jury in a court. So part of the reason why we're here is because we have a certain level of expertise, experience, and things like that. So the comments that were made regarding, you know, what you just mentioned about the safety and the motivations behind why the company's doing this, I'm not sure really has that much impact on what we're eventually going to decide as far as what this process is going forward. Now, you know, I understand your concern about, you know, this obviously went out over YouTube and went to the public and things like that. And so you may want to try and correct the public record. But I would just caution you, let's not go way down this path in trying to convince us about, you know, what the motivations are behind what the company's doing and why the company's doing it. And maybe just concisely discuss the aspects that you want to regarding safety and what you're doing to the system.
Fair enough.
Okay.
My name is Mike Israni, Israni. I retired from PHMSA in 2016 after 22 years with PHMSA. So since 94 through 2016, most major regulations at PHMSA, I was the author. I was a senior technical advisor on all the technical issues at PHMSA. And DIMP and transmission TIMP, we call, or for hazardous liquid, all these integrity programs, and I wrote those. And I had the team that I led for those. I was just disturbed by some of the remarks that were made this morning about the safety of the outside regulators. I just want to clarify that, because you saw all those fancy charts and everything, all the data that PHMSA collects. I had a key role in that, what data we collect at PHMSA while I was there. First of all, impression was given that outside regulators have so many incidents and everything. I want to clarify that 80 to 90%
of the regulators are outside in the country. So obviously you're going to see more incidents outside. We just don't go by the raw numbers. And another thing that BGE staff pointed out, Gas Technology Institute, I want to mention that, I want to emphasize on that because this institute has all the people with the gas pipeline experience. They're all PhDs, they're all scientists. Their whole life they spend analyzing, studying all those. Their study was sponsored by PHMSA because PHMSA does not outright follow what NTSB recommendations come and make it a mandate. They have to do all the kind of studies before they can make it into a regulation. So GTIS study that came out, as it was pointed out, they refer to DEMP program. And they also indicated their preference for the outdoor regulators, and for good reason. And we all engineers recognize that. And people who study at NTSB, they recognize that. So when we hear statements about outside regulators are as risky as inside regulators, science does not say that. The main thing is that when gas is confined in a space inside, that causes explosion, not outdoor ones. So by putting the vehicles hitting, that percentage of vehicles hitting of all the incidents that happen is very small. You know, in all the incidents that we see, we're talking about anywhere from 10 to maybe 18% incidents over 20 years that has happened. So majority of the cases is not the issue, you know, and also in all those incidents, what you saw all on charts and everything, casualties have been just one, and mainly drivers. Whereas whenever the explosion was from indoors, it's multiple casualties, because that's the concern what engineers are, people with safety in this field. Second thing I just want to briefly touch is way back in 2012, PHMSA had put out another advisory bulletin regarding upgrade of the systems, which is the replacement of all the cast iron and bare steel pipelines. Now, this was many years of our own experience at PHMSA, going back even to 1986 onwards, when number of incidents started happening on these cast iron and bare steel mains. So we put out that advisory bulletin based on NTSB recommendations, which was way back in 90s, in 92 or 3, when NTSB put that recommendation that we need to upgrade, get rid of all the cast iron, and upgrade all the pipeline with the polyethylene plastic or some other material. And so PHMSA put advisory bulletin on this. So these are two issues that I wanted to bring up, you know, in this. And one lastly, just want to make a general statement. When companies do increase their pressures in the line, and this is my experience from what other utilities have been doing all over the country, they have done some hydraulic studies. The engineers have done the studies forecasting how much gas is being used, and accordingly they keep adding more and more services. To reach those services, they had to increase pressure in the lines. And when they increase the pressure in the lines, they have to put new regulators. So this is a point I want to bring to the attention.
Okay.
Thank you.
Yes, if I could just clarify a few things for the record.
Sure.
There were intimations made that there were selections of projects based on the prosperity or lack thereof of a neighborhood. I want to go on record. I find that personally offensive, as I was the one responsible for making many of those decisions. It is on the record through our STRIDE cases. You can see where we've been doing work. Especially the early years of STRIDE was predominantly in places like McElderry Park in East Baltimore and Harlan Park in West Baltimore. So I'd like to add that for the sake of the record. Specifically, there was assertions about the timing of Bolton Hill. That project was completed in the summer of 2021, 6 months prior to BGE's policy going into full effect. It was also, by the way, the time at which the legislature was enacting the Flower Branch Act, so it was a time of a lot of discussion on this, and some of that did matriculate into the Bolton Hill neighborhood, as Mr. Gorman and I can attest. and Mr. Spivak as well. No, sorry, not Mr. Spivak, Mr. Holcomb. I apologize. On the point of high pressure versus low pressure, a consideration in addition to Commissioner O'Donnell's, I believe, correct points, should the commission, and we don't recommend this, but should the commission determine that we should replace the low pressure system as is, that would be substantially more expensive than our current plan. The reason being, at higher pressures, the same size pipe can flow more gas. So therefore, at lower pressures, you need a bigger pipe to flow the same amount of gas. The bigger the pipe, the more labor and work it is to put in the ground. On another sort of conceptual question about overpressurization events on regulated versus non-regulated systems, we thankfully have not had a serious low-pressure overpressurization event on our system. We did actually last year, due to debris in the pipelines, have an overpressurization event on a high-pressure system. The result of this was zero negative consequence. The system performed as designed. The service regulators prevented the pressure from getting into the customer's home. It was not a positive outcome. It's not something that we strive for. But these engineering decisions enable those additional safety measures. And this was a serious event that was avoided by those circumstances. And finally, and I think this was Mr. Spivak making this point, that should we be unable to, and we like to use the word interrupt service because of a lack of cooperation from customers, it would require us to keep all of the assets in service under the statutes of Maryland, which say we have to provide service to all of our existing customers until that customer cooperated, which means we can't go back and repave the streets. We can't finish the project for all of those other customers. I will state that in my experience, the vast majority of times where we've had to assert this authority was simply because we could not get a hold of the customer. They wouldn't answer the door. They wouldn't return our phone calls. I suspect often they think we're trying to collect money from them when we're just trying to complete our project. And in all these cases, when those customers call us back, we will restore service in a timely manner. Those are my statements for the record. Thank you.
Good evening, Charles Washington again with BGE. You've heard several times today that BGE changed its position on the Flower Branch Act. That's just simply not true. BGE supported the bill with amendments, a number of amendments. The words that were read to you were my words. I wrote them, I said them. I've never seen them in such big writing as I did today. But what's important to understand is that when the bill was introduced, it was completely prescriptive. It did not give us the opportunity to issue waivers, the discretion to issue waivers, even when it was completely physically impossible to install a regulator outside. And so if you look at the full context of that testimony, what we were telling the committee was that we supported the plan to move regulators outside, but that you had to give us the opportunity to address what could be really difficult challenges in parts of Baltimore City. And so all of those words were about giving us discretion and giving you discretion, because it was both. It was that the commission and the utility would have the opportunity to issue waivers under a long list of circumstances that might make it infeasible or impractical to put a service regulator outside.
Okay. Well, actually, Mr. Washington, I had the pleasure of being in the room when these discussions were taking place, so I remember your original position and the amendments you offered and how the bill was which was part of the genesis of some of my questions about, the dealing with the multifamily dwellings and where that was fitting in the STRIDE program. So, but I think that it's a transition to maybe a discussion about the path forward. So,
Mr. Chairman, if you can, is somebody going to answer my question about the right-of-way, or are you going to submit that? I mean, you could do it today, or you could just submit it for the record. That would be fine.
Yeah. If somebody knows, go ahead.
Yeah.
So, go ahead.
Hi, Sean Gorman. So specifically about the question of the right-of-way, as we were developing the change in the standard, we did reach out to our right-of-way team, and the information that we received from them was that in the city of Baltimore, according to our franchise, the road right-of-way extends from the face of one building across the street to the face of the other building, and that we have the permission to install utility equipment in that right-of-way.
Okay, so that goes, sorry. So that goes from where the facade of one building ends to so that includes the sidewalk.
So that includes the
the
sidewalk,
street,
correct.
and the sidewalk.
Okay.
Okay, thank you.
Okay, all right.
And if I could just make a couple other points from some comments we heard earlier today. So there was some comments about tampering with the regulators and the ability to increase the pressure on those. Specifically the B42R regulator, which is by far the most common, the common one used. And the configuration that we use with those, there are different springs inside of them, and you can put more or less tension on that spring. If you were to increase that to the maximum force possible with the springs that we have in there, the maximum outlet pressure that you would be able to achieve is around 10 inches on the water column, which is within the operating parameters of the equipment that typical customers have inside their homes. It's the upper range of our current low pressure system. So even with that increased as far as it can go, it is still within the operating parameters of the low pressure system that is utilized today. I'd also like to say that, as we can see in some of the pictures that we have shown earlier today, the decision of one customer has impacts on the neighbors surrounding them, and then on the public right of way in that area. To allow one customer to sign a waiver or make a decision is impacting more than just that customer themselves. It is impacting all of those around them and the safety of them and their families. It also potentially impacts anyone who may move into that house at a later date. If someone were to sign this waiver and then potentially move to another house within 3, 5, 10, 12 years, the person who comes into that house will inherit that situation without necessarily being aware of what they just inherited. So a decision by one customer is not a decision that is made solely for them. To go to the bike analogy, when you decide to wear a helmet or not, you are only impacting your own personal safety. When you decide to have an indoor regulator, you are impacting the safety of yourself and all of those around you. And then also, when installing a regulator indoors versus outdoors, there is always going to be a need to drill a hole through the wall. Actually, when the regulator is installed indoors, there is quite possibly the need to drill 2 walls in the holes. One for the gas to enter and then another for the vent to exit. For an outdoor regulator, there would only be a need for one hole to be drilled into the wall, simply for the low pressure gas to enter the house.
Okay. So, going forward, the first request that we would make is between now and the time that we issue any directions, orders, whatever we're going to come out with, I would ask the company to basically stop all the activity you're doing in line with the TRO. I heard the discussion earlier about what the TRO allows and doesn't allow, but what I'm talking about is just in this time period that I'm considering to be a couple of weeks, because I think one of our dates for action is the next circuit court date. I would like the company to basically just hold off on doing anything in this area for that time period. Secondly, there's been a lot of discussion today about possible options to this. Whether there should be, Commissioner O'Donnell had talked about a waiver thing that basically had no waivers possible for anybody, and a waiver situation that allowed everybody to get a waiver for any reason, and something in between. And so, and the company in their filing offered some ideas about mediation type and mitigation type things. So what I would encourage the company to do is to get together with staff, OPC, and the representative of the customers to see and explore if there is some middle path, some compromise to deal with this issue apart from us making the decision. Now, while you're doing that, we are going to be going through our process and trying to come up with a solution to this. So if you don't come up with an idea and you can't come to some compromise on this, then we will make some decision as to what the policy will be going forward. But I at least want to give the parties an opportunity to maybe come together and craft something. Now, obviously, I realize that, the company is going to have to make some significant adjustments in their policies going forward. The representative of the customers may have to make some considerations about their positions, but that's kind of the way the process works. So I would ask you to take that opportunity. If you find out that basically there is no middle path or room for compromise, just notify us, and as I said, we will proceed ahead with making a decision and crafting a policy going forward. So any questions on that?
Yes.
Okay, and Mr. Ralph, just to, so that where everybody is clear,
Yes.
I think what the chair is asking is that you stop moving regulators or installing regulators where there wasn't a regulator before.
Right.
So, okay, so that, I think that does answer my question. You're not saying that we need to stop main replacement?
No, I'm not talking about that. I'm just talking about the reason why we've been here since 10 o'clock this morning.
Just,
Sure it wasn't yesterday morning?
I'm not sure either. Let me just ask one clarifying case. So we have actually had customers reach out to us and ask us to install their regulators externally. Are we to tell those customers no?
I mean, you brought this up. What's your thought? Sure, go ahead.
I guess the situation is that the customer
Calls-
has initiated.
That's correct.
It seems reasonable.
Okay, all right.
That seems
I guess
There's
the
not
only,
as long as there's not a solicitation that they're responding.
Understood.
Right?
or as long as the customer is not doing it because they think you're going to move
Disconnect
the meter at the regulator at some later date.
Yeah.
So that they're not initiating because they want to get a jump on what they think is inevitable. You understand what I'm saying?
So I guess what I'm saying is, if it's informed consent and agreement by the customer, then go ahead. But in all these other situations where the customer either doesn't want you to do it, not sure they want you to do it, we would like you to just hold off.
That's fine, and we understand.
Mr. Chairman, I would add a heavy dose of educational perspective on this point, which is this is subject to change when we issue our guidance order. So the customer needs to be aware of that. That yes, we're stopping you for now. However, when we issue our broader or narrower, whatever it is, our guidance on this matter, that may change.
Sure.
Understood. Understood. That's understood.
Okay. So, Mr. Vignaraja.
I've decided we've talked long enough.
Oh, okay, fair enough. Mr. Lapp, anything?
I was just hoping to get a little clarification because I'm not sure. I haven't seen one of the consent forms in a while, but I'm not sure that they really how explicit they make it that customers are able to say no, I want to hold off, or if there was like I don't know what the company's doing as far as like robocalls out to customers or that sort of thing. We're not trying to get some clarification.
Okay, so Mr.
We're not doing anything like that. No robocalls. We're not calling customers, telling them.
All right.
I will tell you that there are customers who actually want to put their
I understand,
regulators
yeah, right.
outside.
And so what we're talking about are customers that contact the company
That's right.
first, not the other way around. So,
Okay, thank you.
okay. All right, thank you very much, and we're adjourned.